Hello everyone, welcome to 𝐗𝐿𝐴. In this video, we will discuss the top 1000 MCQs of Indian Penal Code. So let's get started from the question number 1. Which one of the following is the date of enforcement of the Indian Penal Code 1860? Correct answer is option D, that is January 1st, 1862. Section 1 of the Indian Penal Code deals with option A, definition of crime, option 2, title, extent of operation of the code, C, title and jurisdiction of the code, and D, none of the above. Correct answer is option B, that is title and extent of operation of the code. Question 3. Who prepared the first draft of the Indian Penal Code? Here the correct answer is option D, that is Macaulay. Question number 4. The draft of IPC was prepared by, correct answer is First Law Commission. And First Law Commission was headed by Macaulay. The preamble of the IPC 1860 aims to provide a option first, comprehensive penal code, B, general penal code, C, exclusive penal code, D, none of these. Correct answer is General Penal Code. Question 6. To which of the following is IPC not applicable? Options are State of Jammu and Kashmir, a foreigner committing offence in foreign country, and option C, committing offence committed on Indian aircraft flying over territory of Japan. Option D, a foreigner committing offence in territorial water of India. Here the correct answer is option B, that is a foreigner committing offence in foreign country. Foreigner and foreign country, here IPC will not be applicable. Whether Indian Penal Code 1860 implies to an offence committed by a citizen of India outside India. Options are A, yes, B, no, option C, if the offence is associated and has nexus with another offence committed in India, option D, if there is a mutual treaty between India and the country in which the offence was committed. Correct answer is option A, that is yes. Question number 8. A, who is a citizen of India commits murder in Uganda. He is arrested in Delhi. He can be tried and convicted of murder only in Uganda, only in that country of which the deceased was a citizen, in any of the above in Delhi. Correct answer is in Delhi. Question number 9. A, who is a citizen of India commits a murder in England. He is found in Indore and arrested accordingly. Where can A be tried? Option A, at New Delhi, the capital of India, at Bhopal, the capital of MP, at Indore where he was found, and option D, at any place in India. Correct answer is option C, that is at Indore where he was found. Question number 10. A Spanish citizen who was residing in Paris instigated the commission of an offence which in consequence was committed in India. Option A is liable as the offence was committed in India. Option B is liable since the IPC also extends to extraterritorial acts. Option C can be held liable because the offence was to be committed in India, and option D cannot be held liable because instigation was not given on Indian territory. Here the correct answer is option A, that is liable as the offence was committed in India. Question number 11. Read the following. Indian courts have jurisdiction to try crime committed by an Indian in a foreign country. Statement 2. Indian courts do not have jurisdiction to try crime committed by a foreigner in India. Of the above, options are first is true and second is false. First is false but second is true. Option C, both 1 and 2 are true. And option D, both first and second are false. Here the correct answer is first is true and second is false. Question number 12. In which of the following situations would the Indian courts have jurisdiction? Statement first. Crime committed by an Indian in a foreign country, crime committed by a foreigner in India, crime committed by a person on an Indian ship. Courts first and second, first and third, second only, 1, 2 and 3. Here the correct answer is 1, 2 and 3. Question number 13. The Criminal Law Amendment Act 2018 came into force from, correct answer is option B, that is 22nd April 2018. Question number 14. The essential ingredients of a crime are, options are actus reus and mens rea, option B, actus reus, mens rea and motive, option C, motive, intention and knowledge, option D, knowledge, intention, action. Here the correct answer is option A, that is actus reus and mens rea. They are the essential ingredients of crime. Question number 15. Which of the following is not essential for an offence? Options are intention, motive, prohibited act, D, punishment for act. Correct answer is option B, that is motive. Motive is not essential for an offence. Question number 16. Which of the following is normally an essential elements of crime? Options: violation, actus reus, motive, will. Correct answer is actus reus. Question number 17. Actus reus is that result of human conduct which the law seeks to prohibit. This definition was given by Correct answer is Kenny. This definition was given by Kenny. Question number 18. Crime which do not require intention, recklessness or even negligence as to one or more elements in the actus reus are known as option A, vicarious liability, option B, strict liability, C, act of God, and D, force majeure. Correct answer is option B, that is strict liability. Question number 19. The maxim actus non facit reum nisi mensitria means common intention, group liability, guilty state of mind in crime, and wrongful motive. Here the correct answer is option C, that is guilty state of mind in crime. Question number 20. Crime is a option A, private wrong, public wrong, civil wrong, none of the above. Correct answer is public wrong. Crime is a public wrong. Question number 21. With reference to crime, response the following. It is a state wrong, it is a civil wrong, it is a private wrong, none of the above. Correct answer is option A, that is it is a state wrong. Question number 22. If actus non facit reum nisi mensitria is a cardinal principle of criminal law, then which one of the following statements correctly reflects the above principle? Options are: mens rea is an essential element of crime and there cannot be crime without mens rea. Option B, criminal liability under Indian law always implies mens rea. Option C, to constitute a crime there must be actus reus and mens rea. Option D, actus reus is not always necessary to constitute a crime. Here the correct answer is option C, that is to constitute a crime there must be actus reus and mens rea. Question number 23. Which of the following maxim is related to mens rea? Correct answer is option B, that is actus non facit reum nisi mensitria. Question number 24. The principle of criminal liability actus non facit reum nisi mensitria was developed and adopted by option A, the equity courts, B, the Indian courts, C, the common law courts, D, none of these. Correct answer is C, that is common law courts. Question number 25. The actus non facit reum nisi mensitria implies that options are A, mere act or illegal omission on the part of the accused makes him liable under criminal law. Option B, mere guilty mind coupled with motive behind a crime makes the accused liable under the criminal law. Option C, guilty mind of the accused coupled with desire to give effect to the guilty mind is sufficient to make the accused liable under the criminal law. And option D, no act per se is criminal unless accompanied by guilty mind. Here the correct answer is option D, that is no act per se is criminal unless accompanied by guilty mind. Question number 26. It is the maxim older than the law of England that no man is guilty unless his mind is guilty. It was observed by Lord Arbinger in. Here the correct answer is R versus All Day. Question number 27. Mens rea is option A, guilty mind, proved fact, intention of the lawmaker, measuring mind. Correct answer is guilty mind. Question number 28. Actus me invito factus non est mens actus means the act itself does not make a man guilty unless his intentions were so. Option B, an act done by me against my will is not my act at all. And option C, the intent and the act both must concur to constitute crime. And option D, none of the above. Here the correct answer is option B, that is an act done by me against my will is not my act at all. Question number 29. In every statute, mens rea is to be implied unless contrary is shown. This view was expressed in options are Shiraz versus D. Rudson, R versus Dudley and Stephen, Harding versus Prince, and R versus Prince. Correct answer is Shiraz versus D. Rudson. Question number 30. For which of the following offence mens rea is not a requisite? Options are kidnapping, robbery, trespass, none of the above. Correct answer is option A, that is kidnapping. For kidnapping, mens rea is not a requisite. Question number 31. In which of the following offence guilty intention is not an essential element? Options are murder, theft, robbery, bigamy. Correct answer is bigamy. For bigamy, guilty intention is not an essential element. Question number 32. In which of the following cases the doctrine of mens rea is not applicable? Options are theft, murder, public nuisance, thug. Here the correct answer is option C, that is public nuisance. Which one of the following offence is not related to mens rea? Options are R versus Prince, Queen versus Tolson, Shiraz versus D. Rudson, and Birendra Kumar Ghosh versus Emperor. Here the correct answer is option D, that is Birendra Kumar Ghosh versus Emperor. This is not related to mens rea. Which of the following does not form a part of actus reus? Options are thought of conduct, result of conduct, circumstances as are specified by law, D. Conduct. Correct answer is option A, that is thought of conduct. Question number 35. Which of the following principle is least relevant for the criminal liability? Options are causation, contemporaneity, novus actus inventions, motive. Correct answer is option D, that is motive. Question number 36. The cardinal principle criminal law, nullum criminum nulla poena sine lege means option A, no crime or punishment can exist without a pre-existing penal law. A man is presumed to be innocent until proven guilty. Ignorance of law is no excuse. Option D, an act must be accompanied by a criminal intent to constitute an offense. Correct answer is option A, that is no crime or punishment can exist without a pre-existing penal law. Question number 37. According to dash, a crime is a violation of a public rights and duties due to the whole community. Options are A, Sir William Blackstone, B, Professor Glanvin Williams, C, Sir Kenny, D, Sir Russell. Here the correct answer is option A, that is Sir William Blackstone. Question number 38. An act committed or omitted in violation of a public law forbidding or commanding it is crime. It has been said by option A, Stephen, option B, William Blackstone, option C, Henry Mine, and option D, Canning. Here the correct answer is option B, that is William Blackstone. Question number 39. An act forbidden by law and which is at the same time revolting to the moral sentiments of the society is called crime. It is said by option A, Keaton, option B, Austin, option C, Stephen, and option D, Patton. Here the correct answer is option C, that is Stephen. Question number 40. In order that an act should be punishable, it must be morally blameworthy. It must be sin. Which of the following made this observation? Options are Salmon, option B, Justice Krishna Iyer, option C, Lord Denning, and option D, Stephen. Here the correct answer is option C, that is Lord Denning. Question number 41. Quae facit per alium per se is the essence of one of the following principles of criminal liability. Options are joint criminal liability, vicarious liability, corporate criminal liability, strict liability. Here the correct answer is option B, that is vicarious liability. Question number 42. In some cases, a crime is constituted even though the act is not done with the guilty intention. These are the cases of, correct answer is strict liability. These are the cases of strict liability. Question number 43. Successful prosecution under criminal law means acquittal of the accused, discharge of the accused, conviction of the accused, punishment of the accused. Here the correct answer is option C, that is conviction of the accused. Question number 44. Which of the following is the correct sequence of stage in crime? Options are A, intention, attempt, accomplishment, preparation. Option B, intention, preparation, attempt, accomplishment. Option C, preparation, intention, attempt, accomplishment. Option D, preparation, motive, attempt, and accomplishment. In question number 44, the correct answer is option B, that is intention, preparation, attempt, accomplishment. This is the correct sequence of the stage in a crime. Question number 45. Preparation of which of the following offences is punishable? 1, waging war against India. 2nd, sedition. 3rd, murder. 4th, dacoity. Options are 1, 2 and 4, 1, 2 and 3, 1 and 2, 1 and 4. In question number 45, correct answer is option D, that is 1st and 4, which means waging war against India and dacoity. Here the preparation is punishable. Question number 46. Man is defined in option number D, section 10 of IPC. Question number 47. Under section 10 of IPC, man denotes a male human being of, correct answer is any age. Question number 48. In IPC, the word woman denotes to option A, the female above the age of 15 years. Option B, a female above the age of 18 years. Option C, a female above the age of 21 years. And option D, a female of any age including newly born female child. In question number 48, correct answer is option D, that is a female of any age including newly born female child. Question number 49. The word person under section 11 of IPC denotes to only male human being, includes a company or association of or body of persons whether incorporated or not. Option C, only female human being, and option D, only government companies. Here the correct answer in question number 49 is option B, that is includes company or association or of a body of persons whether incorporated or not. Question number 50. Homicide cannot be defined as killing of person. In view of the nature of the definition, the word person in option A, section 13 of the IPC, option B, section 11 of the IPC, option C, section 9 of the IPC, and option D, section 7 of the IPC. Here the correct answer is option B, that is section 11 of IPC. Question number 51. Which of the following person is not a judge as defined in section 19 of the IPC? Option A, a magistrate exercising jurisdiction in respect of a charge on which he has the power only to commit for trial to another court. Option B, a collector exercising jurisdiction in a suit under Act 10 of 1859. Option C, a magistrate exercising jurisdiction in respect of a charge on which he has power to sentence to fine or imprisonment with or without appeal. Option D, none of these. Here the correct answer is option A, that is a magistrate exercising jurisdiction in respect of a charge on which he has power only to commit for to trial to another court, will not be a judge, defined in section 19 of IPC. Other options will be comes into the category of judge. Question number 52. Court of Justice is defined in IPC under. Correct answer is section 20. In IPC, in which section of IPC public servant is defined? Correct answer is section 21. Question number 54. The word public servant denotes a person falling under option A, a commissioned officer in the military, every judge empowered by law to do any adjudicatory functions, every officer in the court of justice, all of the above. Here the correct answer is all of the above. Question number 55. Who among the following is not a public servant? Options are Chief Minister of a state, option B, Chairman of the Central Board of Film Censors, option C, Surveyor of an insurance company, and option D, Employee of Nationalized Bank. Here the correct answer is option C, Surveyor of an insurance company is not a public servant. Question number 56. One of the following is not a public servant. Options are liquidator, civil judge, member of the panchayat assisting a court of justice, secretary of cooperative society. Here correct answer is secretary of cooperative society. He is not a public servant. Question number 57. Which of the following is not a public servant as according to section 21 of IPC? Options A, Chief Minister and Prime Minister, Judge and Magistrate, Government Servant appointed on deputation, Principal of Government College. Here the correct answer is option D, that is Principal of Government College. Question number 58. It was held that a Chief Minister or a Minister is in the pay of the government and therefore public servant within the meaning of section 21 clause 12 of IPC. In the case of, correct answer is option A, that is Karunanidhi versus Union of India. Question number 59. Movable property under IPC is defined in. Correct answer is section 22. In section 22, movable property is defined. Question number 60. The definition of movable property under section 22 of IPC excludes. Options are land, things attached to the earth, things permanently fastened to anything which is attached to earth, and option D, all of the above. Correct answer is option D, all of the above. Question number 61. Wrongful gain and wrongful loss have been defined under IPC in. Options are section 22, section 23, section 24, section 27. Correct answer is section 23. Question number 62. Wrongful gain means gain by lawful means of property which the person is gaining is not entitled. Option B, gain by unlawful means of property which the person gaining is not entitled. Option C, gain by unlawful means of property which the person gaining is entitled, and option D, all of the above. Here the correct answer is option B, that is gain by unlawful means of property which the person gaining is not entitled. Question number 63. When a person gains something by unlawful means to which he is not legally entitled, it is. Correct answer is wrongful gain. Question number 64. Whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing. Option A, fraudulently, dishonestly, wrongfully, mischievously. Correct answer is dishonestly. Question number 65. Dishonestly has been defined as doing anything with the intention to cause wrongful gain to one person and wrongful loss to another under section 21 of IPC, section 23 of IPC, section 24 of IPC, or option D, section 25 of IPC. Here the correct answer is option C, that is section 24 of IPC. Word dishonestly as defined in section 24 of IPC means option A, with the intention of causing wrongful gain to one person, option B, with the intention of causing wrongful loss to another person, option C, with the intention of causing wrongful gain to one person and with the intention of causing wrongful loss to another person, or option D, all of the above are true. Here correct answer is option D, that is all of the above are true. Question number 67. Counterfeit under IPC is defined in. Correct answer is option B, section 28. Question number 68. Which of the following pairs is correctly matched? A, counterfeit, section 28, valuable security, section 29, document, section 30, omission, section 31. Here the correct match is option A, that is counterfeit, section 28. Question number 69. Electronic record under IPC is defined in. Correct answer is section 29A. Question number 70. Valuable security is defined in Criminal Procedure Code, Civil Procedure Code, Evidence Act, IPC. Correct answer is IPC. Question number 71. The word valuable security is defined in IPC under? Correct answer is section 30. Question number 72. Which of the following section of IPC defines the word act? Option A, section 32, option B, section 33, C, section 23, and D, section 24. Here the correct answer is option B, that is section 33. Question number 73. Which one of the following sections of the IPC the principal joint criminal liability is applicable? Option A, section 36, option B, section 39, option C, section 34, and option D, section 40. Here the correct answer is option C, that is section 34. Question number 74. Which one of the following section of Indian Penal Code defines voluntarily? Options are section 39, section 38, section 37, section 36. Correct answer is section 39. Section 39 of IPC defines the term voluntarily. Question number 75. Offence is defined under? Options are section 41, section 40, section 42, section 39. Correct answer is section 40 of IPC. Question number 76. Illegal signifies? Option A, everything which is an offence, everything which is prohibited by law, everything which furnishes ground for civil action, all of the above. Correct answer is option D, that is all of the above. Question number 77. To which of the following the word illegal used under section 43 of IPC is not applicable? Option, which is an offence, which is prohibited by law, which furnishes a ground for civil action, which is immoral. Correct answer is option D, that is which is immoral. Question number 78. Section 44 of IPC, the term injury means any harm. Option A, illegally caused to a person in body and mind. Option B, illegally caused to a person in body and property. Option C, illegally caused to a person in body, mind, reputation or property. Option D, illegally caused to a person in body, mind and reputation. Here the correct answer is option C, that is illegally caused to a person in body, mind, reputation or property. Question number 79. The word good faith is defined in IPC in? Correct answer is section 52. Question number 80. Good faith within the meaning of IPC means an act done with due care and attention, an actual belief that the act is not contrary to law, an act in fact done honestly, an act done under bona fide belief. Here the correct answer is option A, that is an act done with due care and attention. Question number 81. The term harbour defined under IPC does not include? A, supplying person with shelter, B, supplying person means of conveyance, C, assisting a person to evade apprehension, D, prior to the commission of the offence, facilitating the commission thereof. Here the correct answer is option D, that is prior to the commission of the offence, facilitating the commission thereof does not come under the harbour definition. Question number 82. Section 34 of IPC creates a substantive offence is a rule of evidence, both A and B, none of the above. Correct answer is option B, that is a rule of evidence. Question number 83. The phrase in furtherance of common intention of all used in section 34 of IPC is? A, in the original draft, B, added by amending act of 1870, C, not at all there, D, added by amending act of 1986. Here the correct answer is option B, that is added by the amending act of 1870. Question number 84. Section 34 of IPC. Option A, physical presence is necessary. Option B, physical presence for participation but not in all cases. C, physical presence is not necessary. D, physical presence is necessary with common knowledge. Here the correct answer is option B, that is physical presence for participation but not in all cases. Question number 85. Common intention means? Option A, similar intention, B, same intention, C, sharing of intention by all persons, D, common plans. Here the correct answer is option C, that is sharing of intention by all persons. Question number 86. When a criminal act is done by several persons in furtherance of common intention of all, each one of them is liable. A, as if it was done by each one of them in singular capacity. B, only for the part each one has done for an abetment to commit the act, for an attempt to commit the act. Here the correct answer is option A, that is as if it was done by each one of them in singular capacity. Question number 87. The principle of common intention applies only when? Option A, at least 5 persons are involved. Option B, at least 2 persons are involved. Option C, at least 1 person is involved. And option D, none of the above. Correct answer is option B, that is at least 2 persons are involved. Question number 88. To establish section 34 of IPC, option A, common intention is to be proved but not overt act to be proved. Option B, common intention and overt act both have to be proved. Option C, common intention need not to be proved but overt act to be proved. And option D, all of the above. Here the correct answer is option B, that is common intention and overt act both have to be proved. Question number 89. Which of the following cases is a case relating to section 34 of IPC? Options are K.M. Nanavati versus State of Maharashtra, Nehrendu Dutt versus King Emperor, Birendra Kumar Ghosh versus King Emperor, and Dedar Nath versus State of West Bengal. Here the correct answer is option C, that is Birendra Kumar Ghosh versus King Emperor is a case relating to section 34 of IPC. Question number 90. Which of the following is not the ingredients of section 34 of IPC? Option A, criminal act done by several persons. Option B, in furtherance of common intention. Option C, meeting of the minds of those who involved in crime. Option D, similar intention of those who involved in the crime. Correct answer is option D, that is similar intention of those who involved in the crime. Question number 91. Which one of the following is not an essential element of section 34 of IPC? Options are criminal act done by several persons, criminal act done in furtherance of common intention. Option C, pre-arranged plans between persons doing criminal act. Option D, act done in furtherance of common object. Correct answer is option D, that is an act done in furtherance of common object is not an essential element of section 34 of IPC. Question number 92. In which one of the following cases Lord Summer said, they also serve who stand and wait? Options are Mehboob Shah versus Emperor, Inder Singh versus Emperor, Birendra Kumar Ghosh versus Emperor, and D, none of the above. Correct answer is option C, that is Birendra Kumar Ghosh versus King Emperor. Here Lord Summer said, they also serve who stand and wait. Question number 93. Which one of the following is not an essential condition for the application of section 34 of IPC? Options are A, criminal act done by several persons. B, criminal act must be done in furtherance of common intention. C, participation by all persons in some manner in act constituting the offence. D, criminal act done in prosecution of the common object. Here the correct answer is option D, that is criminal act done in prosecution of the common object. This is not an essential condition for the application of section 34 of IPC. Question number 94. To impose joint liability under section 34 of IPC, the prosecution needs to prove A, intention, B, same intention, C, similar intention, D, common intention. Here the correct answer is common intention. To impose joint liability under section 34, common intention is need to be proved by the prosecution. Question number 95. Which one of the following brings out the distinction between section 34 and 149 of IPC? Option A, section 149 creates a specific offence whereas section 34 does not. Option B, section 34 creates a specific offence whereas section 49 does not. Section 34 as well as section 149 creates specific offence. Option D, section 34 as well as section 49 do not create specific offences. Correct answer is option A, that is section 149 creates a specific offence whereas section 34 does not. Question number 96. Mehboob Shah versus King Emperor is a leading case on A, conspiracy, B, common intention, C, wrongful confinement, D, common object. Correct answer is option B, that is common intention. Question number 97. In which of the following cases the Privy Council made a distinction between common intention and similar intention? Options are Birendra Kumar Ghosh versus Emperor, Mehboob Shah versus King Emperor, Srinivasmal Barolia versus Emperor, Bannuwal versus Emperor. Here the correct answer is option B, that is Mehboob Shah versus King Emperor. In Mehboob Shah versus King Emperor, Privy Council made a distinction between common intention and similar intention. Question number 98. The difference between section 34 and section 149 of IPC is option A, that in section 34 there must be at least 5 persons whereas section 149 2 persons are required. Option B, that section 149 is only a rule of evidence whereas section 34 creates a specific offence, provides for its punishment. Option C, that section 34 requires active participation in action whereas section 149 requires mere passive membership of the unlawful assembly. Option D, that section 34 need not to be joined with the principal offence whereas section 149 must be combined with the principal offence. Here the correct answer is option C, that is section 34 requires active participation in action whereas section 149 requires mere passive membership of the unlawful assembly. Question number 99. Which one of the following recognizes the principle of vicarious criminal liability under IPC? Options are section 34, section 149, both A and B, none of the above. Correct answer is option C, that is both A and B, that is section 34 and section 149 both recognizes the vicarious criminal liability under IPC. Question number 100. Which of the following cases is not related to principle of joint liability based on common intention? Options are Birendra Kumar Ghosh versus Emperor, Mehboob Shah versus Emperor, I.M. Desai versus State of 𝐷 versus Govinda. Here the correct answer is option D, that is 𝐷 versus Govinda. This case is not related to the principle of joint liability based on common intention. Other 3 cases are related to common intention. Question number 101. Which of the following is false of section 34 and section 149 of IPC? Option A. Section 34 does not by itself create any specific offence, whereas section 149 does so. Some active participation in crime is required in section 34 while it is not needed in section 149. Section 34 speaks of common intention while section 149 contemplates common object. D. Section 34 requires at least 5 persons who must share the common intention while section 149 requires at least 2 persons to share the common intention. In this question, it has been asked which of the following is false of section 34 and 149. So the statement D is false, therefore the correct answer. The difference between section 34 and section 149 of IPC is that option A, whereas in section 34 there must be at least 5 persons, section 149 requires only 2 persons. Section 149 is only rule of evidence, whereas section 34 creates a specific offence. Section 34 creates active participation in action, whereas section 149 requires mere passive membership of the unlawful assembly. D, both B and C. Here the correct answer is option C. Section 34 requires active participation in action, whereas section 149 requires mere passive membership of unlawful assembly. Question number 103. Distinction between section 34 and 149 of IPC has been authoritatively expounded by the Supreme Court in. Correct answer is Nanak Chand versus State of Punjab. Question number 104. The difference between section 34 and 149 of IPC is option A, that whereas in section 34 there must be at least 5 persons, section 149 requires only 2 persons. Option B, the section 149 is only a rule of evidence, whereas section 34 creates a specific offence and provides for its punishment. Option C, that section 34 requires active participation in action, wherein section 149 mere passive membership of the unlawful assembly is sufficient. Option D, that section 34 need not be joined with the principal offence, whereas section 149 must be combined with the principal offence. In question number 104, the correct answer is option C, that is that section 34 requires active participation in action, whereas section 149 is mere passive membership of the unlawful assembly is sufficient. Question number 105. X armed with loaded pistol and Y empty-handed go to Z's shop in furtherance of their common intention to commit robbery. X enters the shop and on being resisted in carrying away property shoots Z with pistol. Z dies at once. For what acts of X and Y is liable? Options are dacoity with murder. Option B, extortion and culpable homicide not amounting to murder. Option C, attempt to commit robbery with armed with deadly weapon. And option D, robbery and murder. Here the correct answer is option D, that is robbery and murder. Question number 106. X and Y go to murder Z. X stood on guard with a spear in hand but did not hit Z at all. Y killed Z. In this case, option A, only Y is liable for the murder of Z. Option B, X and Y both are liable for the murder of Z. Option C, X is not liable as he did not perform any overt act. And option D, both A and C are correct. Here the correct answer is option B, that is X and Y both are liable for the murder of Z. Question number 107. X, a jailer, has a charge of Z, a prisoner. X, intending to cause Z's death, illegally omits to supply Z with food, in consequence of which Z is much reduced in strength, but that starvation is not sufficient to cause his death. X is dismissed from his office and Y succeeds him. Y, without collusion or cooperation with X, illegally omits to supply Z with food, knowing that he is likely to thereby to cause Z's death. Z dies of hunger. What will be the position under IPC 1860? Options are X and Y are guilty of murder. Option B, X is guilty of an attempt to commit murder. And option C, Y is guilty of an attempt to commit murder. And option D, Y is guilty of an attempt to commit culpable homicide. Here the correct answer is option B, that is X is guilty of an attempt to commit murder. Question number 108. A intentionally causes death, partly by illegally omitting to give Z food and partly by beating Z. A has committed the offence of option A, culpable homicide not amounting to murder. B, attempt to commit murder. C, murder. D, grievous hurt. Here the correct answer is option C, that is murder. Question number 109. How many kinds of punishments are provided in section 53 of IPC? Correct answer is 5. Question number 110. Which of the following punishment cannot be awarded under IPC? Options are forfeiture of property, rigorous imprisonment, transportation of life, and option D, death. Correct answer is transportation for life. Question number 11. Question number 111. Death sentences should be awarded in rarest of the rare cases was held in. Correct answer is Bachchan Singh versus State of Punjab. Question number 112. By which one of the following acts the words imprisonment for life were substituted for the words transportation for life in the IPC? Correct answer is option C, that is Act 26 of 1955. Question number 113. Under which of the following sections of IPC the death sentence can be commuted without the consent of the offender? Options are section 53, section 55, section 54 or none of these. Correct answer is option B, that is section 54. Question number 114. Commutation of sentence of imprisonment for life is done under IPC in option A section 52, B section 53, C section 54, D section 55. Correct answer is option D, that is section 55. Question number 115. Who may commute sentence? Options are Chief Justice of High Court, Chief Justice of India, appropriate government, any appellate court. Correct answer is appropriate government. Question number 116. The appropriate government may commute the sentence of death of an accused person to any other sentence. Option A, with the consent of the accused. Option B, with the consent of the relatives of the accused. Option C, with the consent of the advocate of the accused. None of the above. Correct answer is option D, that is none of the above. Question number 117. In how many years a sentence of imprisonment for life can be commuted by the government? Option A, 20 years, B, 18 years, C, 14 years, D, 12 years. Correct answer is option C, that is 14 years. Question number 118. In calculating the fractions of terms of punishment, section 57 of IPC prescribes that imprisonment for life shall be reckoned as equivalent to the imprisonment for option A, 10 years, B, 14 years, C, 20 years, D, 25 years. Correct answer is 20 years. Question number 119. Where is no sum is expressed to which a fine may extend, there the amount of fine to which the offender may be liable will be option A, not exceeding the rupees 50,000, option B, not exceeding rupees 25,000, and option C, not exceeding rupees 10 lakh, and option D, unlimited but not expensive. Correct answer is option D, unlimited but not excessive. Question number 120. Question number 120. Under section 65 of IPC, sentence of imprisonment for non-payment of fine shall be limited to. Options are 1/3 of the maximum term of imprisonment fixed for the offence. Option B, 1/4 of the maximum term of imprisonment fixed for the offence. Option C, 1/2 of the maximum term of imprisonment fixed for the offence. And option D, 1/5 of the maximum term of imprisonment fixed for the offence. Correct answer is option B, that is 1/4 of the maximum term of the imprisonment fixed for the offence. Question number 121. Which section of IPC provided for imprisonment for non-payment of fine when the offence is punishable with fine only? Options are section 63, section 64, section 67, option D, none of the above. Correct answer is option C, that is section 67. Question number 122. In case of an offence punishable with fine only, imprisonment for the non-payment of fine has to be rigorous, has to be simple, can be rigorous or simple, can be partly rigorous or partly simple. Correct answer is option B, that is have to be simple. Question number 123. Under IPC, if the offence is punishable with fine only and accused has been awarded with 50 rupees fine, the period of imprisonment in default shall not exceeding 1 month, not exceeding 2 months, not exceeding 3 months, not exceeding 4 months. Correct answer is option B, that is not exceeding 2 months. Question number 124. Under IPC, which one of the following sections makes provisions for solitary confinement? Correct answer is option C, that is section 73. Question number 125. Under section 73 of IPC provides for the maximum limit of solitary confinement to be option A, 1 year, option B, 2 years, option C, 3 months, and option D, 6 months. Correct answer is option C, that is 3 months. Question number 126. If an offender is sentenced to an imprisonment for a term exceeding 1 year, the term of solitary confinement shall not exceed. Options are 1 month, 2 months, 3 months, no limit. Correct answer is option C, that is 3 months. Question number 127. The term of rigorous imprisonment shall not exceed 6 months, then the maximum period of solitary confinement shall be option A, 15 days, B, 1 month, C, 3 months, D, 6 months. Correct answer is option B, that is 1 month. Question number 128. Enhanced punishment for previous conviction under dash of the IPC. Section 76, section 77, section 68, section 75. Correct answer is option D, that is section 75. Enhanced punishment for the previous conviction under section 75 of the IPC. Question number 129. Imprisonment for the life means imprisonment for 20 years, 74 years, 14 years, whole of the remaining life. Correct answer is D, whole of the remaining life. Question number 130. Chapter 4 of the IPC code deals with, correct answer is option D, that is general exceptions. Question number 131. General exception of IPC limit and override offences and penal provisions of the code and comprises of the following sections: A. 61 to 102, B. 96 to 106, C. 82 to 106 and D. 76 to 106. Correct answer is option D, that is section 76 to section 106. Question number 132. The maxim ignorantia juris non exequat means ignorance of law is no excuse, ignorance of fact is no excuse, ignorance of law is an excuse, ignorance of fact is an excuse. Correct answer is option A, that is ignorance of law is no excuse. Question number 133. Ignorantia facet exequat maxim means mistake of law is excused, ignorance of fact is an excuse, ignorance of law is not an excuse, none of these. Correct answer is option B, that is ignorance of fact is an excuse. Question number 134. The maxim ignorantia facet exequat relates to section 75 of IPC, section 76 of IPC, section 77 of IPC, none of the above. Correct answer is option B, that is section 76 of the IPC. Question number 135. A soldier fires on a mob by the order of his superior officers in conformity with the commands of law. A has committed no offence with his defence comes under section dash of IPC. Options are section 76, section 77, 78, 79. Correct answer is option A, that is section 76. Question number 136. Assertion. A soldier fires on a mob by the order of a superior officer in conformity with the commands of law. A has committed no offence. Reason: nothing is an offence which is done by a person who is bound by law to do it. Choose the correct answer from the quotes given below. Quotes are both A and R are true and R is the correct explanation of A. Option B, both A and R are true but R is not the correct explanation of A. Option C, A is true but R is false, and option D, A is false but R is true. Here the correct answer is option A, that is both A and R are true and R is the correct explanation of A. Question number 137. For the defense of mistake of fact under IPC, option A, actual mistake is sufficient, the act must be reasonable, the act must be reasonable as well as committed in good faith, none of the above is correct. Here the correct answer is option C, that is the act must be reasonable as well as communicated in good faith. Question number 138. A, an officer of a court being ordered by the court to arrest Y and after due inquiry believing Z to be Y arrests Z. What mistake has been committed by A? Option A, mistake of fact, option B, mistake of law, option C, both A and B above, and option D, none of these. Here the correct answer is option A, that is mistake of fact. Question number 139. A police officer without warrant apprehends Z who has committed murder. A has committed the offence of option A, wrongful confinement, B, wrongful restraint, C, A and B both, and option D, no offence. Correct answer is option D, that is no offence. Question number 140. A in good faith accuses Z before a magistrate. Option A has committed no offence. Option B, A has committed the offence of defamation. Option C, A has committed the offence of defamation but he can take defence under section 93 of IPC, and option D, none of the above. Correct answer is option A, that is A has committed no offence. Question number 141. A soldier fires on a mob by the order of his superior officer in conformity with the commands of the law due to which certain persons are injured. What offence has been committed by A? Options are attempt to murder, hurt, grievous hurt, no offence. Correct answer is option D, that is no offence. Question number 142. Which of the following sections of IPC act done in pursuant to judgment or order of a court is not an offence? Options are section 78, section 79, section 90, section 91. Correct answer is option A, that is section 78. Question number 143. Which of the following statement is correct? A hangman who hangs the convict pursuant to the order of the court is exempted from the criminal liability by virtue of section 94 of IPC, section 76 of IPC, section 78 of IPC, section 77 of IPC. Correct answer is section 78 of IPC. Question number 144. A is a police officer. A court of law orders him to arrest B. After due inquiry and believing C to be B, A arrests C. In this case, is guilty of wrongful confinement, can take the defense of mistake of fact, can take the defense of authority of law. None of the above is correct. Correct answer is option B, that is can take the defense of mistake of fact. Question number 145. An act which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law, then act of judge is an offence because judge should have the knowledge of law, is not an offence, is punishable, is unpardonable, and maximum punishment should be imposed. Correct answer is option B, that is it is not an offence. Question number 146. A and B corporation officers legally demolish the illegal constructed structure of C and remove the material for safe custody. Which offence is committed by A and B? Option A, criminal breach of trust. Option B, dishonest misappropriation of property. Option C, theft, and option D, none of the above offence. Correct answer is option D, that is no offense. Question number 147. Which provision of the IPC says nothing is an offense which is done by an accident? Option A, section 79 of IPC, option B, section 78 of IPC, and option C, section 80 of IPC, and option D, none of the above. Correct answer is option C, that is section 80 of IPC. Question number 148. Which of the following is not an essential ingredient of the defense of accident under section 80 of IPC? Options are: the act must be an accident or misfortune, and option B, the act must not be done with any criminal intention, option C, the act need not to be done with proper care and caution, and option D, the accident must be the outcome of lawful act done in lawful manner by lawful means. Here the correct answer is option C, that is the act need not to be done with proper care and caution. Question number 149. A is cutting the wood with an axe at a place where children are playing. The axe flies off and kills a nearby child. A is liable for no offense, murder, culpable homicide, causing death by negligence. Correct answer is option D, that is causing death by negligence. Question number 150. A is at work with hatchet. The head flies off and kills a man who is standing nearby. No want of proper caution on the part of A. His act is murder, culpable homicide not amounting to murder. His act is excusable, not an offense, causing death by negligence. Correct answer is option C, that is his act is excusable, not an offense. Question number 151. B is drowning and insensible. A, in order to save his life, pulls him out of the water with a hook which injures him. A is guilty of A, using criminal force, B, voluntarily causing hurt, C, voluntarily causing grievous hurt, and D, no offense. Here the correct answer is option D, that is no offense. Question number 152. A male teacher during examination while conducting search put his hands in the pocket of the pant of a girl candidate thinking her to be a boy. Here the teacher under the IPC has committed offence under this section: A 354, B 323, C 509, and option D, none of the above. Correct answer is option D, that is no offence. Question number 153. A workman throws snow from the roof giving warning. A passerby is killed. The workman is guilty of murder, guilty of culpable homicide not amounting to murder, guilty of causing death by negligence, not guilty since death was accidental. Correct answer is option D, that is not guilty since death was accidental. Question number 154. Which of the following cases necessity under section 81 of IPC cannot be pleaded as a defense? Option is A, self-defense and prevention of violence, prevention of harm to the accused at the expense of an innocent person, self-preservation is an absolute necessity. Option D, choice of evils affecting the person other than the accused. Correct answer is option B, that is prevention of harm to the accused at the expense of an innocent person. Question number 155. To preserve one's life is generally speaking a duty, but it may be the highest duty to sacrifice it. This observation was made in Queen versus Dudley by Stephens by option A, Lord Denman, option B, Lord Coleridge, option C, Lord Acton, and option D, Justice Pollock. Here the correct answer is option B, that is Lord Coleridge. Question number 156. Necessity as a defense cannot be claimed when the act has been done with good faith, without criminal intent, without inherent risk of causing harm, for avoiding the other greater harm. Correct answer is C, with inherent risk of causing harm. Question number 157. The case of R versus Dudley and Stephen is related to the defense of option A, insanity, B, intoxication, C, mistake of fact, and D, necessity. Correct answer is option D, that is necessity. Question number 158. Z is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Z, but not intending to kill Z, and in good faith intending Z's benefit, A's bullet gives Z a mortal wound. Options are: A has committed the offence of murder as the malice travels with a bullet. Option B, A has committed to murder Z and wildlife animal the tiger. Option C, A has committed no offence, and option D, none of these. Here the correct answer is option C, that is A has committed no offence. Question number 159. X and Y are swimming in the sea. After a shipwreck got hold of a plank, the plank was not large enough to support both. X, having no other option, pushed Y, who was drowned. X has committed culpable homicide, murder, the offence of causing death by negligence, no offence. Correct answer is no offence. Question number 160. The acts of a child constituting general exceptions under IPC are mentioned in Options are section 81 to 82, section 82 to 83, section 83 to 84 and section 84 to 85. Correct answer is option B, that is section 82, 83. Question number 161. Nothing is an offence which is done by a child under 7 years of age is based on the legal maxim dolly capax, dolly in capax, de minimis non curate lex. None of these. Correct answer is option B, that is dolly in capax. Question number 162. The principle of dolly in capax under IPC is an exception to the criminal liability in which of the following sections? Section 81, section 82, section 84, section 87. Correct answer is option B, that is section 82. Question number 163. Which provision of IPC says nothing is an offence which is done by a child under 7 years of age? Correct answer is option C, that is section 82. Question number 164. Nothing is an offence which is done by a child under 8 years, 10 years, 7 years, 12 years. Correct answer is 7 years. Question number 165. Which of the following is presumed under the law to be dolly in capax to commit a crime? Option A child under 7 years of age, option B, a child under 10 years of age, and option C, a child above 7 years and under 12 years of age, and option D, a child between 10 years and 14 years of age. Here the correct answer is option A, that is a child under 7 years of age. Question number 166. Section 82 of IPC deals with the following. Option A, absolute immunity, option B, qualified immunity, option C, conditional immunity, and option D, contingent immunity. Here the correct answer is option A, that is absolute immunity. Question number 167. Nothing is an offence which is done by a person who is a, option A, boy of 6 years having sufficient maturity to understand the nature and consequences of his conduct. Option B, girl below 12 years having sufficient maturity to understand the nature and consequences of her conduct. And option C, a man aged 100 years. And option D, all of the above. Here the correct answer is option A, that is boy of 6 years having sufficient maturity to understand the nature and consequence of his conduct. Question number 168. Under section 83 of IPC, a child is considered to be dolly capax when he is above 7 but below 14 years of age, above 7 but below 12 years of age, of 7 years of age, above 8 but below 14 years of age. Correct answer is option B, that is above 7 but below 12 years of age. Question number 169. The leading case on section 83 of IPC is Bishambar versus Rumal, Devanarayan versus State, Ula versus King, Daya Bhai Chaggan Bhai Thakur versus State of Gujarat. Correct answer is option C, that is Ula versus King. Question number 170. Assertion. A boy aged 9 years intentionally kills B. A is liable to be convicted. Reason. The child up to age of 12 years is immune from criminal liability. Options are both A and R are true but R is not the correct explanation of A. Option B, both A and R are true but R is not the correct explanation of A. And option C, A is true but R is false. And option D, A is false but R is true. Here the correct answer is option C, that is A is true but R is false. A child of 9 years of age stole a gold necklace and immediately afterwards sold it to the accused. Is he guilty of theft? Options are the child is not guilty as he lacked a sufficient maturity of understanding. Option B, the child is guilty as he has attained a sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion. Option C, the child is not guilty as he was below 12 years of age. And option D, none of the above. Here the correct answer is option B, that is the child is guilty as he has attained a sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion. Question number 172. Which expression has been used under section 84 of the IPC? Options are madness, mental ailment, unsoundness of mind, insanity. Correct answer is option C, that is unsoundness of mind. Question number 173. Under which section of IPC act of a person of an unsound mind is not an offence? Options are section 82, section 84, section 83, section 85. Correct answer is section 84. Question number 174. The expression unsoundness of mind is not defined in IPC, is defined in IPC, is not treated as equivalent to insanity, is not general exception in IPC. Correct answer is option A, that is it is not defined in IPC. Question number 175. Insanity is lack of free will, incapacity produced due to drunkenness, incapable of knowing the nature of act committed, diseased mind. Correct answer is option C, that is incapable of knowing the nature of act committed. Question number 176. Which of the following is known as wild beast test? Options are A, Hadfield's case, B, Barlow's case, C, Ferrer's case, and D, R versus Arnold. Here the correct answer is R versus Arnold. Question number 177. The maxim non compos mentis means child of 10 years, not cooperative, not of sound mind, and option D, none of these. Correct answer is option C, that is not of sound mind. Question number 178. Which type of insanity of the following is a ground for exemption from criminal responsibility? Options are medical insanity, lunacy, legal insanity, moral insanity. Correct answer is option C, that is legal insanity. Question number 179. Expression unsoundness of mind has not been defined in IPC and has mainly been treated as equivalent to insanity. An accused who seeks exoneration from liability of any act under section 84 IPC is to prove legal insanity and not medical insanity. It was held by the Supreme Court in the following case. Option A, Abrar versus State of UP. Option B, Surendra Mishra versus State of Jharkhand. Option C, CM Sharma versus State of Andhra Pradesh. And option D, Geeta versus State of UP. Correct answer is option B, that is Surendra Mishra versus State of Jharkhand. Question number 180. Section A. Nothing is an offence which is done by a person who at the time of doing it by reason of unsoundness of mind incapable of knowing the nature of the act. Reason: mistake of fact is a good defence and mistake of law is no defence. Options are both A and R are true and R is the correct explanation of A. Option B, both A and R are correct but R is not the correct explanation of A. And option C, A is true but R is false. And option D, A is false but R is true. Here the correct answer is option B, that is both A and R are correct but R is not the correct explanation of A. Question number 181. Z, under the influence of madness, attempts to kill A. In this case, which of the following is correct? Option A, Z is guilty of attempt to murder but A has right of private defense. Option B, Z is guilty of no offense but A has the right of private defense. This is the correct answer. Z is guilty of no offense but A has the right to private defense. Question number 182. A, under the influence of unsoundness, attempt to kill B. B, in attempting to defend himself, caused grievous hurt to A. Here, option A is liable for the attempt to murder and B is liable for causing hurt. Option B, A commits no offence and B is liable for grievous hurt. Option C, B commits no offence and A is liable for attempt to murder. And option D, both A and B are excused from liability. Correct answer is option D, that is both A and B are excused from liability. Question number 183. McNaughton's case is related to which of the following sections of IPC? Correct answer is Section 84. Question number 184. Which of the following case lays down the principle relating to the defense of unsoundness of mind? Options are R versus Prince, McNaughton's case, R versus Dudley and Stephen. Option D, Mehboob Shah versus Emperor. Correct answer is option B, that is McNaughton's case. Question number 185. Which section of the IPC deals with the defense of involuntary intoxication? Options are Section 84, Section 85, Section 86, Section 87. Correct answer is option B, that is Section 85. Question number 186. The defense of intoxication is not available. Option A, where the person is incapable of knowing the nature of act. Option B, where the intoxication is voluntary. Option C, where the person is incapable of knowing that what he is doing is wrong. And option D, when the person is incapable of knowing that what he is doing is contrary to law. Correct answer is option B, that is where the intoxication is voluntary. Question number 187. Which of the following is a leading case on intoxication? Options are Nathulal versus State of MP. Option B, Director Public Prosecutions versus B.Ed. Option C, Barrow versus 𝐒𝐥𝐴𝐴𝑥. Option D, none of the above. Correct answer is option B, that is DPP, Director Public Prosecutions versus B.Ed. Question number 188. Consider the following statements. The accused at the time of committing the act because of intoxication which was administered to him without his knowledge or against his will is incapable of knowing. Option 1, the nature of the act. Option 2, that the act is wrong or contrary to law. Option 3, that the act is immoral or wrong. And option 4, that the act is of the nature which may be ignored. To claim the benefit of Section 85 of IPC, which of the above need to be proved? Correct answer is option C, that is first and second. That is the nature of the act is wrong or contrary to law. Question number 189. Which section of IPC deals with the voluntary intoxication? Correct answer is Section 86. Question number 190. The case of Durham versus United States is related to insanity, intoxication, necessity, accident. Correct answer is insanity. Question number 191. Which of the following is correctly matched? Section 80, accident. Section 81, insanity. Section 84, necessity. Section 85, mistake of fact. Correct answer is option A, that is Section 80, accident. Question number 192. In Basudev versus State of Pepsu, the Supreme Court has explained the true scope of the following section of the IPC. Section 84, Section 85, Section 86, Section 34. Correct answer is Section 86. Match list 1 and list 2 and select the correct answer using the code given below the list. List 1, option A, act to judge when acting judicially. Correct answer is Section 77. Accident in doing a lawful act. Correct answer is Section 80. Option C, act of a child under 7 years of age. Correct answer is section 82. Option D, act of a person of unsound mind. Correct answer is section 84. Question number 194. Which one of the following cases does not relate to intoxication? Options are DPP versus Beard, Basudev versus State of Pepsu, R versus McNaughton, and R versus Tandy. In question number 194, correct answer is R versus McNaughton. This is not related to intoxication. This is related to legal insanity. Question number 195. The maxim voluntary non-fit injuria has been incorporated in which of the following section of IPC? Options are section 87, section 90, section 92, none of the above. Correct answer is option A, that is section 87. Question number 196. X, a surgeon, amputates the right hand index finger of Y, a 14-year-old beggar, with Y's consent and in good faith that this would enable Y to get more arms. Option A, X commits no offence as the act was done with consent of Y. Option B, X commits an offence as the consent of a child of 14 years is of no avail. Option C, X commits no offence as the act was done in good faith for the benefit of the consent of Y. And option D, X is not exempted from criminal liability as the act done was not in good faith within the meaning of IPC. Here the correct answer is option D, that is X is not exempted from criminal liability as the act done was not in good faith within the meaning of IPC. Question number 197. A school teacher for the purpose of enforcing discipline inflicts moderate punishment upon a student aged about 11 years. In this case, option A is entitled to claim benefit under section 89 of IPC, A is guilty of causing simple hurt, A is guilty of using criminal force, A is entitled to claim defense under. Correct answer is option A, that is A is entitled to claim defense under section 89 of IPC. Question number 198. A and Z agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of such fencing may be caused without foul play. A while playing fairly hurts Z and as a result Z dies. A is liable, option A, for causing hurt to Z, option B for murder to Z by negligence, and option C for no offence, and option D for culpable homicide not amounting to murder. Correct answer is option C, that is for no offence. Question number 199. Point out the incorrect response. In order to avail the defense under section 89 of IPC, the following condition must be fulfilled. Option A, act done for the benefit of a person who is minor under 12 years of age, act done in good faith, the consent of must always be expressed and never implied. Option D, act must be done by the guardian or by the consent of the guardian. Correct answer is option C, that is the consent must always be expressed and never implied. Question number 200. Which one of the following is not an illustration of section 89 of IPC? Option A, father of B slaps his son B moderately for his benefit. Option B, he confesses his son B for his benefit. Option C, a school teacher for the purpose of enforcing discipline inflicts moderate punishment upon a pupil aged 18 years. And option D, A in good faith for pecuniary benefit of his son B emasculates him. Correct answer is option D. This is not an illustration of section 89 of IPC. Question number 201. Which section of IPC deals with those conditions when consent is said to be not free consent? Correct answer is section 90. Question number 202. In which section of IPC the words good faith has not been used? Options are section 90, section 89, section 92, section 93. Correct answer is A, section 90. In section 90, the word good faith had not been used. Question number 203. Under IPC, the defense of consent is not available in the cases of A, consent to cause death, consent to cause grievous hurt, both A and B, none of the above. Correct answer is option C, that is both A and B, consent to cause death and consent to cause grievous hurt. Question number 204. In which of the following cases consent is free consent? Option A, consent given by a person under fear of injury, consent given by an intoxicated person, consent given under misconception of fact, consent given by a child who is above 12 but below 14 years of age. Correct answer is option D, that is consent given by a child who is above 12 but below 14 years of age. Question number 205. The object of section 92 of IPC is the protection of medical practitioners, the protection of legal practitioners, the protection of intoxicated persons, all of the above. Correct answer is the protection of medical practitioners. Question number 206. Z is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Z, but he does it in good faith, intending to save Z. A's bullet gives Z a mortal wound. Which one of the following statement is correct? A will be held guilty of culpable homicide not amounting to murder. A can take the defense under section 92 of the Penal Code dealing with the acts done without consent. C. A can plead accident. D. None of the above is correct. Here the correct answer is option B. That is, A can take the defense of section 92 of the Indian Penal Code dealing with the acts done without consent. Question number 207. A is in a house which is on fire. With Z, a child. People below hold out a blanket. A's drop the child from the house top, knowing it to be likely that the fall may kill the child, but not intending to kill the child and intending in good faith for the child's benefit, and the child dies. Which of the following offence has been committed by A? Option A. Section 304A of IPC, Section 304 Part 2nd of IPC, Section 302 of IPC. A has committed no offence. Here the correct answer is option D, that is, A has committed no offence. Question number 208. A surgeon sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply the child's guardian. A performs the operation in spite of the entreaties of the child in good faith for the child's benefit. The child died. A has committed option A, culpable homicide, option B, murder, C, attempt to murder, D, no offence. Here the correct answer is option D, that is, no offence. Question number 209. A surgeon in good faith communicates to a patient his opinion that the patient cannot live. The patient dies in consequence of the shock. A is guilty of murder, causing death by negligence, culpable homicide not amounting to murder, no offence. Correct answer is option D, that is, no offence. Act causing slight harm is an offence, no offence, no offence if that harm is so slight that no person of ordinary sense and temper would complain of such harm, none of the above. Correct answer is option C, that is, no offence if that harm is so slight that no person of ordinary sense and temper would complain of such harm. Question number 211. The maxim de minimis non curate lex is related to which of the following sections of IPC? Correct answer is section 95. Question number 212. The maxim de minimis non curate lex is the foundation of which general exception under chapter 4 of IPC? Option A, act of causing slight harm. This is the correct answer, act of causing slight harm. Question number 213. Which of the following conclusions can be drawn from the maxim de minimis non curate lex? Option A, necessity knows no law. Option B, nothing is an offence done by a child under 7 years of age. Option C, every person is liable for his own acts. And option D, trifling acts do not constitute an offence. Correct answer is option D, that is, trifling acts do not constitute an offence. Question number 214. The rule de minimis non curate lex means that trivial discrepancies must not be overlooked. Trivial discrepancies must be overlooked. Significant discrepancies must be overlooked. Significant discrepancies must not be overlooked. Here the correct answer is option B, that is, trivial discrepancies must be overlooked. Question number 215. A blacksmith is seized by a gang of dacoits and forced by threat of instant death to take his tools and to force the door of B's house. The dacoits, 10 in number, loots B's money and jewels and kills B's son A. Option A is guilty of dacoity with murder, is guilty of housebreaking and abetment of dacoity, is not guilty of any offence, is guilty of making preparation to commit dacoity. Here the correct answer is option C, that is not guilty of any offence. Question number 216. X voluntarily joins a gang of dacoits. The head of the gang order X to kill Y, otherwise X would be killed. X kills Y in order to save his life. Which one of the following statement is correct with regard to the liability of X? Option A, X is not liable because the act was done in pursuance to the order given by the superior. X is not liable because the act done under the threat. Option C, X is liable because when a person joins a gang voluntarily knowing the character of the gang, then threat cannot be a defense. Option D, X is liable because in no case to save his own life he can take the life of others. Correct answer is option C, that is, X is liable because when a person joins a gang voluntarily knows the character of the gang, then threat cannot be a defense. Question number 217. Nothing is an offence which is done in exercise of the right of private defense. Where the aid of the society cannot be obtained, individual may do everything necessary to protect himself. Options, both A and R are true and R is the correct explanation of A. Both A and R are true but R is not the correct explanation of A. A is true but R is false. A is false but R is true. Here the correct answer is option B, that is, both A and R are true but R is not the correct explanation of A. Question number 218. The right of private defense is based on the natural instinct of self-respect, self-protection, self-reliance, self-sufficiency. Correct answer is self-protection. Question number 219. Every person has the right to private defense. A. His own body and property, his own body and property and the body of any other person, his own body and property and the body and property of any other person. Correct answer is option D, that is his own body and property and the body and property of any other person. Question number 220. The right of private defense is not a right of defense but of retribution. Is a right of defense but not right of retribution. Is a right of defense as well as the right of retribution. Is neither a right of defense nor a right of retribution. Here the correct answer is option B, that is a right of defense but not a right of retribution. Question number 221. Right of private defense is available to all irrespective of gender and age of person except police officer, officers of armed forces, aggressors, officers of BSF. Correct answer is aggressors. Question number 222. Section 97 of IPC expressly states that the right of private defense is subject to the restrictions contained in Section 99, Section 100, Section 98, Section 102. Correct answer is option A, that is Section 99 of IPC. Question number 223. Right of private defense is available against all members of an unlawful assembly in a free fight to retrieve from the wrongdoer's one property, both A and B and above. Correct answer is option A, that is against all members of an unlawful assembly. Question number 224. In which of the following cases Supreme Court has observed that there is no right of private defense against the right of private defense? Options are State of Punjab versus Sohan Singh, Surjit Singh versus State of Punjab, State of UP versus Ram Swarup, MR Singh versus State of Gujarat. Here the correct answer is option C, that is State of UP versus Ram Swarup. Question number 225. Right of private defense is not available against an insane, against a child, when there is a time to recourse the public authorities, all of the above. Correct answer is option C, that is when there is a time to recourse the public authorities. Question number 226. Which of the following statements is correct? Option A. The right of private defense under IPC is available even against an act which is not offence under the code. The right of private defense can be exercised to repeal unlawful aggression and also to retaliate. The right of private defense is available to defend only own person and property. The right of private defense extends to the causing of death when the assault is made with the intention of wrongfully confining a person. Correct answer is option A, that is the right of private defense under IPC code is available against an act which is not an offence under the code. Question number 227. The right of private defense is available only to adults, only to those who are capable of lawfully commit crime, only to the public servants, to all irrespective of age and capacity. Correct answer is option D, that is to all irrespective of age and capacity. Question number 228. Point out the correct answer. The right of private defense under IPC is subject to no restrictions, subject to restrictions given under Section 99, subject to restrictions given under Section 106, subject to restrictions given under Section 82. Correct answer is option B, that is subject to restriction given under Section 99. Question number 229. Which of the following statement is correct? Option A. The right of private defense under IPC is available even against an act which is not offence under the code. The right of private defense can be exercised to repeal unlawful aggression and also to retaliate. Option C. The right of private defense is available to defend only one's own person and property. The right of private defense extends to the causing of death when the assault is made with the intention of wrongfully confining a person. Correct answer is option A, that is when the right of private defense under IPC code is available even against an act which is not offence under the code. Question number 230. Which section of IPC contains the provisions of causing death in the private defense of the body? Options are Section 99, Section 96, Section 98, Section 100. Correct answer is Section 100. 231. In which of the following cases the right of private defense of body does not extend to causing death? Option A. Assault with the intention of committing kidnapping, assault with the intention of gratifying unnatural lust, wrongful restraint, assault with the intention of committing abduction. Here the correct answer is C, that is wrongful restraint. In wrongful restraint, the right of private defense of body does not extend to causing of death. In other options, it extends to the causing of death. Question number 232. Under IPC, subject to the restrictions laid down under its Section 99, in cases of assault causing reasonable apprehension of death or grievous hurt, right of private defense extends to the voluntarily causing of option A, grievous hurt, death, any harm other than death or grievous hurt. Correct answer is option B, that is death. Question number 233. When the right of private defense of property extends to causing death? Option robbery, option B, housebreaking by night, option C, mischief by fire committed to any building used for human dwelling, and option D, all of the above. Here the correct answer is option D, that is all of the above. Robbery, housebreaking by night, mischief by fire committed on any building used for human dwelling. Here the right of private defense of property extends to causing death. Question number 234. The right of private defense of the body does not extend to voluntarily causing death or any other harm to the assailant if the offence which occasions the exercise of the right to be of any of the descriptions herein enumerated. Option A, assault with the intention of committing rape. Option B, an assault with the intention of kidnapping or abducting. Option C, an assault with the intention of wrongfully confining a person under the circumstances which may not reasonably cause him to have recourse to the public authorities for his release. Option D, an assault of causing grievous hurt on provocation. Here the correct answer is option D, that is an assault of causing of grievous hurt on provocation. Question number 235. In which of the following the right of private defense of the body does not extend to causing of death? An assault with the intention of committing rape, an assault with the intention of kidnapping, an assault with the intention of abducting, an assault with the intention of committing wrongful restraint. Correct answer is option D, that is an assault with the intention of committing wrongful restraint. Here the right of private defense of body does not extend to causing of death. In other options it will extend to causing of death, that is an assault with the intention of committing rape, an assault with the intention of kidnapping, and an assault with the intention of abducting. Question number 236. The right of private defense of body extend to causing of death if there is apprehension of death, apprehension of grievous hurt, intention of committing rape, all of the above. Correct answer is all of the above. Question number 237. Choose the wrong proposition. Option A, right of private defense of the body extends to causing death in case of an assault with an intention of committing rape. Option B, right of private defense of the body extend to causing death in case of an act of throwing acid which may reasonably cause the apprehension that grievous hurt will otherwise be the consequences of such act. Option C, right of private defense of the body extend to causing death is available to the husband against adulterer of his wife. Option D, right of private defense of the body extend to causing death is available in an assault with the intention of gratifying unnatural lust. In question number 237, the wrong proposition which has been asked is given in option C, that is right of private defense of the body extend to causing death is available to the husband against an adulterer of his wife. No, this is not correct, and here the wrong proposition has been asked, so the C option will be the right answer. Question number 238. Against which of the following offences right of private defense of body does not extend to causing death? Option A, rape. B, gratifying unnatural lust. C, causing miscarriage. D, kidnapping. Here the correct answer is causing miscarriage. Question number 239. The right of private defense of body commences as soon as reasonable apprehension of danger to the body arises from an attempt or threat to commit the offence, and it continues as long as apprehension of the danger to body continues. Option B, commences as soon as reasonable apprehension of danger to the body arises from an attempt or threat to commit the offences, and it continues even after that apprehension ceases. Option C, commences only when the assault is actually done and continues during the period of assault. And option D, commences only when the assault is actually done and continues even after the assailant has left. Here the correct answer is option A, that is commences as soon as reasonable apprehension of danger to the body arises from an attempt or threat to commit the offence, and it continues as long as such apprehension of the danger of the body continues. Question number 240. In exercise of right of private defense, even death of the accused can be caused under Section 100 of IPC, Section 102 of IPC, Section 103 of IPC, both A and C. Correct answer is option D, that is both A and C. Section 100 of IPC and Section 103 of IPC. Here the right of private defense, even death of the accused can be caused. Question number 241. The right of private defense of property extend to voluntary causing of death or any other harm to the wrongdoer. This is provided in Section 103, Section 105, Section 96, Section 106. Correct answer is Section 103 of IPC. Question number 242. Against which of the following offences the right of private defense of property extend to voluntarily causing of death? Option A, theft. Option B, criminal misappropriation of property. Option C, robbery. And option D, criminal trespass. Correct answer is option C, that is robbery. Here, against which of the right of private defense of property extend to voluntary causing of death? In robbery. Question number 243. No right of private defense of property is available against the offence of criminal breach of trust, theft, robbery, criminal trespass. Correct answer is option A, that is criminal breach of trust. Question number 244. In which case of the following right of private defense of the property does not extend to causing death? Option A, house breaking by night, house trespass, robbery, mischief by fire. Here the correct answer is house trespass. Right to private defense of property does not extend to causing death. Question number 245. Which one of the following is correct group of offences against which right of private defense relating to property can be exercised? Options are theft, extortion, robbery, mischief. Option B, theft, extortion, mischief, criminal trespass. Option C, robbery, mischief, criminal trespass, extortion. Option D, theft, robbery, mischief, criminal trespass. Correct answer is option D, that is theft, robbery, mischief, criminal trespass. Question number 246. In case of free fight between the two parties, option A, right of private defense is available to both the parties. Option B, right of private defense is available to individuals against individuals. Option C, no right of private defense is available to either party. Option D, right of private defense is available only to one party. Correct answer is option C, that is no right of private defense is available to either party. Question number 247. Y picks X pocket. Next day, X, while buying a pan, near his office finds Y paying money from X purse. X catches hold of Y and tries to take back his purse. Y resists. X twists Y's arm with such force that it is broken. X is charged with causing hurt to Y. X can, option A, say that he was acting under the right of private defense of property. Option B, not raise the plea of right of private defense since he had time to seek the help of public authorities. And option C, say that the right of private defense was revived as soon as he saw Y with his purse. Option D, say that he did not use the more force than was required. Here the correct answer is option B, that is, he cannot raise the plea of right of private defense since he had time to seek the help of public authorities. Question number 248. Which of the following pairs is not correctly matched under the IPC? Section 93, communication of made in good faith. Section 95, act causing slight harm. Section 54, communication of sentence of imprisonment for life. Section 54A, definition of appropriate government. Here the correct answer is option C. Section 54 is not the correct match. Question number 249. What punishment may be awarded to the person whose act is covered under general exception? No punishment, half of the punishment prescribed for that offence, 1/4 of the punishment prescribed for that offence, depends upon the discretion of the court. Correct answer is A, that is no punishment. Match list 1 and list 2 and select the correct answer using the codes given below. List 1, section 81 of IPC. In section 81 of IPC, correct answer is defense of necessity. B option, section 84 of IPC. Section 84 of IPC is related to act of a person of unsound mind. And option C, section 86 IPC. Section 86 IPC is related to intoxication. Then last, section 95 of IPC. Section 95 of IPC is related to act of causing slight harm. Question number 251. Under which section of IPC provision for the offence of abetment is provided? Options are section 106, section 107, section 108 and section D, none of these. Correct answer is section 107. Question number 252. Under IPC, abetment is constituted, option A, by instigating a person to commit an offence, by engaging in a conspiracy to commit an offence, by intentionally aiding a person to commit an offence, all of the above. Here the correct answer is option D, that is all of the above. Abetment is constituted by instigating, by engaging in a conspiracy and by intentionally aiding a person to commit an offence. Question number 253. Which of the following is not a mode of abetment under the IPC? A, attempt, B, instigation, C, aiding, D, conspiracy. Correct answer is attempt. Question number 254. If a person instigates, intentionally aids or engages another person to do a thing, he is said to have abetted such another person, conspired with him, that person becomes member of unlawful assembly, designed commission of offence. Correct answer is option A, that is abetted such another person. Question number 255. The principle of proximity of crime under criminal law is irrelevant while deciding the liability for the offence of. Options are theft and dacoity, culpable homicide and murder, kidnapping and abduction, abetment and conspiracy. Correct answer is abatement and conspiracy. Question number 256. Consider the following statement to constitute abetment. It is necessary that the act abetted must be committed, not necessary that the act abetted must be committed. C, necessary that the person abetted must have same intention or knowledge as that of the abetter. Which of the statements given above represents the correct position of law? Correct answer is option A, that is only B. To constitute abetment, it is not necessary that the act abetted must be committed. Question number 257. Which of the following is not necessary to constitute abetment by conspiracy? A conspiracy between two or more persons. An act or illegal omission must take place in pursuance of that conspiracy. Such an act or illegal omission must also take place in order to do the thing conspired. The abettor should concert the offence with the person who commits it. Here the correct answer is option D. This is not necessary to constitute the abetment of conspiracy. Question number 258. For abetment, it is necessary that the person abetted should be capable of committing the offence under the law. It is necessary that the person abetted should have the same guilty intention. It is not necessary that the person abetted should be capable of committing an offence under the law should have the same guilty intention. D, both A and B. Correct answer is C. That is, it is not necessary that the person abetted should be capable of committing an offence under the law or should have the same guilty intention. Question number 259. A instigates B to murder C. B refuses to do so. A is guilty of which one of the following? Options are criminal conspiracy, abetment to attempt of murder, abetment to commit murder, no offense. Correct answer is option C, that is abetment to commit murder. Question 260. Abettor is a person who commits the offense, who instigates the commission of offense, against whom the offense is committed, who is innocent. Correct answer is option B, that is who instigates the commission of offense. Question number 261. A instigates B to murder C. B refuses to do so. Which one of the following is the liability of A? Since essential to constitute an offense, abetment are not fulfilled, A is not guilty of instigating B to murder C. Option B. The refusal to B to act on the instigation of A puts an end to the matter and A is not guilty of any abetment. Option C. A is guilty of abetting B to commit murder. As to constitute abetment, it is not necessary that the act abetted should be committed. Option D. Since the offense was not committed, then there can be no abetment for an offense which is not committed. Hence, A is not liable. Correct answer is option C. That is, A is guilty of abetting B to commit murder. So as to constitute abetment, it is not necessary that the act abetted should be committed. Question number 262. X instigates Y to commit murder of Z. Y in consequence stabs Z, but Z survives the wound. X is guilty of murder, attempt to murder, abetment of attempt to murder, abetment of murder. Correct answer is option D, that is abetment of murder. Question number 263. A asks his servant to beat B. The servant did so. A is guilty of A. Criminal conspiracy, criminal assault, abetment by instigation, criminal conspiracy, assault as well as abetment. Correct answer is option C, that is abetment by instigation. Question number 264. A priest knowingly officiates a bigamous marriage. A is guilty of conspiracy, abetment by instigation, attempt to bigamy, abetment by intentional aiding. Correct answer is option D, that is abetment by intentional aiding for bigamous marriage. Question number 265. A lets out his premises to B, a police officer, with the knowledge that B will torture their C, an accused in a case. B tortures C in those premises. A is not guilty of any offense under IPC, guilty of abetment, guilty of causing hurt, guilty of attempt to commit offenses. Correct answer is guilty of abetment. Question number 266. Consider the following statements. Statement first. A willfully by misrepresentation misled a police officer to arrest B instead of C. A instigates B to murder C. B refuses to do so. Option 3. A instigates B to murder D. B stabs D. D survives from the wound. Which of the above constitute the offense of abetments? Here the correct answer is option A. 1, 2 and 3. All the three statements will be constituting the offense of abetment. Question number 267. A instigates B to kill C by means of a letter sent through post. The abetment by instigation is complete as soon as the letter reaches the addressee, as soon as the abettor posts the letter to the addressee, as soon as the contents of the letter are known to the addressee, even if letter was sent to a wrong address. Correct answer is option C, that is as soon as the contents of letter are known to the addressee. Question number 268. A instigates B, a person of unsound mind, to set a fire to a dwelling house. B, incapable of knowing the nature of the act that he is doing what is wrong or contrary to law, sets fire to the house in consequence of A's instigation. Which of the following statement is legally correct? Since B is incapable of committing offense, A is also not guilty. Option B. B has committed no offense but A is guilty of abetting the offense. Option C. Both A and B are guilty, and option D. Only B is guilty. Correct answer is option B, that is B has committed no offense because he was of unsound mind, but A is guilty of abetting the offense. Question number 269. Which one of the following statement is not correct? Abetment of an abetment is an offense. Abetment of an illegal omission may be an offense. To constitute the offense of abetment, the effect of requisite to constitute the offense need not to be the caused. The person abetted need not be capable by law of committing an offense. Correct answer is option A, that is abetment of an abetment is not an offense. This is not correct. Abetment of an abetment is an offense. That would be the correct answer. That would be the correct statement. But here the wrong statement is asked, so the option A is right. Question number 270. Abetment of an offense is always an offense, may be an offense depending on the circumstances, but not always, never an offense, may not be an offense depending on the circumstances. Correct answer is option A, that is always an offense. Question number 271. Section 109 of IPC is a rule of evidence, substantive offense, a procedure defining clause. Correct answer is substantive offense. Question number 272. A instigates B to instigate C to murder Z, and C commits that offense in consequence of B's instigation. Here A is not guilty of any offense, not guilty of abetting murder, guilty of abetment by conspiracy, guilty of abetting murder. Correct answer is option D, that is guilty of abetting murder. Question number 273. A abets B to assault C. B murders C. Option A is liable for abetment of assaulting C. A is liable for abetment of assaulting and murdering C. A is liable for abetment of murder of C. A is liable for murder. Correct answer is option A, that is A is liable for abetment of assaulting C. Question number 274. A is with guilty intention abets P, a child of 6 years, to commit theft in B's house. The act is not committed. Here A is guilty of theft, guilty of no offense, guilty of abetting theft, guilty of abetting to commit theft. Correct answer is option C, that is guilty of abetting theft. Question number 275. A person who is 19 years of age instigates his sister B, who is 6 years of age, to pick the pocket of a co-passenger. As soon as B slips the purse of the co-passenger in her school bag, she is caught. However, when the purse is opened, it is found to be empty. In this case, which one of the following statement is correct? Option A and B have committed no offense. Option B, A has committed no offense while B has committed theft. Option C, A has committed an offense and B has abetted the same. And option D, B does not commit any offense and A is guilty of abetment. Here the correct answer is option D, that is B does not commit any offense but A is guilty of abetment. Question number 276. B, with the intent to temporarily use W's money and later on return it, instructs C with his 6-year-old son to take away W's purse containing rupees 20,000 without W's consent. C carried out the instructions. The criminal liability in this case is option A, C is guilty of theft, and B of abetment to commit theft. Option B, B does not commit any offense but C commits theft. And option C, both B and C are not guilty of any offense. And option D, B is guilty of abetment of theft and C is not guilty of any offense. Correct answer is option D, that is B is guilty of abetment of theft and C is not guilty of any offense, because he is below 6 years child. He will come into the category of dolly incapax, whereas B will be guilty of abetment of theft. Question number 277. A instigates B to instigate C to murder Z. B accordingly instigates C and C committed murder of Z. Who will be liable for the punishment? A, only C, B, only B, C, only C and B, and or D, A, B and C. Correct answer is option D, that is A, B and C, because A has instigated B and B has instigated C. Therefore, C committed murder, but abetment of an abetment will also be an offense. Question number 278. A instigates B to burn Z's house. B sets fire the home and at the same time commit theft of the property. There, A is guilty of abetting burning of Z's house only, abetting burning of house, and theft only, none of these. Correct answer is option A, that is abetting burning of Z's house only. Question number 279. X, an Indian, abets Y, an American citizen, on telephone from Ajmer to murder P, an American citizen in America. Under what section of IPC X is guilty of abetment? Section 108, Section 108A, Section 110, Section 110A. Correct answer is option B, that is Section 108A. Question number 280. A in India instigates B, a foreigner in Pakistan, to commit murder in Pakistan. B commits murder. In this case, A is guilty of abetting murder. A is not guilty of any offense. A is liable for committing murder. None of the above answer is correct. Correct answer is option A, that is A is guilty of abetting murder. Question number 281. Which of the following are true in the context of abetment? A says to B, I intend to kill C. B says, do as you like. A kills C. B is guilty of abetment, instigation, abetment to murder, none of the above. Correct answer is option D, that is none of the above. Question number 282. Which one of the following statement is correct? Option A, abettor's liability is dependent on the liability of the principal offender. Option B, if the abettor is innocent, the principal offender is also not liable. Option C, abettor and principal offender may be differently liable for different offences. Option D, the principal offender may have the same guilty mind as that of the abettor. Correct answer is option C, that is abettor and principal offender may be differently liable for different offences. Question number 283. Which of the following is essential offence under section 114 of IPC? Option A, there was abetment by accused. Option B, the act was actually committed in pursuance of abetment. Option C, the accused was present while the act was being committed. And option D, all of these. Correct answer is option D, that is all of these. Question number 284. A incites B to beat C. Subsequently, A reaches the place where B is beating C. A is liable under Section 34, Section 109, Section 114, Section 115. Correct answer is Section 114. Question number 285. In which alternative out of the following there are only inchoate offences? Option A, abetment, conspiracy, bigamy. Option B, abetment, conspiracy, attempt. Option C, conspiracy, attempt, bigamy. And option D, kidnapping, abetment, sedition. Correct answer is option B, that is abetment, conspiracy and attempt. Inchoate offences are incomplete offences, and option B is the correct answer. Abetment, conspiracy and attempt are the inchoate offences. Question number 286. Match list 1 and list 2 and select the correct answer by using the codes given below. List 1. Abetment of an abetment is an offence. Correct answer is section 108 of IPC explanation 4. Option B. Abetment of illegal omission. Correct answer is section 108 explanation 1. Third, person abetted need not be capable by law of committing an offence. Correct answer is section 108 explanation 3. And the last, effect of abetment is immaterial. Correct match for this is section 108 of IPC explanation 2nd. Therefore, the correct answer for this in the given option will be option D. Question number 287. In which section of IPC the definition of criminal conspiracy is given? Correct answer is option B, that is section 120A. The definition of criminal conspiracy is given. Question number 288. Under which provision of IPC punishment for criminal conspiracy is given? Correct answer is option A, that is section 120B. The punishment for criminal conspiracy is given. Question number 289. To constitute an offence of criminal conspiracy under IPC, what is necessary condition to be proved? Option A, there must be a prior meeting of 2 or more persons. Option B, there must be an agreement of 2 or more persons to do an illegal act or to do an legal act by illegal means. Option C, a person does an illegal act with the help of 2 or more persons. And option D, 2 or more persons commit a crime, sudden provocation with guilty mind. Here the correct answer is option B, that is there must be an agreement of 2 or more persons to do an illegal act or to do a legal act by illegal means. This is the correct answer. Question number 290. An agreement is designated as criminal conspiracy if 2 or more persons agree to do an illegal act. Some illegal act is done by all the parties to such agreement in pursuance thereof. Any illegal act is done by at least one party to such agreement, none of the above. Correct answer is option A, that is 2 or more persons agree to do an illegal act. Question number 291. Which of the following case is known as Lamington Road shooting conspiracy case? Options are R versus Blake and Ty, In Ray and Ramaratnam, Emperor versus Vaishampayam, Mirza Akbar versus King Emperor. Correct answer is option C, that is Emperor versus Vaishampayam. Question number 292. Which one of the following is not an ingredient of offence of criminal conspiracy? Options are the agreement between 2 or more persons who are alleged to conspire. The agreement should be to do an illegal act. Option C, the agreement should be to do an act which, though not illegal, but is done by illegal means. And option D, some overt act in pursuance of the agreement is always necessary to be done even if the agreement is to commit an offence. Correct answer is option D. This is not the ingredient of offence of criminal conspiracy, and other 3 options given are the ingredient of criminal conspiracy. Question number 293. For criminal conspiracy, minimum number of persons required is 7, 5, 2, 3. Correct answer is 2. For criminal conspiracy, minimum 2 persons are required. Question number 294. What is not necessary to constitute an offence of criminal conspiracy? 2 or more persons, 5 or more persons, agreement to cause illegal act if act is not crime, to do some act in pursuance of the agreement. Correct answer is option B, that is 5 or more persons. Only 2 persons are required to constitute an offence of criminal conspiracy where there is an agreement to cause illegal act and if act is not crime, to do some act in pursuance of the agreement. Question number 295. For the offence of conspiracy, following is not true. Option A, minimum 2 persons required. Offence is heavily mental in its composition. Conspiracy is a rule of evidence. Mere agreement to do anything contrary to law is punishable. Correct answer is option C. Conspiracy is a rule of evidence. For the offence of conspiracy, this statement is not correct. Other statements are correct. Question number 296. When 2 or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means, such an agreement is option A, designated as criminal conspiracy. Option B, designated as a criminal abetment. Option C, both criminal conspiracy and abetment. And option D, none of the above. Correct answer is option A, that is designated as criminal conspiracy. Question number 297. X and Y agree to commit theft in Z's house, but no theft is actually committed. They are guilty of no offence, criminal conspiracy, abetment by instigation. Correct answer is option B. They will be guilty of criminal conspiracy. Question number 298. When A dies as a result of the act of violence by person B, person C not present at the scene of crime can be prosecuted under IPC. Option A, under section 120A and 120B of IPC, under section 141 to 149 of IPC for the act done in furtherance of the common intention, section 34 of the IPC for vicarious liability as C was aware of the offence was likely to be committed by V. Correct answer is option A, that is under section 128 to 120B of the IPC. Question number 299. A and B plan to murder C. The next day they are guilty of the offence of planning, the offence of criminal conspiracy, the offence of attempt to murder, no offence. Correct answer is the offence of criminal conspiracy. Question number 300. Which of the following case is known as the Nasik conspiracy case? Correct answer is Vinayak Damodar Savarkar case is known as the Nasik conspiracy case. Question number 301. A agree with B that he will help B in copying in his examination. This is an act of A, criminal conspiracy, abetment, C, common intention, D, common object. Here this correct answer is criminal conspiracy. Question number 302. Which one of the following statement is correct? Options are: in conspiracy there is no distinction between principal and accessory. Option B, in conspiracy principal and accessory are distinct. Option 3, there has to be distinction between principal and accessory in all offences. Option D, none of the above is correct. Here the correct answer is option A, that is in conspiracy there is no distinction between principal and accessory. Question number 303. A concerts and agrees with B for poisoning C in order to murder him, for which B agrees to procure the poison but did not procure. A and B are guilty of, options are: abetment of murder by conspiracy, attempt to murder with the aid of section 34, criminal conspiracy to murder C, no offence. Correct answer is option C, that is criminal conspiracy to murder C. Question 304. What is the basic difference between an offence of abetment by conspiracy and the offence of criminal conspiracy? Options are: in the case of conspiracy mere agreement is enough, whereas in case of abetment by conspiracy an act should have taken place in pursuance of conspiracy. Option B, there is no difference at all. Option C, in case of conspiracy an act should also have taken place, but in case of abetment by conspiracy no acts need to have taken place. Option D, in case of abetment by conspiracy there need not be an agreement, whereas in case of criminal conspiracy agreement is essential. Correct answer is option A, that is in case of conspiracy mere agreement is enough, whereas in case of abetment by conspiracy an act should have taken place in pursuance of the conspiracy. This is the basic difference between offence of abetment by conspiracy and the offence of criminal conspiracy. Now let us proceed to question number 305. Waging or attempting to wage war or abetting waging of war against the government of India is punishable under, correct answer is section 121. Question number 306. Whoever wages war against the government of India or attempt to wage war shall be punished with, options are: imprisonment up to 14 years with fine, death or imprisonment of life with fine, imprisonment up to 10 years with fine, imprisonment up to 7 years with fine. In question number 306, correct answer is option B, that is whoever wages war against the government of India or attempt to wage war, such shall be punished with death or imprisonment of life with fine. Question number 307. Under which of the following sections of IPC a conspiracy to wage war against the government of India is punishable? Correct answer is section 121A. In section 121A, a conspiracy to wage war against the government of India is punishable. Question number 308. Which section of the IPC defines sedition? Options are: section 122, section 123, section 124, section 124A. Correct answer is section 124A. In section 124A, sedition has defined in IPC. Question number 309. The ambit and the scope of offence of sedition under section 124A of the IPC was considered by a 5-judge constitutional bench of the Supreme Court of India in the case of, here the correct answer is Kedarnath Singh versus State of Bihar. This is the landmark judgment related to sedition. Question number 310. Under section 124A of IPC prescribes punishment for, Options are sedition, waging war against the government of India, abetting mutiny, aiding escape of a prisoner. Correct answer is option A, that is sedition. In section 124A of IPC, punishment for sedition is prescribed. Which of the following is neither an offence against person nor against property? Correct answer is sedition. Sedition is not an offence against a person nor against property, but it is an offence against country. Question number 312. Which one of the following is an essential ingredient of sedition? Here we will discuss the essential ingredient of sedition. Options are dishonest intention, malified intention, words spoken must cause public disorder by acts of violence, words spoken must be capable of exciting disaffection towards the government. In 312, correct answer is option D. The essential ingredient of sedition is words spoken must be capable of exciting disaffection towards the government. Question number 313. Which one of the following is sufficient to prove the offence of sedition? Options are comments expressing disapproval of the policies of the government with a view to obtain a change in policies by lawful means. Option B, proof of disloyalty or ill feelings. Option C, comments expressing disapproval of the administrative action even though these do not excite hatred or disloyalty. Option D, exciting disaffection towards the government. Correct answer in question number 313 is D, disaffection towards the government. Question number 314. Which of the following is a case decided by a federal court on section 124 of IPC? Options are Kedarnath Singh vs State, Nehrendu Dutt vs Emperor, Queen Empress vs Bal Gangadhar Tilak, Emperor vs Sadashiv Narayan. Correct answer is Nehrendu Dutt vs Emperor is a case decided by the federal court on section 124A of IPC. Question number 315. Which one of the following is punishable as sedition? Options are bitter criticism of the government to overthrow it. Option B, inducing people to cease to obey law and lawful authority. Option C, a publicist attacked on the policies of the government. Option D, an attempt to remove the ministers from power. Correct answer is option B, that is inducing people to cease to obey law and lawful authority. This will amount to sedition. Question number 316. A sent through the post offices a packet containing seditious publication with a covering letter requesting the addressee to circulate it to others. It was intercepted and never reached the addressee A. Options: A, committed the offence of sedition. Option B, did not commit any offence. Option C, is guilty of inciting communal riot. Option D, is guilty of attempt to commit sedition. Correct answer will be option D, that is will be guilty of an attempt to commit sedition. Here the proper sedition has not been committed because the post was intercepted, but the attempt to commit sedition was held. Question number 370. X, the chairman of a political party during an election campaign, alleged the ruling party was responsible for inflation, increase in crime, scams and corruption, and hence exalted his party members to overthrow the present government. Which of the following statements will be correct? Options are X is guilty as he was provoking his party men to overthrow the government. Option B, X is not guilty, his acts does not amount to preparation for waging war against the government. Option C, X is not liable as he was saying was true. Option D, X is liable as he was making an irresponsible statement. In 317, correct answer will be option B because it exhaustively explains the situation. X is not guilty as his act does not amount to preparation of waging war against the government. Question number 318. In which of the following section of IPC preparation is punishable? Options are Section 121, 125, 398, Section 122, 125, 399, Section 122, 126, 399, Section 121, 126 and 398. Here the correct answer is option C, that is Section 122, 126 and 399. Section 122 is relating to waging war against government of India and Section 126 is related to committing depredation on territories of power at peace with government of India, whereas Section 399 is related to making preparation to commit dacoity. In all these sections, preparation is punishable in IPC. Question number 319. Which of the following is not punishable under the IPC? Options are preparation to wage war against the state, preparation to commit murder, preparation to commit dacoity, preparation to commit depredation on the territory of friendly power. Here the correct answer is option B, that is preparation to commit murder. Preparation to commit murder is not punishable. Murder and culpable homicide not amounting to murder is punishable. Whereas preparation to wage war against the state is punishable, preparation to commit dacoity is punishable, and preparation to commit depredation on the territory of a friendly power is also punishable. All these sections we have discussed in the last section, Section 122, Section 126 and Section 399, that is related to preparation to commit dacoity. Question number 320. Match list 1 with list 2 and select the correct answer using the code given below. In list 1, Section 120A. Section 120A is related to criminal conspiracy. Option B, Section 121A. Section 121A is related to conspiracy for waging war. Section 124A. Section 124A is very easy. It is related to sedition. Section 108A. Section 108A is related to abatement of offence outside India. So therefore, correct answer for section 320 for question 320 will be option B. Question number 321. Which section of IPC provide for the offence relating to Army, Navy and Air Force? Correct answer is option C, that is section 131 to section 140. In section 131 to 140, offences relating to Army, Navy and Air Force are written. Question number 322. Unlawful assembly has been defined in IPC under unlawful assembly has been defined in section 141. Section 141 exhaustively explains what is unlawful assembly. Question number 323. For an unlawful assembly, the minimum number of persons required is, for an unlawful assembly, the minimum numbers should be 5. Question number 324. Which of the following is not an essential element of unlawful assembly? Options are 5 or more persons. This is an essential element. Common object, common intention to resist the execution of any law or of any legal process. Here it has been asked which of the following is not an essential element. So correct answer will be common intention. Common intention is not an essential element in unlawful assembly, but common object is an essential element in unlawful assembly, including 5 or more person, and to resist the execution of any law or any legal process. Now let us proceed to question number 325. For an unlawful assembly must have a common object of the kind specified in option section 140 IPC, section 141 of IPC, section 142 of IPC, section 144 of IPC. Correct answer is section 141 of IPC. Question number 326. Joining unlawful assembly armed with deadly weapon has been dealt with under dash of the IPC. Options are section 141, section 142, section 143, section 144. Correct answer is section 144. In section 144, joining unlawful assembly armed with deadly weapon has been described in IPC. Question number 327. Rioting means use of force or violence by an unlawful assembly or by a member thereof in prosecution of a common object of such assembly as per section 144 of IPC, section 145 of IPC, section 146 of IPC, section 148 of IPC. Here the correct answer is section 146 of IPC. Question number 328. Use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute. Correct answer is rioting. Question number 329. In IPC, punishment for rioting is provided in section 147. Question number 330. Punishment for rioting under IPC is for 2 years only, for 3 years only, for 2 years or fine or both, for 3 years or fine or both. Correct answer is option C, that is for 2 years or fine or both is the punishment for rioting under IPC. Question number 331. Rioting while armed with deadly weapon is punishable under IPC in options are section 159, section 146, section 147, section 148. Correct answer is option D, that is section 148. Rioting while armed with deadly weapon is punishable in section 148 of IPC. Question number 332. Section 149 of IPC is a declaratory provision, creates a distinct offence, a rule of evidence, all of the above. Correct answer is creates a distinct offence. Question number 333. For an application of section 149 of IPC, the offender must be a member of an unlawful assembly. The offence must have committed in prosecution of the common object, both A and B, either A or B. Here the correct answer is option C, that is both A and B. For an application of section 149, the offender must be member of unlawful assembly and the offence must have been committed in prosecution of a common object. Common object, unlawful assembly will be essential ingredient for section 149 of IPC. Question number 334. The ingredient of section 149 of IPC are, options are knowledge or the probability of the commission of the offence, common intention, unlawful object stated in section 141 of IPC, active participation in commission of crime. Select the correct answer using the codes given below. According to the codes, the correct answer is 1 and 3. Option D will be the correct answer, that is knowledge of the probability of the commission of offence and unlawful object stated in section 141 of IPC. 1 and 3. Question number 335. Which one of the following correctly brings out the main distinction between common intention and common object? Options are common intention creates specific offence whereas common object does not. Common intention as well as common object create specific offence. Common object creates specific offence whereas common intention does not. Both common object as well as common intention do not create specific offence. In 335, correct answer is option C, that is common objects create specific offence whereas common intention does not create a specific offence. This is the correct answer. Question number 336. Which one of the following section of IPC uses the word wantonly? Options are section 1 to section 272, section 172, section 153, section 253. Correct answer is section 153. Question number 337. Promoting enmity between different group on grounds of religion is punished with IPC under section 151, section 153, section 153A, section 153B. Correct answer is section 153A. Promoting enmity between different groups on grounds of religion is punished. Question number 338. Under which one of the following sections of the IPC promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. and doing acts prejudicial to the maintenance of harmony has been dealt with? Correct answer is section 153A. 339. Section 153AA has been inserted in IPC by which of the following Criminal Law Amendment Act? Options are Act of 2001, Act of 2003, Act of 2005, Act of 2006. Correct answer is Act of 2005. Question number 340. Imputations, assertions prejudicial to national integration have been provided under which one of the following sections of IPC? Options are section 154, section 153A, section 153B, D, none of the above. Correct answer is option C, that is section 153B. Imputations, assertions prejudicial to national integration have been provided under section 153B of IPC. Question number 341. Which one of the following section of IPC deals with vicarious liability? Options are section 120A, section 121, section 154, section 159. Correct answer is option C, that is section 154. Section 154 of IPC deals with vicarious liability. Question number 342. Which one of the following section of IPC is an extension of the principle of respondent superior to criminal law? Options are section 121, section 159, section 120A, section 154. Correct answer is section 154. Question number 343. Under IPC, the offence of affray has been defined in, correct answer is section 159. In section 159, the offence of affray has been defined. Question number 344. Which offence does not require the minimum number of 5 persons? Options are rioting, dacoity, affray, none of these. Correct answer is affray. In affray, the minimum number of 5 persons are not required, only 2 persons is required. Question number 345. When 2 or more persons fight in a public place and commit breach of peace, they commit, correct answer is affray. When 2 persons fight in a public place and commit breach of peace, they commit affray. Question number 346. To constitute the crime of affray, what is necessary among the followings? Options are fighting at least 5 persons, fighting in public place, fighting in a market, use of weapons. Correct answer is option B, that is fighting in a public place. Question number 347. Which one of the following offences cannot be committed at a private place? Murder, assault, riot, affray. Correct answer is affray. Affray has to be committed at a public place, whereas riot can be committed at private place. Question number 348. Which of the following does not constitute an offence of affray? Options are 5 or more persons by fighting in public place disturb the public peace. Correct answer is option A, that is 5 or more persons. Only 2 persons required to commit an affray by fighting in a public place or disturbing the public peace. Question number 349. Minimum number of persons required for affray under section 159 of IPC is, correct answer is option B, that is 2. This I have already discussed in last question. Question number 350. Maximum sentence of imprisonment that can be awarded for the offence of affray. Options are 3 months, 2 months, 1 month, 6 months. Correct answer is option C, that is 1 month. Maximum sentence of imprisonment is 1 month that can be awarded for the offence of affray. Question number 351. Which of the following statement is not true? Options are rioting and affray have been divided in section 146 and 159 of IPC respectively. Option B, rioting must be committed in public place, affray may be committed in any place. Option C, rioting is punishable with imprisonment extending to 2 years, affray is punishable with imprisonment extending 1 month. Rioting is committed by 5 or more persons and affray is committed by 2 or more persons. This statement is correct, so this will not be the correct answer. Related to rioting and affray, the punishment which is prescribed, that is for rioting extending 2 years and affray extending to 1 month, is also correct. Therefore, this is also not the incorrect answer. And sections, writing have been defined in section 146. Yes, this is correct. And 159 of IPC, this is also correct. So 3 options are correct. Writing must be committed in public place and affray may be committed in any place. This is the answer because it has been asked in question which of the following is not. Affray has to be committed in public place. That is the must and essential condition for committing affray, and writing whereas can be committed at any place. Therefore, option B will be the correct answer for question number 351. Now let us proceed to question number 352. Personation of a public servant is an offence under section 186, under section 171, under section 170, under section 169. Personation of a public servant is an offence in section 171 of IPC. Question number 353. A private doctor running his own clinic refuses to provide medical treatment to B, a victim of acid attack. A is liable under which one of the following section of IPC? Options are section 166, section 166A, section 166B, section 167. Correct answer is option C, that is section 166B. In section 166B, the culprit will be liable. Question number 354. Bribery is defined in section 170 of IPC, section 171B of IPC, section 171D of IPC, section 171E of IPC. Correct answer is option B, that is section 171B of IPC. This bribery is mentioned in the chapter that is related to elections in IPC. Question number 355. Which section of IPC defines personation at elections? Options are section 171A, section 171B, section 171C, section 171D. Correct answer is section 171D. It is related to personation at elections. Question number 356. False statement in connection with an election is mentioned under which section of IPC? Options are section 171G, section 171H, section 171D, section 171E. Correct answer is option A, that is section 171G. Question number 357. A candidate at an election propagated that he was Chalanti Vishnu and representative of Lord Jagannath himself, and that anyone who does not vote for him would be sinner against the Lord and the Hindu religion. Options are: he is guilty of committing the offence of undue influence at election, punishable under IPC. He is not guilty of an offence under IPC, but his candidature shall be cancelled. Option C, he is not guilty under any law for the time being in force. He is guilty of the offence of personation at election. Here in question number 357, correct answer is option A, that is he will be guilty of committing the offence under offence of undue influence at elections, punishable under IPC. Question number 358. A, being legally bound to appear before a district judge as a witness, intentionally omits to appear. A has committed the offence defined in which section of the IPC? Options are section 172, section 173, section 174, section 175. Correct answer is section 174. In section 174, A has committed the offence by intentionally omitting to appear as a witness. Section 359. Penalty for non-appearance in a case where a declaration has been made under section 82 clause 4 of the Code of Criminal Procedure 1973 pronouncing a person as a proclaimed offender is provided in section 175A of IPC, section 174A of IPC, section 173A of IPC, section 172A of IPC. Correct answer is option B, that is section 174A of IPC. Question number 360. A, being legally bound to produce a document before a district court, intentionally omits to produce the same. A has committed the offence under dash of IPC, section 177, 173, 174 or 175. Here the correct answer is option D, that is section 175. Question number 361. A landholder knowing the murder committed within the limits of his estate willfully misinforms the magistrate of the district that the death has occurred by accident in consequence of the bite of snake. A is guilty of the offence under section 177, section 179, section 178, section 182. Correct answer is option A, that is section 177 of IPC. Question number 362. A refuses to answer a question which is relevant to the subject concerning with the public servant, is authorized to inquire. A is liable to be punished under section 179 of IPC, section 80 of IPC, section 181 of IPC, section 173 of IPC. Correct answer is option A, that is section 179 of IPC. Question number 363. Under IPC, fabricating false evidence has been defined in section 191, section 192, section 193, section 197. Correct answer is option B, that is section 192. In section 192, fabricating false evidence has been defined. Question number 364. Consider the following statements. Having been bound by law to state the truth, a person makes a false statement in a proceeding before a public servant. Statement second. Having been legally bound by an oath to state the truth, a person makes a false statement before the court of justice. Which of the above will amount to give false evidence? Options are 1 only, second only, both 1 and 2, D, neither 1 and 2. In 364, correct answer is option C, that is both 1 and 2. Question number 365. whoever being legally bound by an oath or by an express provision of law to state the truth or being bound by law to make a declaration upon any subject makes any statement which is false and which he either knows or believes to be false or does not believe to be true is said to have committed contempt of court, an offence of giving false evidence, an offence of fabricating false offence, none of the above. Correct answer is option B, that is an offence of giving false evidence. Question number 366. Whoever being legally bound by an oath to state the truth or being bound by law to make a declaration upon any subject matter is said to give false evidence when he makes a statement which is false, he makes a statement which he believes to be false, he makes a statement which he does not believe to be true, all of the above. In 366, option D will be the correct answer. All of the above statements are true. Question number 367. A puts a jewel into the box belonging to B with the intention that they may be found in that box, and this circumstances may cause B to be convicted of theft. A has committed the offence under which section of IPC? Section 191, section 193, section 192. A has committed no offence. Here the correct answer is option C, that is section 192. Question number 368. Punishment for giving false evidence in court is provided under section 198, section 193, section 196, section 197. Correct answer is option B, that is section 193. In section 193 of IPC, punishment for giving false evidence in a court is provided. Question number 369. A makes a false entry in his electronic record for the purpose of using it as a corroborative evidence in the trial court. A has fabricated false evidence, not fabricated false evidence, committed forgery, none of the above. Correct answer is option A, that is A has fabricated the false evidence. Question number 370. A makes a false entry in his shop book for the purpose of using it as a corroborative evidence in a court. He committed the offence punishable under section 191, section 192, section 193, section 194. Correct answer is option C, that is section 193 of IPC. Question number 371. Question number 371. Which one of the following offences under IPC is exclusively triable by a court of session? Options are section 185, section 195, section 205, section 215. Correct answer is section 195. Question number 372. How much punishment may be given to a person accused of giving false evidence in a judicial proceedings? Options are 7 years of imprisonment, 7 years of imprisonment and fine, 7 years of imprisonment or fine, 5 years of imprisonment fine. Correct answer is option B, that is 7 years of imprisonment and fine. Question number 373. Which section was incorporated in IPC by Criminal Law Amendment Act 2006? Options are section 498A, section 153AA, section 229A, section 195A. Correct answer is option D, that is section 195A. Question number 374. Section 195A of IPC is related to protection of witness, protection of victim, threat to give false evidence, none of these. Correct answer is option C, that is threat to give false evidence. Question number 375. As per section 195A of IPC, which was inserted by the Criminal Law Amendment Act 2006, the offence of threatening any person to give false evidence is punishable with, options are imprisonment up to 7 years or with fine or with both, imprisonment up to 5 years or with fine or with both, imprisonment up to 3 years or with fine or with both, imprisonment up to 1 year or with fine or with both. Here the correct answer is imprisonment up to 7 years or with fine or with. Question number 376. Corrupt usage of fabricated evidence as true with the knowledge that the evidence is fabricated is specifically punishable under section 193 of IPC, section 196 of IPC, section 199, section 199 of the IPC. Here the correct answer is option B, that is section 196 of IPC. Question number 377. Using as true any such declaration known to be false is dealt under section 199, section 200, section 201, section 202. Correct answer is option B, that is section 200 of IPC. Question number 378. A knowing that B has murdered Z, hide the body with the intention of screening B from punishment. A is liable under section. Options are 302, 109, 204, 201. Correct answer is 201. Question number 379. Intentional omission to give false information offence of a person legally bound to inform is dealt under section 202 of IPC, 203, 204, 205. Correct answer is option A, that is 202 of IPC. 380. A knowing that B has murdered C, assist B to hide the body with the intention of screening B from punishment. A is liable for the punishment to 7 years imprisonment and fine, 7 years of imprisonment, 5 years imprisonment, 5 year imprisonment and fine. Correct answer is option A, that is 7 year imprisonment and fine. Offence of destruction of electronic record to prevent its production as a evidence is punishable under IPC in section 201, section 202, section 203, section 204. Correct answer is option D, that is section 204. Question number 382. Which section of IPC provides punishment for dishonestly making false claim in the court? Options are section 179, section 205, section 209, section 211. Correct answer is option C, that is section 209 of IPC. Question number 383. When a person tries to escape from lawful custody while taken on a magistrate to furnish security for good behavior could be punished under provision of Section 224 of IPC, Section 225 of IPC, Section 225A of IPC, Section 225B of IPC. Correct answer is Section 225B IPC. When a person tries to escape from lawful custody while taken to a magistrate to furnish security for good behavior could be punished in Section 225B of IPC. Question number 384. A, knowing that B, C, D, E, F and G are about to commit the offence of dacoity in Kathmandu, Nepal, harbors them in his house in Sitamarhi, Bihar with the intention of facilitating the commission of such dacoity. A has not committed any offence as the dacoity was yet to take place, not committed any offence that can be tried in India, committed the offence of harboring dacoits, committed an offence which can be tried and punished in Nepal only. Here the correct answer is option C, that is A has committed the offence of harboring dacoit. Question number 385. Disclosure of the identity of a victim of rape is punishable under which section of IPC? Section 228, Section 228A, Section 376A, Section 376B. Correct answer is Section 228A of IPC. This question is very important for judiciary examination. Question number 386. A harbors B, whom he knows that he has committed a capital offence with the intention of screening him from legal punishment. A will be punished with minimum 2 years of imprisonment, with rigorous imprisonment for a maximum of 5 years, with imprisonment of either description for a maximum period of 7 years, with fine. Correct answer is option B, that is with rigorous imprisonment for a maximum period of 5 years. Question number 387. Which of the following is not correctly matched under IPC? Furnishing false information, Section 177 is the correct match. Giving false evidence, Section 191 is the correct match. Causing disappearance of evidence of offence, Section 205. This is not the correct match, hence the correct answer, and counterfeiting coin is defined in Section 231. Therefore, option C will be the correct answer because it has been asked which of the following is not correct matched under IPC. Question number 338. Chapter 12 of IPC deals with false evidence and offence against public justice, with offence relating to elections, with offence relating to coin and government stamps, with the offence relating to weight and measures. Correct answer is option C, that is with offence relating to coin and government stamps. Question number 389. A imports into India or exports therefrom any counterfeiting coin known the same to be counterfeit. He is guilty under section. Correct answer is Section 237 of IPC. Question number 390. Which one of the following is an Indian coin according to Section 230 of IPC? Options are 𝐾𝐠, lump of unstamped copper which is used as money, Farkhabad rupee, none of the above. Correct answer is option C, that is Farkhabad rupee. Question number 391. Under which section, under Section 230 of IPC 1860, which of the following is not or has not been a coin? Options are the coin denominated as the company's rupee, the Farkhabad rupee, a matter used for time being as money and stamped and issued by the authority of some state or sovereign power, lumps of unstamped metal used as a money. Correct answer is option D, that is lumps of unstamped metal as money. This will not be regarded as coin under Section 230 of IPC. Question number 392. Which provision of IPC makes water pollution punishable? Options are Section 277, Section 278, Section 279, Section 280. Correct answer is option A, that is Section 277. Question number 393. A hotel situated at the bank of a water reservoir, despite objection, discharges its polluted water in the reservoir, causing fouls to reservoir water. For the offence under IPC, the manager of the hotel can be charged under Section 277, 276, 278 or 282. Here the correct answer is option A, that is Section 277. Question number 394. Making atmosphere noxious to health is dealt under Section 278 of IPC, Section 279, Section 280, Section 281. Correct answer is option A, that is Section 278 of IPC. Making atmosphere noxious to health is dealt. Question number 395. Under which of the following section of IPC rash or negligent driving of vehicle on public ways is an offence? Correct answer is option B, that is Section 279. Question number 396. In order to constitute an offence under Section 279 of IPC, person has to drive any vehicle or ride on any public place, on another person's property, on any public way or government property. Correct answer is option C, that is on any public way. Question number 397. The punishment for general form of public nuisance is provided in. Options are Section 268 of IPC, Section 269 of IPC, Section 290 of IPC, Section 291 of IPC. Here the correct answer is option C, that is Section 290 of IPC. Question number 398. Question number 398. Uttering obscene words near public place is not an offence, is an offence under Section 294, is an offence under Section 290, is an offence under Section 292, Clause 2B of IPC. Here the correct answer is option B, that is an offence under section 294 of IPC. Question number 399. A sings obscene songs near the gate of Girls Degree College. What offence he has committed? Assault, outraging the modesty of a woman, criminal intimidation, obscenity. Correct answer is option D, that is obscenity. Question number 400. To which of the following section IPC Hickling rule is related to? Options are section 292, section 291, section 290, section 294. Correct answer is option A, that is section 292. Hickling rule is related. Question number 401. A distributes compact disc CD to B, a young boy of 19 years, for seeing obscene pictures for recreation. A has committed an offence under which of the following section of IPC? Correct answer is section 293. A has committed offence under section 293 of Indian Penal Code. Question number 402. Offences against human body are provided under which of the following chapters? Offences against human body are provided under chapter 16. So here correct option will be option D. Question number 403. Which of the following provisions of the Indian Penal Code defines culpable homicide? Culpable homicide is defined under section 299 of IPC. Now let us proceed to question number 404. Which of the following pairs or sections of Indian Penal Code pertains to culpable homicide and murder? Options are section 34 and 149, section 323 and 325, section 299 and 300, none of the above. Correct answer is section 299 and section 300 are the pairs or sections of Indian Penal Code pertains to culpable homicide and murder. Question number 405. Acts which come into the category of culpable homicide not amounting to murder are mentioned in which sections of IPC? Options are section 300, option B section 299, option C section 299 and 300, and option D section 302. Correct answer is option B, that is section 299. In section 299, culpable homicide not amounting to murder are mentioned in IPC. Question number 406. Killing of human being by another human being is called? Correct answer is homicide. Killing of human being by another human being is called homicide. Question number 407. Culpable homicide means attempt to cause death, causing death intentionally, causing grievous injury, causing injury which is likely to cause death. Here the correct answer is causing death intentionally. Culpable homicide elaborates itself in this option. When a person causes death of another person intentionally, it is called culpable homicide. Otherwise, it will be homicide, that is killing of human being. Question number 408. Homicide is the killing of human being by human being. Reason: homicide is always unlawful. Select the correct answer with the help of quotes given below. Options are both A and R are true and R is the correct explanation of A. Both A and R are true but R is not the correct explanation of A. Option C, A is true but R is false. Here the correct answer will be option C, that is A is true but R is false, because homicide is the killing of human being by human being. This is the correct statement, but homicide is always unlawful. This is not the correct statement, because sometimes in war one person kills the another person in a war, and there are certain many occasions where one person killed another person, but it is considered to be homicide, but there is no culpability in it. Therefore, the reason will be wrong. Therefore, the correct answer will be option C. Now, let us proceed to question number 409. Which one of the following option is incorrect? Option A, all murders are culpable homicide but not vice versa. Option B, all culpable homicides are murder. Option C, an intention to kill not always necessary to make out a case of murder. Option D, clause C of section 299 requires knowledge of the probability of death. Here the correct answer is option B, that is all culpable homicide are murder. All culpable homicide are not murder. So this statement will be the incorrect statement. Therefore, the option B is right. Question number 410. In Rex versus Govinda, the points of distinction between the provisions of the following sections of IPC were explained. Here the correct answer is option C, that is section 299 and 300. Rex versus Govinda is a landmark case which explains the distinction between section 299 and 300 of IPC. Question number 411. Culpable homicide has been defined in. Correct answer is under section 299 of IPC. Culpable homicide is defined. Question number 412. The mens rea required under section 299 of Indian Penal Code is intention or knowledge, intention or negligence, intention or reckless, negligence or malice. These options are incorrect. This is the right statement, intention or knowledge. The mens rea required under section 299 of IPC is intention or knowledge. Now let us proceed to question number 413. Culpable homicide is causing death with the intention of causing such bodily injury as it likely to cause death, with the knowledge that by such act death is likely to be caused. Option C, with the intention of causing death, all of the above. Here the correct answer is option D, that is all of the above. Culpable homicide is causing death with the intention of causing such bodily injury as is likely to cause death, with the knowledge that by such act death is likely to be caused. This is also culpable homicide, and with the intention of causing death. So all the three statements are correct. Therefore the option D is the right answer. Question number 414. Under IPC, which of the following acts will constitute homicide? Options are termination of pregnancy before the 12th week of pregnancy, termination of pregnancy before the 20th week of pregnancy, termination pregnancy before the 36th week of pregnancy, and option D, causing death of a living child after a part of the child's body has been brought forth of mother's body. Here the correct answer is option D, that is causing death of the living child after a part of the child body has been brought forth of the mother's body. This is the right answer. Now let us proceed to question number 415. State of AP versus 𝐷𝐸 case deals with the distinction between which of the following sections of IPC? Correct answer is option B, that is section 299 and 300. AP versus 𝐷𝐸, and Rex versus Govinda is also a landmark case which also deals with the same sections. Now let us proceed to question number 416. Under which of the following cases first time the Supreme Court of India has reaffirmed the distinction between culpable homicide and murder while adopting the view suggested in Govind case? Options are Inder Singh versus State of Pepsu, State of Andhra Pradesh versus R.R. Puneya, K.M. Nanavati versus State of Maharashtra, Madhavan versus State of Kerala. Correct answer is, this we have already discussed, State of Andhra Pradesh versus R.R. Puneya. Here the view suggested in Rex versus Govind case was reaffirmed. Question number 417. A, with the intention to facilitate robbery, put a residential house to fire in the night and causes death of person due to this fire. A has committed the offence of only by putting fire in the house, culpable homicide, intentionally causing death by accident. Here the correct answer is option B, that is culpable homicide. Question number 418. X knows Z to be behind a bush. Y does not know about it. X, intending to cause or knowing to be likely to cause Z's death, induces Y to fire at the bush. Y fires and kills Z. What is the guilt of X and Y? Options are both X and Y are guilty of having committed culpable homicide. Option B, both X and Y are guilty of having committed murder. Option C, X is guilty of having committed culpable homicide but Y is not guilty of having committed any offence whatsoever. And option D, X is guilty of having committed murder but Y is not guilty of having committed any offence. Here the option C will be the correct answer. Here X will be guilty of committed culpable homicide but Y is not guilty of committed any offence. Question number 419. J, a priest, beats a boy for curing him from evil spirit. The boy dies. J is not liable for any offence, liable for culpable homicide, entitled to defence of good faith, liable for attempt to murder. Here the correct answer will be liable for culpable homicide. Question number 420. A fires a bullet into a bush where unknown to him Y is doing some work and bullet kills Y. A is not guilty of murder of Y because A had not fired intentionally at Y. The options are true, partially true, false, none of the above. Correct answer is true. A will not be liable because he has not fired intentionally. There is no culpability or there is no guilty mind, that is mens rea, involved in it. Therefore, Y will not be punished for this act. Question number 421. Under which one of the following provisions of IPC causing death of child in the mother's womb is not homicide? Options are explanation first to section 299, explanation second of section 299, explanation third of section 299, explanation 4 of section 300. Correct answer is option C, that is explanation third of section 299. In this, causing death of a child in the mother's womb is not homicide. Question number 422. Murder is defined in the following section of IPC. This is very easy. Murder is defined in section 300. Question number 423. How many circumstances have been enumerated under section 300 of the IPC under which culpable homicide is murder? Options are 2, 3, 4, 5. Correct answer is option C, that is 4. Question number 424. When the injury is intentional and sufficient to cause death in the ordinary course of nature and death follows, the offence is attempt to murder, culpable homicide and amounting to murder, murder, grievous hurt. Here the correct answer is option C, that is murder. Question number 425. Decision in which of the following cases has been described by the Supreme Court to have attained the status of landmark for bringing out correct test for application of section 300 clause 3 of IPC? Options are Kapoor Singh versus State of Pepsu, Virsa Singh versus State of Punjab, KM Nanavati versus State of Maharashtra, Raval Penta Venkalu versus State of Hyderabad. Here the correct answer is option B, that is Virsa Singh versus State of Punjab. This is a very landmark judgment in IPC and you please remember this question, Virsa Singh versus State of Punjab. Question number 426. Intention to cause death is not essential under section 300 clause. Here the clause has been asked. Options are firstly, secondly, thirdly and fourthly. Correct answer is option D, that is fourthly. In section 300 clause 4, intention to cause death is not essential. Now question 427. The plea of sudden and grave provocation under section 300 exception 1 of IPC is a, options are questions of law, question of fact, mixed question of law and fact, presumption under law. Correct answer is option B, that is question of fact. Question number 428. The case of KM Nanavati versus State of Maharashtra is related to, yes, correct answer is option D, that is grave and sudden provocation. This comes under the exception of murder. Question number 429. In the context of exception of grave and sudden provocation, which of the following is correct? Options are A. Provocation should not be voluntarily provoked by the offender. Lawful exercise of the right of private defense does not give provocation. Lawful exercise of power by a public servant in obedience to the law does not amount to provocation. All of the above. Here the correct answer is option D, all of the above. All the statements are correct statements. Question number 430. Culpable homicide is not murder if it is done under intoxication, sudden and grave provocation, irresistible impulse, all of the above. Correct answer is option B, that is sudden and grave provocation. Culpable homicide will not be murder if this was involuntary intoxication. Question number 431. Which one is incorrect? Culpable homicide does not amount to murder in certain cases of grave and sudden provocation, provided the question whether the provocation was grave and sudden is a pure question of law. The provocation was not sought by the offender. The provocation is not given by anything done in the lawful exercise of right of private defense. The provocation is not given by anything done in the obedience to law. Here the correct answer is option A, that is the question whether the provocation was grave and sudden is a pure question of law. This is incorrect because it will be the question of fact to prove whether the provocation was grave or sudden. Question number 432. Culpable homicide is not murder if it is committed. Options are when the offender is acting in anger, when the offender is acting under the spell of madness, when the consent of the victim who completed 18 years of age, with the consent of the victim who has completed 12 years of age. Correct answer is option C, with the consent of the victim who has completed 18 years of age. Culpable homicide is not murder. Question number 433. Give the correct response. An intention to kill is not always necessary to make out a case of murder. A knowledge that the natural and probable consequences of act would be death could make out a case of murder. Option C, both A and B are correct, and option D, none of the above. Here, both the statements, that is A and B, are correct responses. That's why the option C is correct option. Question number 434. A shoots Z with the intention of killing him. Z dies in consequences. A is guilty of murder, culpable homicide, both A and B, none of the above. Correct answer is option A, that is murder. Here it was the intention to kill him. Question number 435. A appears as a witness before Z, a magistrate. Z says that he does not believe a word of A's deposition and that A has perjured himself. A is moved of sudden passion by these words and kills Z. This is grave and sudden provocation, murder, culpable homicide not amounting to murder, all of the above. Here the correct answer is murder. Question number 436. A, with intent to murder, administered a fatal dose of poison to Z. Then while Z was still alive, a stranger B, without A's knowledge, attacked Z and shot him dead. Here, what will be the correct response? Option A, A and B both would be guilty of murder. A would be guilty of culpable homicide and B would be guilty of murder. Option C, A would be guilty of an attempt to murder and B would be guilty of murder. This will be the correct response. A would be the guilty of an attempt to murder because he has an intention to kill but ultimately killed by B. That's why A would be guilty of an attempt to murder and B would be guilty of murder. Question number 437. A with the intention of murdering Z instigates B, a child below 7 years of age, to do an act which causes Z's death. B, in consequences of instigation, did the act in the absence of A, thereby causes Z's death. What offense has been committed by A? Options are no offense because A was not present at the time of murder, committed simple offense of causing hurt, committed offense of attempt to murder, committed murder. Here the correct answer will be committed murder. Question number 438. A snake charmer, while showing his play, claims to cure the snake bite. The deceased got himself a snake bite, believing on assurance of the snake charmer. The snake charmer could not cure the deceased. The snake charmer is liable for murder, cheating, may be liable for culpable homicide, liable for nothing. Correct answer is murder. He will be liable for murder. Question number 439. X drives very fast through a crowded road to catch the flight, knowing that this act in all probability may cause death. Y is killed by his vehicle. X is guilty of culpable homicide not amounting to murder, murder, grievous hurt, negligence. Correct answer is option B, that is murder. Question number 440. X knows that Y is suffering from a disease in his head and also knows that if a blow is given to Y on a head, it is likely to cause his death. That means X has a knowledge that he can cause death. X gives a fist blow to Y on his head. Y died. X will definitely be liable for murder. Question number 441. Which of the following cases is considered as locus classicus on section 300 thirdly of IPC? Options are Shivaji Sahabrao Bobde versus State of Maharashtra, Virsa Singh versus State of Punjab, Rudal Shah versus State of Bihar, none of the above. Correct answer is Virsa Singh versus State of Punjab, as I have already discussed that this is a great landmark judgment and you must read this judgment thoroughly because the question from Virsa Singh can come in exams. Question number 442. X and Y go to murder Z. X stood on a guard with a spear in hand but did not hit Z at all. Y killed Z. Options are only Y is liable for murder of Z, X and Y are liable for murder of Z, X is not liable as he did not perform overt act, D both A and C. Correct answer is option B, that is X and Y are liable for the murder of Z. Question number 443. Z strikes B. B is by this provocation excited to violent rage. A bystander intending to take advantage of B's rage and cause him to kill Z puts a knife into B's hand for that purpose. B kills Z with a knife. What offense A is guilty of? Options are culpable homicide not amounting to murder, abetting culpable homicide, attempt to murder, murder. Here the correct answer is option D, that is murder. Question number 444. A placed a bomb in a medical store and gave the people inside 3 minutes to get out of before the bomb exploded. B, an arthritic patient, failed to escape and was killed. A is liable for murder, culpable homicide, causing death by negligence, causing death by gross negligence. Correct answer is murder. Question number 445. C, under the influence of passion, excited by a provocation given by A, intentionally kills a child named B. C has committed the offense of, options are murder, culpable homicide not amounting to murder, not committed any offense because he kills B due to provocation, causes the death of B by doing rash negligent act not amounting to culpable homicide. Here the correct answer is option A, that is murder. Question number 446. A, without any excuses, fires a loaded cannon into a crowd of persons and kills one of them. Although he may not have premeditated design to kill any particular individual, A committed the offense of section 299, section 300, section 304, section 304A. Correct answer is section 300. Question number 447. B, intentionally to cause B's death partly by illegally omitting to give B food and partly by beating A. A has committed the offense of culpable homicide not amounting to murder, murder, grievous hurt, hurt. Correct answer is murder. Question number 448. S, a wounded soldier requests his commander Y to shoot him in order to relieve him from pain. The latter shoots him to death. X is guilty of Murder, culpable homicide not amounting to murder, no offense, none of the above. Here the correct answer is B, that is culpable homicide not amounting to murder. Question number 449. Give the correct response. All murders are culpable homicide but not vice versa. All culpable homicides are murders. A murder can never be culpable homicide, none of the above. Here the correct answer is A, that is all murders are culpable homicide but not vice versa. All culpable homicides are not murder, but all murders are culpable homicide. Question number 450. The salient feature required to be considered to assess the defense of grave provocation within the meaning of IPC is, it can only be by words spoken and not otherwise. The mental background created by previous act of the victim cannot be seen considered in any circumstances. Whether a reasonable man belonging to same class of society as the accused placed in the same situation would be so provoked to lose his self-control need to be considered. Applicable only if the accused has a scope for premeditation and calculation. In question number 450, the correct answer is option C, that is whether a reasonable man belonging to same class of society as the accused placed in same situation would be so provoked to lose his self-control need to be considered. Question number 451. Sudden and grave provocation is a defense for the offense of murder. Please specify the category of the defense. Complete defense, partial defense, sentencing defense, general defense. Here the correct answer is partial defense. Sudden and grave provocation is a partial defense in the offense of murder. Now proceed to question number 452. A gave poisoned halwa sweet dish to B with the intention to kill him. B ate one spoon and kept it on the side. C, who was sitting there, picked up and ate it. C dies. Here A is guilty of culpable homicide not amounting to murder, offense of murder of C. Here A is not guilty of murder as he has never intended to kill C. And option D, causing grievous hurt. Correct answer is option B, that is offense of murder of C. Question number 453. X threatens Y that if Y does not shoot P, X will shoot Y. On this, Y shoots P and P dies. The act of Y comes under section 94 of IPC, section 93 of IPC, section 302 of IPC, none of the above. Correct answer is option C, that is section 302 of IPC. Not being armed with deadly weapon and not expressing any intention to kill, A tied B to an electric pole with ropes and assaulted him, as a result of which B died. A committed the offense of punishable under section 302, 304, 304A, 326. Correct answer is option B, that is section 304. Question number 455. The accused inflicted injuries on non-vital parts of the deceased which were not found to be sufficient in the ordinary course of nature to cause death, but it was proved that he inflicted the injuries with the knowledge that with these injuries the victim was likely to die. The case would be punishable under section 301 IPC, 303, 304 part 1 IPC, 304 part 2nd IPC. Correct answer is option D, that is 304 part 2nd IPC. Question number 456. A denied food to his wife B for several days by keeping her confined in a room with an intention to accelerate her death. B ultimately managed to escape. In this case, A is guilty of attempt to murder, A is guilty of wrongful confinement, A is guilty of wrongful restraint, A is guilty of no offense. Correct answer is A is guilty of attempt to murder. Question number 457. Attempt to commit culpable homicide is provided in IPC under. Correct answer is option D, that is section 308. Question number 458. When A dies as a result of an act by B, B cannot be tried and convicted for murder under section 302 of the IPC, for culpable homicide not amounting to murder under section 304 of IPC, for attempting to commit murder under section 307 of IPC, for grievous hurt under section 325 of IPC. Correct answer is option C, that is for attempt to murder under section 307 of IPC. Match the following. Match list 1 and list 2. Attempt to culpable homicide, correct answer is section 308 IPC. Attempt to commit suicide, correct answer is section 309 IPC. Assault provided in section 351 of IPC, and abduction is given under section 362 of IPC. Question number 460. It embodies what was the English author describes the doctrine of transferred malice. Options are section 301, section 34, section 149, section 304A. Correct answer is option A, that is section 301. Question number 461. X intended to kill A but instead killed B, whom he had no intention to kill. Under which doctrine X is liable for the murder of B? Options are doctrine of extended malice, doctrine of mens rea, doctrine of diminished responsibility, doctrine of transferred malice. Correct answer is option D, that is doctrine of transferred malice, provided in section 301 of IPC, as we have discussed in the last question. Question number 462. A had a stepchild whom he wanted to kill. For the purpose, he gave B, who was taking care of the child, a piece of cake which had poison in it, and asked B to feed the child the cake. B, however, ate the cake himself and died as a result. Which of the following statement is accurate? A will be liable for the offence of murder. A will not be liable for the offence of murder. A will be liable for abetment to murder. A will be liable for conspiracy to commit murder. Correct answer is option A, that is A will be liable for the offence of murder. Question number 463. A intentionally fired a shot from his pistol at B, but it hit C and C died. The offence committed by A is attempt to murder, culpable homicide, murder under section 300, murder under section 301. Correct answer is option D, that is murder under section 301. Question number 464. X intended to kill A but instead killed B, whom he had no intention to kill. Under which doctrine X is liable for the murder of B? Doctrine of mens rea, doctrine of transfer of malice, doctrine of extended malice, and doctrine of agency. Correct answer is option B, that is doctrine of transfer of malice. Question number 465. Death caused by rash and negligent act is covered IPC under. Correct answer is section 304A. Question number 466. Section 304A of IPC pertains to dowry death, abetment of suicide, causing death by negligence, culpable homicide not amounting to murder. Here the correct answer is option C, causing death by negligence, section 304A. Question number 467. Which one of the following offences bailable? Options are murder under section 302 of IPC. Murder is not bailable. Death by negligence under section 304A of IPC. Yes, this offence is bailable. Dowry death, section 304B of IPC, this is also not bailable. Abetment to commit suicide under section 306 of IPC, this is also not bailable. So therefore the correct answer will be option B, that is causing death by negligence under section 304A of IPC. Question number 468. If in a trial for causing death by negligence, it is established that the accused had been at fault, though victim had also been equally at fault, the fact that the actual injury was brought about by carelessness or contribution of the victim also will be no defense. Contributory negligence would be a good defense. The degree of culpability as to the amount of negligence on his part shall be deciding factor, none of the above. Correct answer is option C, that is the degree of culpability as to the amount of negligence on his part shall be a deciding factor. Question number 469. A is cutting the wood with an axe at a place where children are playing. The axe flies off and kills a nearby child. A is liable for no offense, murder, culpable homicide, causing death by negligence. Correct answer is option D, that is causing death by negligence. Question number 470. Every doctor is not responsible under section 304A of the Indian Penal Code for the death of a person due to his negligent operation unless his intention is culpable. This has been laid down in Gyanendra vs. State 1972 Supreme Court, Sarveshwar Prasad Sharma vs. State 1978 Supreme Court, Jacob Matthew vs. State of Punjab 2005 Supreme Court, Munna vs. State 2005 Supreme Court. Here the correct answer is option C, that is Jacob Matthew vs. State of Punjab 2005 Supreme Court. Question number 471. The maximum term of imprisonment which can be imposed by the court for the offence of under section 304A of IPC is. Options are 3 years, 2 years, 1 year, 6 months. Correct answer is option B, that is 2 years. Question number 472. Which one of the following section of IPC is related to dowry death? This is also a very important question. Correct answer is section 304B is related to dowry death. Question number 473. Bride burning has been made as an offence under Indian Penal Code in which section? Bride burning is also dowry death. It is given under section 304B. Question number 474. Which is not essential ingredient of offence of dowry death? Options are cruelty or harassment towards woman by her husband or any relative of her husband in, for, or in connection with any demand of dowry. Cruelty must be soon before her death. Ocular testimony regarding injuries by accused person to woman, death of woman within 7 years of marriage. Here the correct answer is option C, that is ocular testimony regarding injuries by accused person to woman. This is not the essential ingredient of the offence of dowry death. Other options, that is cruelty or harassment towards woman by her husband or relative of her husband in front or in connection with any demand of dowry, is an important ingredient. Cruelty must be soon before her death. This is also important ingredient. And one of the most important ingredient is death of a woman within 7 years of her marriage. This 7-year time duration is also very important. So this comes under the ingredient of dowry death. And option C, that is ocular testimony regarding injuries by accused person to woman, is not correct. Question number 475. The offence of dowry death under section 304B of IPC is committed where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within. Options are 7 years of her marriage and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband. Option B, 10 years of her marriage and it is shown that soon before her death she was subject to cruelty or harassment by her husband or any relative of her husband for in connection with any demand for dowry. Here the 10 year, this is not the correct answer. 7 years of her marriage and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of husband or in connection with any demand for dowry. This is the correct answer. Option C will be the correct answer. Number 476. By which amendment section 304B of IPC relating to dowry death was inserted? Options are Criminal Law Amendment Act 1985, Criminal Law Amendment Act 1986, Criminal Law Amendment Act 1987 or Criminal Law Amendment Act 1988. Here the correct answer is option B, that is Criminal Law Amendment Act 1986. Question number 477. Wife of A committed suicide after 2 years of her marriage and before her death she was subjected to cruelty and harassment by A and his parents for demand of dowry. A and his parents has committed the offence of. Correct answer is option D, that is section 304B of IPC. Question number 478. Abetment of suicide of child is punishable under section 306, 305, 309, 109. Correct answer is option B, that is under section 305 of IPC, abetment of suicide of child is punishable. Question number 479. Which one of the following section of IPC relates to punishment for abetment to commit suicide? Options are section 306, 307, 308, 309. Correct answer is section 306. Question number 480. To convict a person for offence under section 306 IPC, ingredient of section 107 are to be proved, ingredient of section 107 IPC are not to be proved, mere cruelty is sufficient, none of these. Correct answer is option A, that is ingredient of section 107 IPC are to be proved. Question number 481. Point out the case where actual commission of an offence cannot be punished. Options are theft, attempt to theft, suicide, none of the above. Correct answer is suicide, because in suicide he cannot be punished. So correct answer is suicide. Question number 482. Which section of IPC provides for punishment for attempt to commit suicide? Options are section 306, 307, 309, 376. Correct answer is option C, that is section 309. Question number 483. Attempts to commit suicide is triable by Court of Session, Magistrate of First Class, any magistrate, Executive Magistrate. Correct answer is option C, that is any magistrate. Question number 484. The case of 𝐵𝐻𝐾𝐽 versus State of Punjab is related to murder, culpable homicide, abetment of suicide, attempt to commit suicide. Correct answer is option D, that is attempt to commit suicide. Question number 485. Right to a life with human dignity does not include right to terminate natural life was held in P. Ratnam versus Union of India, 𝐵𝐻𝐾𝐽 Kaur versus State of Punjab, Rajendra Prasad versus State of UP, Machi Singh versus State of Punjab. Here the correct answer is option B, that is 𝐵𝐻𝐾𝐽 Kaur versus State of Punjab. Question number 486. Which among the following is not an offence? Suicide, murder, preparation to dacoity, attempt to murder. Attempt to murder is also an offence, murder is offence, preparation to dacoity is offence mentioned in IPC. Suicide is not an offence because naturally the person who has committed a suicide will not be there to be punished. So option A is the correct answer. Now question 487. The term thug has been defined in which of the following section of IPC? It's very easy question. Section 310, thug has been defined. Question number 488. Acts with the intention to cause miscarriage administered a drug to pregnant lady. Why? The child in the womb died. X is guilty of murder, culpable homicide not amounting to murder, no offence, causing miscarriage. Correct answer is option D, that is causing miscarriage. Question number 489. A administers poisonous drug to a woman, B to cause miscarriage. It is found that B was not pregnant. In this case, A is guilty of attempt to cause miscarriage, A is guilty of attempt to cause miscarriage, A is guilty of murder, A is guilty of no offense. Correct answer is option B, that is A is guilty of attempt to cause miscarriage. Question number 490. A, claiming to be a family planning expert, gave X some chemical. After consuming the chemical, the child in the womb of X died in the womb. A has committed no offense, offense of murder, offense of culpable homicide not amounting to murder, offense of causing miscarriage. Correct answer is option D, that is offense of causing miscarriage. Question number 491. A, with the intention of causing death of a child, B, who is below 12 years, exposes him in a desert place where A will be liable under which section of IPC? Options are section 317, 307, 304, 511. Correct answer is option A, that is section 317. Question number 492. Section 317 of IPC punishes the offence of exposure and abandonment of child under 12 years by parent or person having care. That is section 304 of IPC provides for punishment for the offence of culpable homicide not amounting to murder. A exposes her child with the knowledge that she is thereby likely to cause its death. The child dies in consequence of such exposure. In such circumstances, A may be charged with and convicted of the offence under section 304 of IPC, charged with and convicted of the offence under section 317 and 304 of IPC, charged with and convicted of the offence under section 317 of IPC, charged with the offence under section 317 and 304 of the IPC, but convicted only for the offence under section 304. In question number 492, option B will be the correct answer, that is charged with the convicted of the offence under section 317 and 304 of the IPC. Question number 493. Hurt as defined in section 319 of the IPC is causing of the following to any person: bodily pain, disease, infirmity. All the options are correct, therefore D is the right answer. Question number 494. A prostitute suffering from a communicable disease has sexual intercourse with a man representing that she was free from any disease, commits unnatural offence, cheating, hurt, mischief. Correct answer is option B, that is hurt. Question number 495. A attacks B to disfigure his face permanently. A could not do so, but causes B severe bodily pain for 10 days. A commits the offence of attempt to murder, voluntarily causing hurt, voluntarily causing grievous hurt, simple hurt. Correct answer is option B, that is voluntarily causing hurt. Question number 496. The offence of grievous hurt has been defined in, correct answer is section 320. The offence of grievous hurt has been defined in section 320 of IPC. Question number 497. How many kinds of hurt are included in grievous hurt under section 320 of the IPC? Correct answer is option D, that is 8. Question number 499. Any hurt is grievous hurt if it causes the sufferer to be in severe bodily pain or unable to follow his ordinary pursuits during the space of 15 days, 20 days, 25 days, 30 days. Correct answer is option B, that is 20 days. For 20 days, if a person is hurt or it causes to suffer severe bodily pain or unable to follow ordinary pursuits, it will come into the category of grievous hurt. Question number 500. A has knocked down 4 teeth of B. A has committed the offence of attempt to cause hurt, causing grievous hurt, attempt to murder. Correct answer is option C, that is causing grievous hurt. Question number 501. Two persons A and B fight with each other. A was having a blade with which A inflicts injury on the face of B, leaving permanent scar on the face of B. A is guilty of the offence of causing. Options are grievous hurt by sharp cutting object, grievous hurt by rash or negligent act, simple hurt by sharp cutting object, simple hurt by rash or negligent act. Here the correct answer is grievous hurt by sharp cutting object. Question number 502. A was beaten by A. In this act, A's shoulder was dislocated, not fractured. B is liable for, here B will be liable for the grievous hurt. Question number 503. Which kind of hurt is not grievous? Options are any hurt which endangers life, any hurt which causes the sufferer to be during the space of 15 days in severe bodily pain, permanent privation of the sight of either eye, privation of any member or joint. Correct answer is option B, that is any hurt which causes sufferer to be during the space of 15 days in severe bodily pain. This is not grievous hurt. Other hurts are grievous hurt. Question number 504. Which of the act amounts to grievous hurt? Options are option A, beating with a hockey stick, emasculation, both, none of the above. Correct answer is option B, that is emasculation. Question number 505. A causes B a superficial skin deep injury by a sword. What offense is committed? Option: hurt, hurt by dangerous weapon, bleeding hurt, serious hurt. Here the correct answer is option B, that is hurt by dangerous weapon. Question number 506. Which one of the following offenses cannot be summarily tried? Options are grievous hurt, theft with the value of stolen properties below ₹100, theft relating to the section 454 and 456 of IPC, offense of abetment of offenses enumerated. Here the correct answer is option A, that is grievous hurt. Grievous hurt cannot be tried summarily. Question number 507. B assaults A using sharp edged weapon, resulting in an injury which is 6 meters long and half meter deep in the right forearm of A. B is liable to be charged for an offence punishable under section 323, section 324, section 325, section 326. Correct answer is section 325 IPC. Question number 508. An offence of voluntarily causing grievous hurt by dangerous weapons or means as provided under section 326 of IPC is compoundable, non-compoundable, compoundable with the permission of court, none of the above. Correct answer is option B, that is non-compoundable. Question number 509. Acid attack is an offence mentioned in section 326, section 320, section 326A, section 354. Correct answer is section 326A of IPC. Question number 510. Which of the following is an offence under IPC? Purchasing acid, throwing acid on a person with the intention of maiming or disfiguring, manufacturing acid, selling acid. Here the correct answer is option B, that is throwing acid on a person with the intention of maiming or disfiguring. Question number 511. In which case the Honorable Supreme Court has directed to pay minimum compensation of ₹3 lakh per acid attack victim? Options are Lakshmi versus Union of India, Sanjay Mitra versus State of West Bengal, Vennagood Anuradha Sameer versus Vennagood Mohandas Sameer, Indra Vijay Ashok versus State of Madhya Pradesh. In question number 511, correct answer is Lakshmi versus Union of India. This is a landmark judgment. It has been asked in various examinations, so please remember this question. Question number 512. Voluntarily throwing or attempting to throw acid is an offence punishable under IPC. This we have already discussed, punishable under section 326B. Question number 513. Voluntarily causing grievous hurt to extort property or a valuable security or to constrain to do anything which is illegal or which may facilitate the commission of an offence is dealt under. Options are section 329, section 330, section 331, section 332. Correct answer is section 329 of IPC. Question number 514. A police officer tortures B in order to induce B to confess that he committed a crime. Under which section of IPC the police officer is guilty of an offence? Correct answer is section 330 of IPC. Question number 515. What punishment may be awarded for the offence voluntarily causing hurt to deter a public servant from his duty under section 332 of IPC? Imprisonment up to 3 years or fine or both, imprisonment up to 5 years or fine or both, imprisonment up to 7 years and fine or both, imprisonment up to 10 years and fine or both. Correct answer is imprisonment up to 3 years or fine or both under section 323 of IPC. Question number 516. Which one of the following sections of IPC relates to punishment for voluntarily causing hurt on provocation? Options are section 324, section 332, section 334, section 323. Correct answer is section 334. Wrongful restraint has been defined under section 339 of IPC, section 340 of IPC, section 341 of IPC, section 342 of IPC. Correct answer is section 339 of IPC. Wrongful restraint is defined in section 339 of IPC. Question number 518. Who voluntarily obstruct any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is wrongful confinement, wrongful restraint, force, defamation. Correct answer is wrongful restraint. Question number 519. Punishment for wrongful restraint is only simple imprisonment, only rigorous imprisonment, both A and B, none of the above. Correct answer is only simple imprisonment. Question number 520. A threatens to set a savage dog at Z if Z goes along a path which Z has a right to do. It is no offence, offence of hurt, wrongful restraint, wrongful confinement. Correct answer is wrongful restraint. N, a landlord after repeatedly demanding and not letting the rent of his flat from the tenant. H, one day locked the flat in order to not to allow H to enter it till he pays the rent to him. Which of the following offences N has committed under IPC? Wrongful confinement, criminal force, assault, wrongful restraint. Here correct answer is wrongful restraint. Question number 522. Wrongful confinement has been defined under section 339, section 340, section 342. None of these. Correct answer is option B, that is section 340 of IPC. Wrongful confinement has been defined. Question number 523. In which section of IPC the punishment for wrongful restraint has been provided? Correct answer is section 341. In section 341, punishment for wrongful restraint has been provided. Question number 524. Police officer arrested and detained a person in lockup despite production of a bail order from court. Police officer is liable to wrongful restraint, wrongful confinement, kidnapping, abduction. Correct answer is option B, that is wrongful confinement. Police officer will be liable for wrongful confinement. Question number 525. A causes Z to go within a walled space and locks Z in. Z thus prevented from proceeding in any direction. Which of the following crimes was committed by A? Here A has committed the wrongful confinement. If any person is confined into some walled space or walled structure and was prevented from proceeding in any direction, it will be wrongful confinement. If in any particular direction, then it will be wrongful restraint. Here the correct answer is option C, that is wrongful confinement. Question number 526. If a police officer arrested and detained a person in the lockup despite producing the bail order from the court, the police officer is guilty of, correct answer is wrongful confinement. Question number 527. A jail doctor confined a prisoner in a cell to administer anemia against his will. He is guilty of, doctor will be guilty of wrongful confinement. Question number 528. A places men with firearms at the outlets of building and tells Z that they will fire at Z if Z attempts to leave the building. Option A wrongfully restrains Z, A wrongfully obstructs Z, A wrongfully confines Z, A wrongfully orders Z. Here option C is correct. A wrongfully confines Z. It will be the wrongful confinement of Z because he cannot leave the building. That's why it is a wrongful confinement. Question number 529. A was on his journey by a car from Delhi to Agra. B met him in a way and requested for a lift up to Mathura, an intermediate town. A acceded to his request, but on reaching Mathura did not drop B there in spite of his repeated request. B was carried over to Agra against his wishes. Here A is not guilty of any offence. A is guilty of offence of abduction. A is guilty of offence of wrongful confinement. A is guilty of using criminal force. Correct answer is A is guilty of offence of wrongful confinement. Question number 530. A police officer arrested and detained a person in the lockup despite production of bail orders from the court. The police officer is guilty of, again we are discussing this question, correct answer is wrongful confinement. Question number 531. A causes Z to go within a walled space and locks Z in. A shall be guilty of, correct answer is wrongful confinement. A will be guilty of wrongful confinement. Question number 532. A police officer without warrant apprehends Z who has committed murder. Option A wrongful confinement, wrongful restraint, A and B both, no offence. Correct answer is no offence because police officer has the right to apprehend a person who has committed murder or who has committed any crime in front of him. Question number 533. A police constable compels a person to remain in police station on false case of theft and allowing him to go after receiving money from him. He is liable for forgery, cheating, extortion, wrongful confinement. Correct answer is wrongful confinement. Question number 534. In which of the following section of IPC punishment for wrongful confinement has been provided? Punishment for wrongful confinement has been provided in section 342. The act of using force by one person to another has been described in section 349, section 350, section 320, section 362, section 351. Correct answer is section A, section 349 of IPC. The act of use of force by one person to another has been described. Question number 536. Which one of the following provision of IPC relates to criminal force? Section 349, section 350, section 351, none of the above. Correct answer is option B, that is section 350. Question number 537. A intentionally pulls up a woman's wheel without her consent, intending or knowing it to be likely that he may thereby injure, frighten or annoy her. A is guilty of molestation, criminal force, assault. Correct answer is option C, that is criminal force. Question number 538. Which one of the following is not an illustration of criminal force? Option A spits over B. A removes the wheel of a lady B causing annoyance to her. A shakes his fist at B. A pours boiling water at the bucket from which B was bathing. Correct answer is option C, that is A shakes his fist at B. This is not an illustration of criminal force. Other option, that is option A, B and D, they are the illustration of criminal force. Question number 539. A incites a dog to spring upon Z without Z. Here A has committed the offence of. Correct answer is criminal force. Question number 540. A spits over B. A would be liable for the offence of annoyance, assault, using criminal force, defamation. Correct answer is using criminal force. Question number 541. In a case, A had a dispute about possession of a land with C. C dug a well with a view to cultivate the said land, but A forcibly entered on the land and damaged well. A committed criminal trespass, mischief, criminal force, none of these. Correct answer is option B, that is mischief. Question number 542. Assault can be caused by gestures, preparations, both A and B, neither A or B. Correct answer is option C, that is both A and B. Assault can be caused by gestures as well as preparations. Question number 543. Assault cannot be caused by mere words, mere gestures, mere preparations, all of these. Correct answer is mere words. Question number 544. Which of the following is not an illustration of assault? A takes up a stick saying to B, I will beat you. A threatens B to see him later on. A medically examines a woman without her consent. A throws brickbats into the house of B. Which of the following is not an illustration of assault? Here the correct answer is option B, that is A threatens B to see him later on. All the other three options, option A, option C and option D, are the illustration of assault, but option B is not the illustration of assault. Question number 545. A shakes his fist at Z, intending or knowing it to be likely that he may thereby cause Z to believe that A is about to strike Z. A has committed use of force, use of criminal force, assault, use of force and assault both. Correct answer is option C, that is assault. Question number 546. A begins to unloose the muzzle of a ferocious dog, intending or knowing it to be likely that he may thereby cause Z to believe that he is about to cause the dog to attack Z. A has committed no offence. A has committed the offence of assault in IPC, committed the offence of attempt to commit assault, committed the offence of criminal intimidation under IPC. Here the correct answer is option B, that is committed the offence of assault under IPC. Question number 547. A person pointing a loaded gun at another person shall be deemed to be guilty of battery, assault, false imprisonment, none of these. Correct answer is option B, that is assault. Question number 548. Assault in order to outrage the modesty of a woman is punishable under section 363 IPC, section 509 IPC, section 511 IPC, section 354 IPC. Correct answer is section 354 of IPC. Assault in order to outrage the modesty of a woman is punishable. Question number 549. A demand or request for sexual favor from a woman is punishable under IPC under section 354A, section 354C, section 354B, section 354D. Correct answer is option A, that is section 354A. Question number 550. Voicerum is defined under which section of IPC? Section 354A, 354B, 354C, section 355. Correct answer is option C, that is section 354C. Question number 551. Offence of voicerum is punishable under section 354D, section 354C, section 354A, section 354B. Correct answer is section 354C of IPC. Question number 552. The offence of voicerum under section 354C of IPC is committed when option A, a man commits the act of physical contact and advances involving unwelcome and explicit sexual overtures, a man makes sexually colored remarks, a man who monitors the use by a woman of the internet, email or any other form of electronic communication, Option D, a man who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator, or disseminates such image. In question number 552, the correct option will be option D. This is related to the offense of voyeurism. Question number 553. When a woman was taking bath in a bathroom, X captures the image in his mobile and upload it on her Facebook page. What offense has been committed by X? X has committed the offense of voyeurism. Question number 554. Voyeurism has been criminalized in India by the virtue of the amendment to IPC. Correct answer is 2013. In 2013, as per the recommendation by Justice Verma Committee, the 2013 amendment takes place and the voyeurism has been criminalized. Question number 555. The offense of stalking is punishable under section 354D of IPC. The offense of stalking is punishable. Question number 556. A man who monitors the use by a woman of internet, email or any other form of electronic communication commits the offense of option A, sexual harassment, option B, criminal trespass, option C, voyeurism, and option D, stalking. Correct answer is option D, that is stalking. Question number 557. A man who regularly visits the Instagram page of a bikini model woman celebrity and also follows her commits the offense of stalking, voyeurism, obscenity. Man commits no offense. Here the correct answer is option D, that is man commits no offense. Question number 558. A and B are good friends. A proposes to B for marriage, but she denies. A, in suspicion of B's love affair with someone else, monitored her mobile phone and email accounts used by B. What offense has been committed by A? Here the A has committed the offense of stalking. Question number 559. According to the IPC, any man who monitors the use by a woman of the internet, email or any other form of electronic communication commits the offense of stalking. Question number 560. Which of the following acts will amount to an offense of stalking? A postgraduate student walking behind a female teacher, a police officer following a woman for detection of crime, a male colleague monitoring the emails of a female colleague, option D, none of these. Here the correct answer is option C, that is a male colleague monitoring the emails of female colleague. Question number 561. Even after a clear indication of disinterest shown by a woman to a man, if such a man follows her, then under which circumstance it would not constitute the offense of stalking? Option A, it was pursued under a law, one-sided love affair, due to commercial transaction, none of the above. These all three options are incorrect and option A is correct if it was pursued under a law. Question number 562. A and B are good friends. A proposes to B for marriage but she denies. A, in suspicion of B's love affair with somebody else, monitors the use of a mobile phone and email account by B. What offense has been committed by A? Here the correct answer is option C, that is stalking. Question number 563. Under which one of the following sections of the IPC an assault or criminal force used in attempting to commit theft of property is punishable? Options are Section 379, Section 381, Section 384, Section 356. Correct answer is option D, that is Section 356. Question number 564. The offense of Section 361 of IPC is basically against family, society, any person, lawful guardian. Correct answer is option D, that is lawful guardian. Question number 565. How many kinds of kidnappings are there in IPC? Option A 1, option B 2, option C 3 and option D 4. Correct answer is option B, that is 2. In kidnapping, the consent of minor is wholly immaterial, partially immaterial, wholly material, partially material. Correct answer is wholly immaterial. Question number 567. The word takes in section 361 of IPC signifies taking by force, taking by fraud, physical taking, all of the above. Correct answer is physical taking. Question number 568. Which one of the following is not an essential ingredient for the offense of kidnapping under IPC? Minor child, intention of the accused without the consent of lawful guardian, out of the keeping of lawful guardian. Correct answer is option B, that is intention of the accused. Question number 569. For the offense of kidnapping, what should be the age of minor? Options are 16 years, 18 years, below 16 years if male and below 18 years if female, within 21 years if male and within 18 years if female. Correct answer is option C, that is below 16 years if male and below 18 years if female. Question number 570. The case of S. Vardarajan versus State relates to section 366A of IPC, section 364A of IPC, section 363 of IPC, none of the above. Correct answer is option C, that is section 363 of IPC. Question number 571. Kidnapping of a female from lawful guardianship can be committed if she is under 16 years of age, under 18 years of age, under 21 years of age, under 14 years of age. Correct answer is option B, that is under 18 years of age. Question number 572. A and B both are of 16 years of age. A entices B for marriage and takes her to another city. What offence has been committed by A? Offence are: A has committed kidnapping, A has committed no offence, A has committed abduction, A is himself minor, A has committed no offence. Correct answer is option A, that is A has committed kidnapping. Question number 573. A is the 17 years old daughter of B. C, without the consent of B, takes A for a tour of South India. C has committed the offence of kidnapping, abduction, wrongful confinement, wrongful restraint. Correct answer is option A, that is kidnapping. Question number 574. A meets a girl aged 15 years in park. She tells him that she is 16 years of age. She is ill-treated at her house by her father and that she would be happy to be taken away from there. Thereafter, A takes the girl to his house and allows her to remain there. In this case, A has committed the no offence as the girl has came with him with her own consent. A has committed no offence as the girl misrepresented her age and A believed her matured and capable of consenting. A has committed the offence of kidnapping of minor from the lawful guardian. A has committed the offence of kidnapping and wrongful confinement. In question number 574, the correct answer is option C, that is A had committed the offence of kidnapping of minor from lawful guardianship, because consent and misrepresentation is irrelevant here. This is the kidnapping of minor from the lawful guardian. Question number 575. Whoever by force compels or by any deceitful means induces any person to go from any places: abduction, kidnapping, slavery, forced labor. Correct answer is option C, that is slavery. Question number 576. Which of the following is an offence of continuing under the IPC? Rape, theft, abetment, abduction. Correct answer is option D, that is abduction. Abduction is a continuing offence. Question number 577. Abduction can be committed against a person of any age, a male or female below 18 years of age, women only, none of the above. Correct answer is option A, that is a person of any age. Question number 578. For the offence of abduction of person, abducted must be option A minor, option B major, option C minor or major, option D none of these. Correct answer is option C, minor or major. Question number 579. Section 362 of IPC, the offence of abduction may be committed with a girl under 18 years of age, a boy under 16 years of age, a person of unsound mind. None of the above is correct. Correct answer is option D, that is none of the above is correct. Question number 580. In which of the following sections of IPC kidnapping or maiming a minor for the purpose of begging has been discussed? Correct answer is option C, that is section 363A. In section 363A, kidnapping or maiming a minor for the purpose of begging has been discussed. Question number 581. A forcibly carries or entices B away from his home in order that B may be murdered. A has committed offence in IPC under section 362, section 364, section 365, section 367. Correct answer is option B, that is section 364. Question number 582. Under which section of IPC kidnapping for ransom is provided? Option A, section 364, section 362, section 363A, section 364A. Correct answer is option D, that is section 364A. Question number 583. Punishment provided for kidnapping for ransom in IPC is up to 7 years of imprisonment, life imprisonment only, death sentence or life imprisonment, 10 years of rigorous imprisonment. Correct answer is option C, that is death sentence or life imprisonment. Question number 584. Under IPC, punishment for the offence of importing girls from any country outside India or from the state of Jammu and Kashmir is up to 10 years if the age of the girl is under 18 years. Correct answer is option C. Question number 555. Whoever kidnaps or abducts any child with the intention of taking dishonestly any movable property from the person of such child shall be punished under section 369 of IPC if the child is under 10 years, 12 years, 14 years, 15 years. Correct answer is option A, that is 10 years. Question number 556. Punishment for trafficking of a person is Section 366A of IPC, Section 368 of IPC, Section 364A of IPC, Section 370 of IPC. Correct answer is option D, that is Section 370 of IPC. Question number 587. What is not an offence under IPC? Option A, marital rape, bigamy, affray, mischief. Bigamy, affray and mischief are the offences under IPC, whereas marital rape is not an offence under IPC. Question number 558. Sexual intercourse with the consent of a girl amounts to rape if she is under. Correct answer is option D, that is 18 years. If a girl is under 18 years, her consent is not meant, there will be an offence of rape. Question number 559. Recently, Supreme Court has interpreted the exception 2 of Section 375 of IPC as sexual intercourse or sexual acts by a man with his own wife, the wife not below the 18 years, is not rape. The case is Independent Thought versus Union of India, Youth Advocate Association versus Union of India, Lily Thomas versus Union of India, 𝐷𝐿𝐿𝐿𝐿 Srivastava versus Union of India. Correct answer is option A, that is Independent Thought versus Union of India. Question number 590. Exception 2 to Section 375 states that non-consensual sexual intercourse by a man with his own wife does not amount to rape. Presently, age circumscribed for this exception is 12 years, 18 years, 21, 15 years. Correct answer for question number 590 is 18 years. Question number 591. The Criminal Law Amendment Act 2018 amended the Section 376 subsection 1 clause A of IPC, increased the punishment for the offence of rape from 7 years to, correct answer is option B, that is 10 years. Question number 592. A commits sexual intercourse with his own wife aged under 15 years with her consent. Option A, no assault, option B, rape, and option C, assault, and option D, use of criminal force. Here the correct answer is option B, that is rape. Question number 593. A promises to marry B, his student, and inducted her to cohabit with him. He has given her a false assurance of marriage and also fraudulently gone through certain ceremonies of marriage, making B believe that she was lawfully wedded wife of A. Later, A refused to recognize her as his wife. What offence has been committed by A? Options are rape, adultery, outraging the modesty of women. A has committed no offence. In question number 593, the option A will be the right, that is rape. Question number 594. A has sexual intercourse with a widow with her consent. A is guilty of rape, adultery, insulting modesty of women, no offence. Here the correct answer is option D, that is no offence. Question number 595. Name of the victim of sexual offence shall not be mentioned. It was held in which of the following case? S. Ramakrishna State, Balwant Rai versus Changi Ram, Gulzari Lal versus State of UP, Rampati versus State of Bihar. Correct answer is option A, that is S. Ramakrishna versus State. This is important. Question number 596. When a man having sex with a woman, even with her consent, man is said to commit rape if the age of that woman is less than 17 years, 19 years, 18 years, 16 years. Correct answer is option C, that is 18 years. If the age of woman is less than 18 years, it will be amount to rape. Question number 597. Where the accused caught hold of a girl, grabbed her by force by the side of the bushes, threw her down on the ground, removed her undergarments, got over her and attempted to penetrate, but before he could succeed, the girl started bleeding. The accused was guilty of preparation of rape only. The accused was guilty of outraging the modesty of rape. The girl was guilty of attempted rape. The accused was guilty of insulting the modesty of the girl. Here the correct answer is option C, that is the accused was guilty of attempted rape. Question number 598. Which section will be attracted if a public servant commits rape on a woman in his custody? Option A, Section 376 subsection 2 clause A of IPC, Section 376 subsection 2 clause D, Section 376 subsection 2 clause G, Section 376 subsection 2 clause B. Correct answer is option D, that is Section 376 subsection 2 clause B. Question number 599. Which of the following section of IPC punishes for causing death or resulting in persistent vegetative state of victim during the commission of offence of rape? Options are Section 376B, Section 376B, Section 376D, Section 376A. Correct answer is option D, that is Section 376A. Question number 600. Which one of the following offence of IPC prescribes punishment up to death sentence in reference to the offence of rape? Options are Section 376D, Section 376C, Section 376B, Section 376A. Correct answer is Section 376A. Prescribes punishment up to death sentence in reference to the offence of rape. Question number 601. What punishment for custodial rape is provided? 7 years of rigorous imprisonment with fine, rigorous imprisonment for a term which shall not be less than 10 years but which may extend to imprisonment for life and shall also be liable to fine, 15 years of imprisonment, 20 years of imprisonment. Correct answer is option B, that is rigorous imprisonment for a term which shall not be less than 10 years but which may extend to imprisonment for life and shall also be liable to fine. Question number 602. A has sexual intercourse with his own wife who is living separately from him under a decree of separation without her consent. Which section of IPC covers the matter? Options are section 376, section 376A, section 376B, section 376C. Correct answer is option C, that is section 376B. Question number 603. Under which section of IPC gang rape is punishable? Options are section 376A, section 376B, section 376C, section 376D. Correct answer is option D, that is section 376D. In this, gang rape is punishable. Question number 604. For a gang rape, it is necessary that rape should be committed by more than one person. It is committed by more than two persons. It is committed that rape should be committed. It is necessary that rape should be committed by at least 5 persons. None of the above is correct. Correct answer is option A, that it is necessary that rape should be committed by more than one person. Question number 605. Where a woman is being gang raped, each of those persons shall be deemed to have committed the offence of rape and shall be punished with. Correct answer is option D, that is rigorous imprisonment of not less than 20 years. Question number 606. Match list 1 and list 2 and select the correct answer. 1. Voluntarily throwing or attempting to throw acid. Correct answer is imprisonment of not less than 5 years may extend to 7 years. Option B. Buying minor for purpose of prostitution, etc. Correct answer is imprisonment for a term which may extend to 10 years. Gang rape, rigorous imprisonment of not less than 20 years which may extend to fine. And robbery committed on the highway between sunset and sunrise. Here the correct answer will be imprisonment which may extend to 14 years. By going these matches, the correct answer is option A. Question number 607. Which of the following are correctly matched? Harbor, section 51A IPC, wrongful loss, section 23 IPC, gang rape on women under 12 years of age, section 376DB IPC, gang rape, section 376D IPC. In this question, correct answer is option C, that is 2, 3 and 4. These matches are correctly matched: wrongful loss, gang rape, and gang rape under 12 years of age, section 376DB, gang rape, section 376D IPC. Question number 608. Section 377 of IPC regarding unnatural offences was partially struck down by the Supreme Court in the case of, correct answer is Navtej Singh Johar versus Union of India. This is one of the landmark judgment in judicial history of India. Make sure you remember this answer. Question number 609. Which one of the following cases pertains to the constitutionality of section 377 of IPC? Correct answer is Navtej Singh Johar versus Union of India. Question number 610. Chapter 17 of IPC deals with what offence? Chapter 17 deals with the offences against property. Theft has been defined in. Theft has been defined under section 378 of IPC. The subject matter of theft is can be movable, can be immovable, both A and B, either A or B. The subject matter of theft will be movable property. Question number 613. Section 379 of IPC is. Section 379 of IPC provides punishment for the theft. Punishment for theft under IPC may be extended up to 3 years, 5 years, 2 years, none of the above. Correct answer is 3 years. Question number 615. Under which section of IPC committing theft of a computer from shop is punishable? Options are section 379, section 380, section 381, section 383. Correct answer is option B, that is section 380. Question number 616. Which one of the following is not correct? For theft of property must be movable. For theft, property must be removed out of the possession of the owner of property. For theft, property should have been removed from taking it away. For theft, property should be removed dishonestly. Here the correct answer is option B. For theft, property must be removed out of the possession of the owner of property is not necessary, because possession and ownership are two different things. There can be theft also if the person who is not the owner of the thing is holding. There is an illustration in the theft. if you are taking a watch from a person who is repairing your watch from him only and you have not paid money, and without knowing him you are taking your watch only, you will be the owner of the watch, but this will come under the category of theft. So the correct answer will be option B. Here it is in me asked, which is not correct. Question number 617. Which one is not essential element of theft? Options are movable property, possession of property, ownership of that property, removal of that property. Correct answer is option C, that is ownership of that property. This we have already discussed. Question number 618. Which one of the following is not correct in respect of the definition of theft? Options are removal of movable property of another out of ownership of that person without his consent with intent to take away the property. Correct answer is option B, that is out of the ownership of that person. Question number 619. Planning to commit a theft is a cognizable offence, no offence in itself, strict criminal liability, criminal ownership. Correct answer is option B, that is no offence in itself. Question number 620. Theft is an offence against a person, immovable property, movable property, both movable and immovable property. Correct answer is movable property. Question number 621. Dishonest intention must precede the act of committing robbery, criminal misappropriation, theft, criminal breach of trust. Correct answer is option C, that is theft. Question number 622. In order to constitute theft, what is not an ingredient in IPC? Dishonest intention, moving of the property, common intention, movable property. Correct answer is option C. Common intention is not the requisite for committing the theft. Question number 623. Which one of the following is not an essential element of theft? Dishonest intention, removal from possession, immovable property without consent. Correct answer is option 6. It is not about the immovable property. Theft will be of movable property. Question number 624. Which one of the following is not a characteristics of for an offence of theft? Dishonest intention to take property. The property must be movable. It should be taken out of the possession of another person. Movement of property is not necessary. Correct answer is option D. This is not the characteristics of theft. Question number 625. Which one of the following is not a correct ingredient for the offence of theft? Options are dishonest intention to take property. Property must be movable. Property must be taken without the consent of the person in whose possession it is. Property must be taken without consent of the owner of the property. Correct answer is option D. That is, property must be taken without the consent of the owner of the property. Theft is not about the ownership. It is about the possession. Question number 626. Which of the following acts constitute the commission of theft? Options are C finds a necklace in the bedroom of D and C retains that necklace. C finds the necklace of D on the road and keeps it. C buys necklace from E and subsequently learns that E had stolen it from D. C is given the necklace by D for safekeeping, but C wears the necklace and drops and loses it. Here the correct answer is option A. C finds a necklace in the bedroom of D and C and retains that necklace. It is theft. Question number 627. A meets a bullock carrying a box of treasure. He drives the bullock in a certain direction in order that he may dishonestly take the treasure. In this case, A commits criminal misappropriation of property. No offence until the treasure is being taken away. Theft as soon as the bullock begins to move. This is the correct answer, option C. Theft as soon as the bullock begins to move. Question number 628. A takes some ornaments belonging to B out of the possession without B's consent with the intention of keeping it until he obtains money from B as the reward for its restoration. A is guilty of criminal misappropriation, guilty of extortion, not guilty of theft of extortion, guilty of theft. Correct answer is option D, that is guilty of theft. Question number 629. A government servant removed a file from his colleague's office to his house, made it available to an outsider and then returned it back to the office. The same day in the evening, A is guilty of which of the following offence? Criminal misappropriation of property, theft, criminal breach of trust, none of the above. Correct answer is option B, that is theft. Question number 630. A makes an attempt to pick the pocket of B by thrusting his hands into B's pocket. A fails in the attempt in consequence of B's having nothing in the pocket. A is guilty of no offence, theft, attempt to theft using criminal force. Correct answer is attempt to theft. Question number 631. A cuts down 2 trees of his neighbor's field without his permission and takes away them without neighbor's knowledge. It is an extortion, it is a theft, it is a criminal trespass, it is a dishonest intention. Correct answer is option B, it is a theft. Question number 632. Y owed some money to X. X removed the bullock of Y grazing by the side of a stream and kept it tied in his own house. When Y asked him to release the bullocks, X told him that he would do so when the money was paid. X is guilty of criminal breach of trust, criminal misappropriation, extortion, theft. Correct answer is theft. Question number 633. A finds a ring belonging to Z on a table in the house which Y occupies. A dishonestly removes the ring. A has committed which of the following offense? Correct answer is theft. Question number 634. A removes B's book from his house without his consent with the intention to return it to him. If he as a friend rewards him for return, A is liable for theft, attempt to theft, criminal breach of trust, attempt to criminal breach of trust. Correct answer is option A, that is theft. Question number 635. A had consensual sexual relations with Z's wife. She gives to A a valuable property which A knows to belong to her husband. Z and she has no authority from Z to give. A takes the property dishonestly. Which of the following offences has been committed by A? Options are criminal breach of trust and criminal misappropriation, theft and criminal breach of trust, theft, criminal breach of trust. Correct answer is option C, that is theft. Question number 636. A and B, who are cadets in the Indian Air Force, take out from the Jodhpur aerodrome an aircraft without the authority of the commandant and fly it away to Pakistan. What offence has been committed by them? They have committed the offence of theft. Question number 637. A is invited by B for a cup of tea. While B is in the kitchen preparing tea, A finds a golden ring on the table. He picks it up and places it somewhere in the room with the intention of dishonestly taking it away sometime later. A commits theft. Question number 638. A handed over his watch to a watchsmith for repairing. In order to not pay the repairing charges, A picked up his watch from the shop when the watchsmith was not looking. In this case, A is guilty of criminal breach of trust, A is guilty of cheating, A is guilty of theft, A is not guilty of any offence because the watch he picked up was his own. However, he should pay the repairing charges to watchsmith. Correct answer is option C, that is A is guilty of theft, because theft is not about the ownership, it is about the person who is having the possession of a certain movable property. Question number 639. A, having pawned his gold locket to Z, takes it out of Z's possession without Z's consent, not having paid what he borrowed on the gold locket. A has committed offence under 379 of IPC. Question number 640. A commits theft of a property in B's possession, and while committing this theft, he has a loaded pistol under the garment kept up for the purpose of hurting B. In case B should resist, the offence committed by A is defined under which section of IPC? It is defined in under section 382 of IPC. A, in good faith, believing property to belonging to Z to be his own property, take the property out of B's possession. A is guilty of theft, criminal misappropriation of property, criminal breach of trust, no offence. Correct answer is option D, that is no offence, because it was in good faith. Question number 642. Extortion is defined in section 383, section 390, section 387, section 384. Correct answer is option A, that is section 383 of IPC. The offence of extortion cannot be committed against which of the following? Movable property, immovable property, valuable security, none. Correct answer is option D, none. Extortion can be committed against movable property, immovable property as well as valuable security. Question number 644. X telephonically threatens M to publish a defamatory statement unless he gives him rupees 20,000 to K. K has committed the offence of extortion. Question number 645. A, by putting B in fear of grievous hurt, dishonestly induced B to sign a blank paper and delivers it to A. B, after signing that paper, delivers it to A. A has committed the offence of extortion. Question number 646. X obtains property from Z by saying that your child is in the hands of my gang and will be put to death unless you send us 10 lakh rupees. X commits the offence of extortion. Question number 647. Inducing person with dishonest intention to part with his property by putting him in fear of physical injury amounts to an offence of, correct answer is extortion. Question number 648. A, by putting Z in fear of grievous hurt, dishonestly induces Z to sign or affix his seal on and delivers the paper to A. A has committed offence of extortion. Question number 649. A police officer obtains a sum of rupees 10,000 from B by putting him under the fear that he will immediately be put into prison and will not be released for months. The police officer will be guilty of extortion. Question number 650. When by putting any person in fear of injury, he is dishonestly induced by another to deliver property, it is extortion. Section 387 IPC relates to extortion by putting a person in fear of death, putting person in fear of death or of grievous hurt in order to commit extortion, extortion by threat of accusation of an offence punishable with death or imprisonment for life, etc. None of the above. Correct answer is option B, that is putting a person in fear of death or of grievous hurt in order to commit extortion. Question number 652. Which of the following charges cannot be compounded without the permission of the court before the prosecution is pending, before which the prosecution is pending? Options are section 298 of IPC, section 426 of IPC, section 491 of IPC, section 388 of IPC. Here correct answer is option D, that is section 388 of IPC. Question number 653. To constitute the crime of robbery, which of the following is necessary? Theft, extortion, cheating, either theft or extortion. Correct answer is option D, that is either theft or extortion. Question number 654. X meets Y in the way. Y points out a dangerous knife to X and demands his watch. X gives the watch to Y. What offence has been committed? Theft, extortion, robbery, assault. Here correct answer is robbery. Question number 655. A meets B on a national highway, shows him a pistol and demands B's purse. B in consequence surrenders his purse. Which of the following offences was committed by A? Here robbery is committed. Question number 656. A holds Z down and fraudulently takes Z's money and jewels from Z's clothes without Z's consent. A is guilty of committing theft, extortion, robbery, dacoity. Correct answer is option C, that is robbery. Question number 657. A meets B and his child in a jungle. A takes the child and threatens to kill him unless B delivers his purse. A has committed extortion, theft, robbery, dacoity. Correct answer is option C, that is robbery. Question number 658. A pulled an earring away from a woman's ear and thereby tore and wounded her ear. A is guilty of robbery. Question number 659. A contingent of police led by sub-inspector is on patrolling duty at night. They are attacked by two criminals in which one is constable is severely injured and criminals escaped with their property. Here a case can be made under IPC for the offence of theft, dacoity, robbery, mischief. Correct answer is option C, that is robbery. Question number 660. X, who stole jewellery from a jeweller's shop, caused fear of instant hurt to Z, who tried to stop him while carrying away the stolen watch. Here X can be held liable for the offence of extortion, robbery, dacoity, theft. Correct answer is option B, that is robbery. Question number 661. Minimum number of offenders for the commission of robbery under IPC must be 1 person, 2 person, 3 person, 5 person. Correct answer is option A, that is 1 person. Which one of the following statement is not correct? Options are: in every robbery there are at least 2 persons. In every robbery there is fear of violence. In every robbery there is either theft or extortion. In every dacoity there is robbery. Here it is asked which of the statement is not correct. Here statement A is not correct because even a single person can commit robbery, whereas the element of fear and violence of the robbery, either theft or extortion, or every dacoity is a robbery, is a correct statement. Therefore will not be the right answer. Statement A is right answer. Question number 663. Which offence does not require a minimum number of 5 persons? Question number 663. Which offence does not require a minimum number of 5 persons? A. Unlawful assembly, B. Riot, C. Robbery, D. Dacoity. Correct answer is option C, that is robbery. Question number 664. The offence of theft becomes robbery when it is coupled with force, committed by 2 or more persons but less than 5 persons, committed by 5 or more persons, coupled with imminent danger to life. Correct answer is option A, that is coupled with force. Question number 665. Under which section of IPC attempt to commit robbery is punishable? A. Section 392, B. Section 393, C. Section 395, D. Section 396. Correct answer is option B, that is section 393. Question number 666. Which of the following statement is false? Option A. Theft is robbery if in order to committing the theft or in committing theft or in carrying away or attempting to carry away property obtained by the theft, the offender for that end voluntarily causes or attempts to cause to any person death or hurt or wrongful restraint or fear of instant death or of instant hurt or of instant wrongful restraint. Option B. Extortion is robbery if the offender at the time of committing the extortion is in the presence of the person put in fear, commits the extortion by putting the person in fear of instant death, of instant hurt, or of instant wrongful restraint to that person or to some other person, and by so putting in fear induces the person, so put in fear then and there is to deliver up the thing extorted. Option C. Property the possession whereof has been transferred by theft or by extortion or by robbery, any property which has been criminally misappropriated or in respect of which criminal breach of trust has been committed, designated as stolen property. D. None of these. In question number 666, correct answer is option D, that is none of these. Question number 667. Which one of the following factor distinguishes robbery from dacoity? Option A. Time span, property, number of offenders, place of offence. Correct answer is option C, that is number of offenders. Which section of IPC has defined dacoity? Options are section 390, section 391, section 395, section 393. Correct answer is option B, that is section 391. Question number 669. X and his 4 associates attempted to commit theft at a place of Y and caused hurt to Y. They were forced to retreat without collecting the booty because of stiff resistance by the inmates. They are guilty of theft, robbery, criminal misappropriation, dacoity. Correct answer is option D, that is dacoity. Question number 670. Robbery is dacoity if committed conjointly by more than 2 persons but less than 5 persons, 5 or more than 5 persons, at least 7 persons, at least 10 persons. Correct answer is option B, that is 5 or more than 5 persons. Question number 671. What is the minimum imprisonment prescribed for the use of deadly weapons in dacoity under IPC? Options are 10 years, 7 years, 5 years, 14 years. Correct answer is option B, that is 7 years. Question number 672. Making preparation to commit dacoity is punishable under IPC under section 393, section 395, section 398, section 399. Correct answer is option D, that is section 399. Question number 673. Preparation to commit dacoity is a punishable offence, not punishable offence, no offence, none of the above. Correct answer is option A, that is punishable offence. Question number 674. Match list 1 and list 2. List 1 contains of elements of offence, whereas list 2 is types of offence. Option A. Movable property obtained without consent. It will be theft. Movable property obtained without consent by instant violence. It is robbery. Movable property obtained without consent induced by fear. It is extortion. Movable property obtained by using violence of gang of 6 persons. This is dacoity. Question number 675. The law relating to criminal misappropriation of property is given under section 403, section 404, section 407, section 411 IPC. Correct answer is option A, that is section 403 of IPC. Criminal misappropriation of property is provided. Question number 676. Misappropriation of property has been defined under dash of IPC. Correct answer is option A, that is section 403 of IPC. Question number 677. In case of criminal misappropriation, the subsequent intention must be fraudulent, dishonest, innocent, illegal. Correct answer is option B, that is dishonest. Question number 678. A finds a government promissory note belonging to Z bearing a blank endorsement. A, knowing that the note belongs to Z, pledges it with a banker as a security for a loan, intending at a future time to restore it to Z. A has committed the offence of cheating, criminal breach of trust, criminal misappropriation of property, mischief. Correct answer is option C, that is criminal misappropriation of property. Question number 679. A and B being joint owners of an elephant, A takes the elephant out of B's possession intending to use it. A then sells the elephant and appropriates the whole proceeds to his own use. What offence has A committed? Cheating, theft, criminal breach of trust, dishonest misappropriation. Correct answer is option D, that is dishonest misappropriation. Question number 680. A finds a valuable diamond not knowing to whom it belongs. A sells it immediately without attempting to discover the owner. A is guilty of theft as it is causing wrongful gain to him, guilty of criminal breach of trust, guilty of extortion, guilty of criminal misappropriation of property. Correct answer is option D, that is guilty of criminal misappropriation of property. Question number 681. A finds a purse with money not knowing to whom it belongs. He afterwards discovers that it belongs to B and appropriates to his own use. A is guilty of theft, criminal misappropriation, criminal breach of trust, cheating. Correct answer is option B, that is criminal misappropriation. Question number 682. A finds a rupee on the highway not knowing to whom the rupee belongs. A picks up the rupee. A has committed the offence of dishonest misappropriation of property, theft, dishonestly receiving stolen property, none of the above. Correct answer is option D, that is none of the above. Question number 683. A's wallet falls out of his pocket unknown to him. His friend B, who sees this, picks up the same. On finding that the wallet contains rupees 2000, B uses the money for his own purpose. After 6 hours, B puts rupees 2000 back in the wallet and returns the same to A. B is guilty of no offense, theft, as B has caused wrongful loss to A for 6 hours. Criminal misappropriation of property, cheating, as he deceived A. Correct answer is option C, that is criminal misappropriation of property. Question number 684. A finds a watch on the floor of a state transport bus while he was leaving it as the last passenger. He picked it up and put it in his pocket instead of returning it to the state transport authorities. Next day, he sold it. A is liable for theft, extortion, criminal misappropriation, criminal breach of trust. Correct answer is option C, that is criminal misappropriation. Question number 685. A poor student finds a letter on the road containing a banknote. From the content and direction of letter, he learns from whom the note belongs. A uses that note for buying some books. A has committed the offense of dishonest misappropriation of property, the offense of theft, no offense, the offense of criminal breach of trust. Correct answer is option A, that is the offense of dishonest misappropriation of property. Question number 686. Dishonest misappropriation of property possessed by deceased person at the time of his death is an offense punishable under IPC in Section 404, Section 406, Section 407, Section 409. Correct answer is option A, that is Section 404. Question number 687. Z dies in possession of a furniture and money. His servant A, before the money comes into the possession of any such person who is entitled to, dishonestly misappropriates it. A has committed offence under which of the following sections of IPC? Section 403, Section 404, Section 405, Section 406. Correct answer is option B, that is Section 404 of IPC. Question number 688. According to IPC, taking property dishonestly from the dead body does not amount to offence, amount to the offence of theft, amount to the offence of criminal misappropriation, amount to the offence of criminal breach of trust. Correct answer is option C, that is amount to the offence of criminal misappropriation. Question number 689. Unlawful removal of ornaments from the body of a deceased person amounts to criminal breach of trust, extortion, cheating, criminal misappropriation. Correct answer is option D, that is criminal misappropriation. Question number 690. Removal of ornaments from the body of one after causing his death constitutes an offence under Section 392 of IPC, 379, 420 of IPC, 404 of the IPC. Correct answer is option D, that is Section 404 of the Indian Penal Code. Question number 691. The offence of criminal breach of trust is described in Section 405 of IPC. Question number 692. Criminal breach of trust is related to movable property only, immovable property only, both movable and immovable properties, none of the above. Correct answer is option C, that is both movable and immovable properties. Question number 693. Criminal breach of trust is an offence signifying entrustment, demand, refusion, all of the above. Correct answer is option A, that is entrustment. Question number 694. In an offence of criminal breach of trust, what is necessarily involved? Registered society, registered trust, registered or unregistered trust property. Correct answer is option D, that is property. Question number 695. If a person entrusted with the property dishonestly converts to his own use, he commits fraud, cheating, criminal misappropriation, criminal breach of trust. Correct answer is option D, that is criminal breach of trust. Question number 696. An offence against property may be wrongful confinement, criminal breach of trust, defamation, public nuisance. Correct answer is option B, that is criminal breach of trust. Question number 697. A, who was entrusted by B with certain blocks for printing a catalog, prints catalog of rivals firm with the same block. A is guilty of criminal breach of trust. Question number 698. Which of the following case is related to criminal breach of trust under Section 406 of IPC? Barendra Kumar Ghosh versus Emperor, J.M. Desai versus State of Bombay, Mehboob Shah versus Emperor, Kedar Nath versus State of West Bengal. Here the correct answer is option B, that is J.M. Desai versus State of Bombay. Question number 699. A sends a mobile phone to his friend through his servant B. The servant took the phone at his house and used it over a period of time. B is the guilty of the offence of theft, criminal misappropriation of property, criminal breach of trust, cheating. Correct answer is option C, that is criminal breach of trust. Question number 700. Z, going on a journey, entrusts his golden plate to A till Z shall return. A carries the plate to market and sells it. What crime was committed by A? A has committed a crime of criminal breach of trust. Question number 701. A carrier is entrusted by Z with property to be carried by water. A dishonestly misappropriates the property. A has committed which one of the following? Criminal breach of trust, criminal misappropriation of property, habitually dealing in stolen property, or cheating. Correct answer is option A, that is criminal breach of trust. Question number 702. A is a warehouse keeper. B is going on a journey, entrusts his household goods to A under a contract that they shall be returned on payment of a stipulated sum for warehouse room. A dishonestly sells the goods. A will be guilty of committing criminal breach of trust. Question number 703. A residing in Calcutta is an agent for Z residing at Delhi. There is an express or implied contract between A and Z that all sums remitted by Z to A shall be invested by A according to Z's direction. Z remits a lakh of rupees to A with the directions to A to invest the same in the company's paper. A, in good faith believing that it will be made more for Z's advantage to hold shares in the Bank of Bengal, disobeys Z's direction and buys shares in the Bank of Bengal. For Z, instead of buying company's paper, Z suffers loss. A is liable for, options are cheating, criminal breach of trust, criminal misappropriation, no offence is committed. Correct answer is option D, that is no offence is committed. Question number 704. A, being executed to the will of a deceased person, dishonestly disobeys the law which directs him to divide the effects according to the will and appropriates them to his own use. Which offence A has committed? Theft, criminal misappropriation, criminal breach of trust, cheating. Correct answer is option C, that is criminal breach of trust. Question number 705. A lady wishing to get a railway ticket, finding a crowd at a ticket window at station, asked B, who was near window, to get a ticket for her and handed him over a money for same. B took money and instead of getting ticket ran away with money. What offence has been committed by B? Offence of theft, offence of criminal misappropriation, offence of criminal breach of trust, offence of cheating. Correct answer is option C, that is offence of criminal breach of trust. Question number 706. X, a rich person residing at Kochi, sends rupees 50,000 to his agent at Chennai with a direction that the money be equally to two poor students A and B who are studying in the engineering college over there. Instead of doing so, the agent gives the money equally to two other very poor deserving students. The agent has committed criminal breach of trust, no offense, cheating, criminal misappropriation. Agent has committed criminal breach of trust. Question number 707. X is an agent for Y. There is a contract between X and Y that all sums remitted by Y to X shall be invested by X according to Y's direction. Y remits rupees 10 lakh to X with a direction to X to invest the same in infrastructure bonds. X dishonestly disobeys the direction and puts the money in his own business to generate more profit. X committed no offense, criminal misappropriation, criminal breach of trust, extortion. Correct answer is option C, that is criminal breach of trust. Question number 708. X, an employer, deducts a certain percentage from the salary of his employees, telling that it is their contribution to the provident fund, but fails to credit it in the fund. X commits criminal breach of trust, criminal misappropriation, theft, cheating. Correct answer is option A, that is criminal breach of trust. Question number 709. A partner collecting money on behalf of the firm and directed to use money for purpose of firm does not deposit the money in the bank account of the firm. He is liable for criminal breach of trust, civil breach of trust, either A or B, D both, A or B. Correct answer is option A, that is criminal breach of trust. Question number 710. Can a person commit a breach of trust for his own property? Yes, no. It will depend upon the facts of the case. It will depend upon the discretion of the court. Correct answer is yes. Question number 711. The accused was entrusted with some silver for the purpose of making ornaments and he dishonestly mixed copper into ornaments. The offence committed is fraud, cheating, extortion, criminal breach of trust. Here the correct answer is option D, that is criminal breach of trust. Question number 712. Match list first with list second and select the correct answer for using the codes given below. Delivery of property. Here the correct match is extortion. And taking of property. Taking of property is theft. Entrustment of property. Entrustment of property is criminal breach of trust. And convertibility of property got innocently to one's own use is criminal misappropriation of property. Once again, I will repeat. Delivery of property, extortion. Taking of property, theft. Entrustment of property, criminal breach of trust. Convertibility of property got innocently to one's own use is criminal misappropriation of property. Therefore, the correct answer will be here option A. Question number 713. Stolen property as per section 410 of IPC includes property the possession whereof has been transferred by theft, extortion or robbery, property which has been criminally misappropriated, property in respect of which criminal breach of trust has been committed, all of these. Here the correct answer is option D, that is all of. Question number 740. In an offence under section 410 and 412 of the IPC, the actus reus is in respect of place, time, person, possession of stolen property. Correct answer is option D, that is possession of stolen property. Question number 715. Which is not the stolen property? Possession whereof was obtained by cheating, possession whereof was obtained by robbery, possession whereof was obtained by dacoity, possession whereof was obtained by criminal breach of trust. Here it has been asked which of the following is not the stolen property. The correct answer is option A, possession whereof was obtained by cheating. Question number 716. Dishonestly includes any person in delivering property is criminal breach of trust, cheating, misappropriation, extortion. Correct answer is option B, that is cheating. Question number 717. Deception is an essential element of the following: criminal breach of trust, forgery, cheating, all of the above. Here the correct answer is option C, that is cheating. Question number 718. For the offence of cheating, the person deceived must have been fraudulently or dishonestly induced to deliver property. As a consequence of the intentional inducement, damage or harm in the body, mind, reputation or property is caused or likely to be caused to the person deceived. Here the options are both 1 and 2 are correct and none of the above is correct. Correct answer for 718 question number is option C, that is both 1 and 2 are correct. Question number 719. For an offence of cheating, intention to cheat should be present in the end, in the middle, both the above from the very beginning. Correct answer is option D, that is from the very beginning. Question number 720. The point of difference between extortion and cheating lies in mens rea, way of obtaining consent, both A and B, none of the above. Correct answer is option B, that is way of obtaining consent. Question number 721. A intentionally deceives Z into a belief that A has performed A's part of a contract made with Z, which he has not performed, and thereby dishonestly induces Z to pay money. A has committed the offence of criminal breach of trust under section 405 of IPC, the offence of criminal breach of trust by public servant or by banker, merchant or agent under section 409 of IPC, the offence of dishonest misappropriation of property under section 403 of IPC, or D, the offence of cheating under section 415 of IPC. Correct answer is option D, that is for the offence of cheating under section 415 of IPC. Question number 722. To sit at an examination falsely personating another and signing papers in that other's name amounts to cheating as well as forgery. Forgery only, cheating, cheating by personation as well as forgery. Correct answer is option D, that is cheating by personation as well as forgery. Question number 723. A is not a servant in the income tax department, but showing himself as income tax officer, putting raid into B's business center and gets valuable articles. Thus A commits cheating, cheating by personation, robbery, fraud. A commits cheating by personation. Question number 724. Which of the following sections of IPC relates with punishment for cheating? Options are section 415, section 417, section 416, none of the above. Correct answer is option B, that is section 417. Question 725. A cheats by pretending to be B, a person who's deceased. A is liable to be punished under 420 of IPC, 419 of IPC, 418 of IPC, 417 of IPC. Correct answer is option B, that is section 419 of IPC. Question number 726. When a person with intent to cause damage to other persons cause destruction of property is said to have committed a mischief, rioting, robbery, nuisance. Correct answer is option A, that is mischief. Question number 727. Essential ingredients for the offence of mischief is intention to cause destruction of a property, intention to change the nature of a property, intentionally causing wrongful loss or damage to the property of another by destroying or diminishing its value. Correct answer is option C. Question number 728. A gave B a pen drive which he knows has files that was infected with a virus. A did not inform B of the same. B inserted a pen drive into his computer and opened the files. His computer was infected by the virus and most of the files on it were lost. Which of the following offense A will be held guilty of? A will be guilty of option C, that is mischief. Question number 729. Which one of the following section of IPC relates to the punishment for mischief? Section 426. Question number 730. A having a joint property with Z in a house intending thereby to cause wrongful loss to Z shoots the horse. Under what sections of IPC A shall be charged with? A shall be charged with under section 429 of IPC. Question number 731. A having insured a ship voluntarily causes the same to be cast away with the intention to causing damage to the underwriters. A has committed the offence of criminal breach of trust under section 405 of IPC, cheating under section 415 of IPC, criminal misappropriation of property under section 403 of IPC, mischief under section 425 of IPC. Correct answer is option D, that is mischief under section 425 of IPC. Question number 732. A voluntarily throws into a river a ring belonging to Z with the intention thereby causing wrongful loss to Z. It will be theft, mischief, extortion, cheating. Correct answer is option B, that is mischief. Question number 733. A causes cattle to enter upon the field belonging to Z intending to cause damage to Z's crops. A committed the offence of cheating, mischief, dishonest misappropriation of property, none of these. Correct answer is option B, that is mischief. Question number 734. Criminal trespass has been defined in which section of IPC? It is defined in section 441 of IPC. Question number 735. B enters into house of A without obtaining A's permission to congratulate him on his success. What crime was committed by B? Criminal trespass, house trespass, mischief, none of these. Correct answer is option D, that is none of. Question number 736. X with a view to murder Y enters Y's bedroom at night. When Y is out of station, X will be guilty of house trespass. Question number 737. The offence of criminal trespass is complete when a person enters upon the property in the possession of another with intent to commit a bailable offence, any offence, non-bailable offence, a cognizable offence. Correct answer is any offence. Question number 738. In which of the following section of IPC lurking house trespass has been defined? It is defined in section 443. Question number 739. Trespass being made in surreptitious manner, concealment, is called house trespass, house breaking, lurking house trespass, none of the above. Correct answer is option C, that is lurking house trespass. Question number 740. A finds the key of Y's house door which Y had lost and commits house trespass by entering Y's house having opened the door with the key. What offence A has committed? A has committed the offence of house breaking. Question number 741. X, the doorkeeper of Y, is standing Y's doorway. A commits house trespass by entering the house having deterred Z from opposing him by threatening to beat him. A has committed A, house trespass, B, criminal trespass, C, lurking house trespass, D, house breaking. Correct answer is option D, that is house breaking. Question number 742. A enters Z house through a window. A commits trespass, house breaking, all of the above. Correct answer is option C, that is house breaking. Question number 743. A commits house trespass by making a hole through a wall of Z's house and putting his hands and through the aperture, for which offence A is liable. A is liable for house breaking. Question number 744. Ram, while going on pilgrimage, entrusted a box containing jewelry to his neighbor Shyam. Shyam, dishonestly with intent to commit mischief, breaks open the box without having any authority. Shyam has committed the offence of section 406 of IPC, section 379 of IPC, section 462 of IPC, none of the above. Correct answer is option C, that is section 462 of IPC. Question number 745. Delivery of property. Correct answer is extortion. Taking of property. Correct answer is theft. Entrustment of property. Correct answer is criminal breach of trust. And convertibility property to God's one's own use is criminal misappropriation of property. By going through these matches, the correct match will be for question number 745 is option B. Question number 746. Which of the following is not a correct match? Offense in section of IPC. Extortion, section 383 of IPC. It is a correct match. Dacoity, section 391 of IPC. It is also a correct match. Robbery, section 389 of IPC. This is not the correct match, so option C is the right answer. 747. By which act of 2000 some section relating to forgery under IPC were amended? Options are Information Technology Act, CRPC, Trademark Act, Indian Evidence Act. Correct answer here is option A, that is Information Technology Act. Question number 748. The offence of forgery is committed as regards to government currency notes, GC notes and documents or electronic records, artistic work. Correct answer here is option C, that is documents or electronic record. Question number 749. Which of the following provisions of IPC defines making a false document? Options are Section 464, Section 465, Section 466, Section 467. Correct answer is option A, that is Section 464. Question number 750. The punishment for the offence of forgery of a will is prescribed under Section 463 of IPC, 468 of IPC, 467 of IPC, 471 of IPC. Correct answer is Section 467 of IPC. Question number 751. A prepares a mark sheet with an intention to use it as original to secure a job. Under IPC, he is said to have committed the offence of forgery. Question number 752. A, having lost the receipt for debt which he has paid to B, makes out another receipt for himself, and when B sues him, he puts up the made up receipt in evidence. In this case, A is guilty of the offence of forgery, A is guilty of no offence, A is guilty of cheating. None of the above answer is correct. Here the correct answer is option A, that is A is guilty for the offence of forgery. Question number 753. A signs his own name to a bill of exchange, intending that it may be believed that the bill was drawn on another person's on the same name. A has committed the offence of forgery, forging for the purpose of cheating, cheating by personation, attempt to commit forgery. Correct answer is option A, that is forgery. Question number 754. In his will, Mr. Y wrote, I intend my property to be equally divided between my three children, A, S and H. A dishonestly scratched out the name of H, intending that it may be believed that the whole of the property may be left to be divided between H and himself alone. A is guilty of, obviously A will be guilty of for the offence of forgery. Question number 755. Which section of IPC is related with property mark? Options are Section 478, Section 476, Section 479, Section 480. Correct answer is option C, that is Section 479. Question number 756. Section 489A of IPC is related to property mark, falsification of accounts, counterfeiting currency notes or banknotes, counterfeiting a mark used by public servant. Here the correct answer is option C, that is counterfeiting currency notes or banknotes. Question number 757. Which one of the following section of IPC relates to punishment for counterfeiting currency notes or banknotes? Here the correct answer is option A, that is Section 489A. Question number 758. Possession of forged or counterfeit currency notes or banks is punishable under Section 489C. Under which section of IPC it is omission and not an act which is an offence? Options are Section 491, Section 296, Section 468, Section 508. Correct answer is option A, that is Section 491. Question number 760. A man by deceit caused a woman not lawfully married to him to believe that she is lawfully married to him and to cohabit with him in that behalf, is dealt under Section dash of IPC. Correct answer is option D, that is Section 493 of IPC. Question number 761. Who may complain for bigamy under Section 494 IPC? Options are mother, father, brother or sister on behalf of wife. This is the correct answer. Question number 762. Sarla Mudgal, President Kalyani versus Union of India is a case on the following. Options are rape, adultery, bigamy, kidnapping. Correct answer is option C, bigamy. This is very important landmark judgment. Question number 763. In which of the following offence mens rea is not an essential ingredient? Mens rea will not be an essential ingredient in the offence of bigamy. Question number 764. In Joseph Sign versus Union of India, declared that section IPC ultra vires. Section 494, section 495, section 498, section 497. Correct answer is option D, that is section 497. In which of the following cases Supreme Court has remarked that husband is not the master of his wife? Here the correct answer is option A, that is Joseph Sign versus Union of India. Question number 766. A Hindu husband converting to Islam and marrying again will be guilty of bigamy. It was held in which of the following case? It was held in Sarla Mudgil versus Union of India. Question number 767. Chapter 20A of IPC is related to which of the following? Offence relating to marriage, cruelty by husband or relatives of husband, criminal breach of contract of service, defamation. Correct answer is option B, that is cruelty by husband or relatives of husband. Question number 768. Cruelty to a woman by husband or relative of husband is defined under? It is defined in section 498 of IPC. Question number 769. Section 498A of IPC came into force on? Correct answer is 25th December 1983. Question number 770. Which section of IPC defines cruelty? Cruelty is defined in section 498A of IPC. Question number 771. Which of the following is not correctly matched? Navtej Singh Johar versus Union of India, section 498A of IPC. This is not correctly matched. So therefore this option A will be the right answer. Question number 772. The provision of section 498A of IPC which punishes the husband or any of his relative for harassing the married woman for dowry were introduced in IPC by? Option A, Act 46 of 1983. Question number 773. The offence of cruelty in section 498A of IPC punishes subjecting a woman to cruelty by the husband or relative of the husband of a woman, any person known to the woman, any person, all of these. Correct answer is option A, that is to the husband or relative of the husband of a woman. Question number 774. Which one of the following cases pertains to misuse of section 498 of IPC? Naresh Kumar versus State of Himachal Pradesh, Preeti Gupta versus State of Jharkhand, Rajendra Paswan versus State of Jharkhand and others, A versus State of Bihar. Correct answer is option B, that is Preeti Gupta versus State of Jharkhand. This is related to the misuse of section 498A of IPC. Question number 775. Cruelty under section 498A includes willful conduct likely to drive the woman to commit suicide, willful conduct likely to cause grave injury or danger to life, limb or health, harassment with a view to coerce her to meet any unlawful demand of dowry, all of the above. Here the correct answer is option D, that is all of the above. Question number 775. Cruelty under section 498A includes willful conduct likely to drive the woman to commit suicide, willful conduct likely to cause injury or danger to life, limb or health, harassment with a view to coerce her to meet any unlawful demand of dowry, all of the above. Here the correct answer is option D, that is all of the above. Question number 776. The punishment for the harassment of the woman by her husband or any of his relative with a view to coercing her or any person related to her for dowry is imprisonment for a term which may extend up to 3 years. Question number 777. In which of the following cases Supreme Court held that legal and valid marriage is not a necessary ingredient to attract section 498A of IPC? Correct answer is Reema Agarwal versus Anupam and others. Question number 778. Cognizance of an offence under section 498A of IPC can be taken by a court on a police report, on the complaint of the person aggrieved, on the complaint of father, mother of the person aggrieved, all of the above. Correct answer is all of the above. Question number 779. A and B have married for 10 years. A, the husband constantly physically abused his wife B. The injuries were such that she needed medical treatment. On March 18, 2018, A inflicted an injury on B's hand, which led to it being fractured. In this context, which of the following statement is accurate? Section 498A of IPC can be invoked against A. Section 498A of IPC will not apply in this case since there was no demand for dowry. Section 498A of IPC will not apply since there is an offence under Protection of Violence from Domestic Violence Act. This is not a crime, it is a ground for divorce under the relevant personal law. Here the correct answer is option A. Section 498A of IPC can be invoked against A. Question number 780. Offense of defamation relates to harming the reputation of a person. Defamation is an immoral act, unethical behavior by media, corrupt and indecent behavior in public, civil wrong and criminal offense. Correct answer is option D, that is civil wrong and criminal offense. Question number 782. Defamation can be only of a living person, of a living as well as deceased person, of an individual, a company, association or collection of the persons, both B and C. Correct answer is option D, that is both B and C. What is not defamation? Publication of any imputation, imputation to a deceased person, imputation to a company, opinion regarding public conduct of a public servant. Correct answer is option D, that is opinion regarding public conduct of a public servant is not defamation. Question number 784. How many exceptions have been provided for the offense of defamation under section 499 of IPC? Correct answer is option B, that is 10. Question number 785. Which of the following statement is false with respect to the offense of defamation under section 499 of IPC? It is not defamation to impute anything which is true concerning any person, if it be for the public good that the imputation should be made or published. Whether or not it is for the public good is a question of fact. It is a defamation to express in good faith any opinion whatever respecting the conduct of a public servant in the discharge of his public functions or respecting his character, so far as his character appears in that conduct and no further. This statement is not correct, so it is false. Therefore, in question number 785, option B is right. Question number 786. On account of an agitation, the lawyers ceased to participate in court proceedings and resorted to satyagraha. An editorial in a newspaper criticized as to whether it behoves to the lawyers as a class to resort to strike. The lawyers were inter alia described as Kajia Dalal, that is dispute broker, in the editorial. Options are: editor of the newspaper is guilty of the offense of defamation. Editor of the newspaper is not guilty of the offense of defamation. Option C, not only editor but chairman of board of director and its general manager are also guilty of defamation. And option D, none of the above. Here the correct answer is option B, that is editor of the newspaper is not guilty of the offense of defamation. Question number 787. A in good faith says of a book published by Z that Z books is indecent. Z must be a man of impure mind. In this defamation punishable under section 500 IPC? No, because it falls within one of the exceptions of section 499 of IPC. Therefore, it will not be a defamation. Question number 788. A magistrate is making report to a superior officer about B's character imputation made in good faith and public good. A commits offence under section 500 IPC, offence under section 501 IPC, no offence as it is within the exception under section 499 under section 504 IPC. Here correct answer is option C, that is no offence as it is within the exception under section 499. Question number 789. Which one of the following statement is not defamatory? A says about a woman, B, that she has paramour wherever she goes. A publishes a photograph with a false caption Gunda. A says, I am not surprised that B's book is foolish for he is libertine. Option D, A in the course of a police investigation says B may be involved in the murder of D because both of them were bitter enemies. Here it has been asked which of the following is not defamatory. Therefore, correct answer is option D. Question number 790. Cognizance of offence of defamation under chapter 21 of IPC can be taken on a police report on a complaint made by an aggrieved person, suo motu, all of the above. Correct answer is option B, that is on a complaint made by an aggrieved person. Question number 791. The following are exceptions to defamation: imputation of truth for public good, public conduct of public servants, literary criticism. Correct answer is option D, that is all of the above. Question number 792. An imputation in the form of alternative or expressed ironically may amount to defamation, not amount to defamation, amount to outrage the modesty if intended to a woman, neither defamation nor outrage the modesty. Correct answer is option A, that is amount to defamation. Question number 793. A shopkeeper to protect his own money says to B who manages his business, sell nothing to Z unless he pays you ready money, for I have no good opinion of his honesty. A is not liable for defamation. Question number 794. Which of the following is defamation? X says Y is an honest man, he never stole Z's watch, intending to cause it to be believed that Y did steal Z's watch. X is asked who stole Z watch, X points to Y. X draws a picture of Y running away with Z's watch. All of the above. Here the correct answer is option D. All of the above statements are defamation. Question number 795. In answer to the charge of defamation, which of the following are good defenses? Imputation which is true and published for the public good. Opinion respecting the conduct of a public servant concerning discharge of duties of office expressed in good faith. Both A and B, none of these. Here the correct answer is option C, that is both A and B. Now question number 796. A says Z is an honest man. He never stole B's watch, intending to cause to be believed that Z did steal B's watch. A will be liable for defamation. Question number 797. In which one of the following cases section 499 and section 500 of IPC have been recently declared constitutional by the Supreme Court? Option A, Subramaniam Swamy versus Union of India is the right answer. Question number 798. Under IPC, which of the following amounts to defamation? To convey a caution intended for good of person to whom conveyed for public good. To make an imputation concerning a company or an association or collection of persons as such. Censure passed in good faith by person having lawful authority over others. Publication of reports of proceedings of court. Here the correct answer is option B, that is to make an imputation concerning a company or association or collection of persons as such. Question number 799. An offence of criminal intimidation involves assault, affray, battery, threat. Correct answer is option D. Offence of criminal intimidation involves threat. Question number 800. A places men with firearms at the outlets of a building and tells Z that they will fire at Z if Z attempts to leave the building. What offence A has committed? A has committed the offence of wrongful confinement as well as criminal intimidation. Therefore, option D, that is 1 and 3 both are correct, will be the right answer. Question number 801. Intentional insult with intent to provoke breach of peace is punishable under section 504 IPC. Question number 802. A, for the purpose of inducing B to desist from prosecuting a civil suit, threatens to burn B's house. What offence was committed by A is guilty of? Abetment, criminal assault, criminal force, criminal intimidation. Correct answer is criminal intimidation. Question number 803. False statement, rumor, etc. circulated with intent to cause mutiny or offence against public peace is dealt under section 505 of IPC. Correct answer. Question number 804. Which one of the following provisions of IPC punishes to misconduct in public by a drunken person? Correct answer is section 510 IPC. The minimum duration of imprisonment provided for an offence under IPC is 24 hours under section 511. Yes, this 24 hours under section 510. Sentence of 20 hours under section 510. Sentence of imprisonment till rising of the court under section 511. Here the correct answer is 24 hours under section 510. This is the minimum duration of imprisonment provided under IPC under section 510. Question number 806. For which of the offence last section of IPC makes provision for punishment? Abetment to commit an offence, attempt to commit an offence, planning to commit an offence, preparation to commit an offence. Correct answer is option B, that is attempt. In section 511 of IPC, attempt to commit an offence is provided. Question number 807. Which one of the following is an inchoate offence? Options are public nuisance, criminal attempt, unlawful assembly, riot. Correct answer is option B, that is criminal attempt. Inchoate offences are incomplete offences. Question number 808. Doctrine of locus potentia is a doctrine invoked in cases of obscenity, rape leading to offer of marriage, attempt, exploitation of theory of punishment. Correct answer is option C, that is attempt. Question number 809. The punishment for attempting to commit offence punishable with imprisonment for life or other imprisonment is provided under section 511, under section 509, section 510, section 507. Correct answer is option A, that is section 511 IPC. Question number 810. The section 511 IPC is not applicable to attempt to commit suicide, attempt to commit rape, attempt to theft. Here the correct answer is option A, that is attempt to commit suicide. Question number 811. Section 511 IPC does not apply in cases of attempt of theft, affray, riot, murder. Correct answer is D, murder. Question number 812. Which one of the following statement is not correct with regard to the nature of criminal attempt? Options are: criminal attempt is the direct movement towards the commission of the offence after the preparations are made. Criminal attempt is an intentional preparatory action which fails in its object, an act which is done intentionally in attempting the commission of an offence. And option D, when commission of an act done intentionally is successful, it is criminal attempt. Correct answer is option D, that is, when commission of an act done intentionally is successful, it is criminal attempt. Question number 813. Preparation and attempt are two stages of commission of crime. Preparation is not punishable generally, but attempt is. One basic reason as to why preparation is not punishable is that there is no nexus between preparation and attempt. Can be chances of change of mind before commission offence. Is absence of intention, is absence of attempt. Correct answer is option B, that is, can be chances of change of mind before commission of offence. Question number 814. Under IPC, preparation to do a criminal act is an offence, not an offence only in respect of certain criminal acts, none of the above. Correct answer is option C, that is, an offence only in respect of certain criminal acts. Question number 815. In which of the following section of IPC preparation is punishable? Options are section 121, 125, 398, 122, 125, 399, 122, 126, 399, 121, 126, 398. Correct answer is option C, that is section 122 of IPC, 126 of IPC and 399 of IPC. Attempt to commit an offence is punishable with. Options are half, 1/4, 1/3, full. Correct answer is half. Question number 817. Section 511 of IPC applies to offences punishable under the IPC, any special law, any local law, all of the above. Correct answer is option A, that is IPC. Question number 818. Section 511 of IPC does not apply in case of attempt of rioting, attempt of theft, attempt of waging war against the government of India, attempt of affray. Correct answer is option C, that is attempt of waging war against the government of India. Question number 819. Which one is not a theory of attempt for section 511 of IPC? Options are proximity rule, theory of impossibility, object theory, Durham theory. Correct answer is option D, that is Durham rule. Question number 820. X applied for the post of lecturer in Delhi University and submitted his application along with degree of PhD. Interview call was issued to X on 2nd February 1992. Was the date fixed for the interview of X? But on 10th January 1992, the university came to know the copy of degree attached with the application was bogus and cancelled the interview. Here, X is guilty of cheating, X is guilty of attempt to cheat, X is not guilty of cheating not because the university has not been cheated, none of the above. Here, correct answer is option B, that is X is guilty of attempt to cheat. Question number 821. A woman ran to a well stating she would jump in it, but she was caught before she could reach it. She is guilty of attempt to suicide, attempt to injure herself, attempt to culpable homicide, no offence. Correct answer is option D, that is no offence. Question number 822. A see B drowning but does not save him. B is drowned. A committed. Here A committed, no offence. Question number 823. A intending to commit theft enters the house of B at night and removes from one of the rooms a box to the country yard where he opens it. He does not find in the box anything worth taking and leaving the box there goes away. In this case, A will be liable for the house trespass and attempt to commit theft. Question number 824. A makes an attempt to pick the pocket of B by thrusting his hand into B's pocket. A falls in the attempt in consequence of B's having nothing in his pocket. A is guilty of attempt to theft. Question number 825. A makes an attempt to steal some jewels by breaking open a box and finds after so opening the box that there is no jewel in it. He has committed the offence of attempt to theft. Question number 826. Which one of the following is an illustration of criminal attempt? Options are: A tries to kill B by witchcraft, A goes to Mumbai to buy dye to make counterfeit currency notes, A intending to kill B fires at B's coat hanging in his room treating it B, A takes away his own umbrella thinking it to be of someone else. Here the correct answer is option C, that is A intending to kill B fires at B's coat hanging in his room treating it B. Question number 827. A picked up a revolver and believing it to be a loaded pulled the trigger with the criminal intention of shooting B dead. Fortunately, the revolver was not loaded and B escaped unhurt. A has committed the offence of murder, attempt to murder, culpable homicide not amounting to murder. A has committed no offence. Correct answer is option B, that is attempt to murder. Question number 828. A woman ran to a well stating that she would jump into the well but she was caught before she could reach. She is guilty of attempt of murder, attempt of culpable homicide, attempt to commit suicide, no offense. Here the correct answer is option D, that is no offense. Question number 829. A, intending to murder B by poison, purchases a poison and mixes the same with a glass of water. He gives the glass to bearer to serve B. The bearer, while approaching B, loses balance and the glass drops out of his plate. What offense A has committed? A has committed the offense of attempt to murder. Question number 830. X, a married woman, being annoyed from family quarrels, threatens her husband that she would commit suicide by falling into a nearby well. She runs towards the well, but at distance she is stopped from committing suicide by some stranger from behind. Decide liability. X is liable for an attempt to commit suicide. X is not liable for attempt to suicide. X is liable for threatening of suicide. None of the above is correct. Here the correct answer is option B, that is X is not liable for attempt to suicide. Question number 831. Which one of the following is not an essential of an offense? Motive, punishment, intention, prohibited act. Correct answer is motive. Motive is not an essential for an offense. Question number 832. X, a boy of 22 years, sits on a cot of a sleeping girl of 19 years old and pulls down her lower clothes. Point out the correct answer. X is liable for punishment under section 378 of IPC. X is liable and punishment under section 354 of IPC. X is liable for punishment under section 509 of IPC. X is liable for punishment under all sections of enumerated above. Here the correct answer is option B, that is X is liable for punishment under section 354 of IPC. Question number 833. X abets Y to beat Z. While Y was beating Z at the residence of Z, X reaches there with 3 of his friends. Y still continues to beat him. Point the correct answer. X is liable under section 109 of IPC. X is liable under section 323/34 of IPC. X is liable under section 120B of IPC. X is liable under section 114 of the IPC. Here the correct answer is option D, that is X is liable under section 114 of the IPC. Question number 834. In which of the following circumstances X cannot cause death of Y while exercising his right of private defense of property under section 103 of IPC? If Y is committing dacoity, Y is likely to cause death of X, Y is committing housebreaking by night with the dangerous weapon, Y is committing robbery. Here the correct answer is option B, that is Y is likely to cause death of X. Question number 835. A shoots at a bird in B's house in order to steal it but accidentally kills B. Point out the correct answer. A is liable for the murder of B. A is not liable for the murder of B. A is liable for the culpable homicide of B. A is not liable because it was an accident under section 80 of IPC. Here the correct answer is option C, that is A is liable for the culpable homicide of B. Question number 836. Which one of the following jurists opined that crime is an act or omission in violation of public rights? Options are Pollock, Austin, Blackstone, William Glanville. Here the correct answer is option C, that is Blackstone. Question number 837. X abets Y to commit murder of Z. Y commits murder of Z. X is liable under section 109, section 120B, section 302, section 115. Here the correct answer is option A, section 109 of IPC. Question number 838. Under which one of the following circumstances X cannot cause death of Y in exercise of his right of private defense of body under section 100 of the IPC, even if Y has created an apprehension of imminent danger to his life, of causing death, of causing robbery, of causing rape or unnatural lust, of causing grievous hurt? Here the correct answer is option B, of causing robbery. Question number 839. A entered a house to commit theft. Old lady living in the house saw the thief and shouted for help. Neighbors collected near the house and caught hold of the thief who was trying to escape. The neighbors gave the thief beatings with fists and lathis. The neighbors are liable to similar intention, common intention, unlawful assembly, conspiracy. Here the correct answer is option B, that is common intention. Question number 840. During the murder trial, it was proved that the murder was committed by 6 persons. Out of the 6 accused, identity of 2 accused persons could not be verified. Hence, the 2 accused persons were acquitted. Rest of the 4 accused persons claimed acquittal. Point out the correct answer determining liability of the 4 accused persons. Options are: shall be liable under section 302/149 of the IPC, shall be liable under section 302 or 34 of IPC, liable for negligence, shall not be liable for murder. Here the correct answer is option B, that is shall be liable under section 302 and section 334 of the IPC. Question number 841. Defense of insanity under section 84 of the IPC requires unsoundness of mind of any kind, legal insanity, medical insanity, moral insanity. Correct answer is option B, that is legal insanity. Question number 842. Point out the correct answer. A instigates B to instigate C to kill D. In pursuance of that instigation, B writes a letter to C to kill D. C does not read the letter. Therefore, A and B are liable for the abetment of murder. A is liable for abetment of murder, but B is liable for the abetment of murder. But B is not liable for abetment of murder. Option C. A is liable for abetment of murder, but B is liable for attempt to abetment of murder. Option D. None of the above is correct. Option A is correct. That is, A and B are liable for the abetment of murder. Question number 843. Point out the correct statement. A and B went to cause murder of C. A was with a spear and B was with a stick. B caught C and beat C with a stick. A did nothing while B was beating. When C fell down and became unconscious, A took him to nearby hospital for care where he died. A and B both are liable under section 302 and 34 of IPC. A is liable under section 302 of IPC, but B is liable for nothing. Option C. B is liable for murder. A is liable for abetment of murder. None of the above. Here the correct answer is option A. That is, A and B both are liable for section 302 and 34 of IPC. Question number 844. X gives poisonous apple to Y with intention to cause his death. Y comes to know the fact that the apple is poisonous. Y gives that apple to a minor child for eating. Child eats that and dies. In this case, X is accused of murder and Y is accused of abetment of murder. X and Y both are accused of murder. Option C. Y has committed the offense of murder and X has not committed any offense. Option D. X is accused of attempt to murder and Y is accused of murder. Correct answer is option D. That is, X is accused of attempt to murder and Y is accused of murder. Question number 845. A with the intention to commit theft instigates B to take possession of that property belongs to him. B with that impression that the property belongs to A takes possession of property bona fidely. In relation to the above statements, statement A is accused of abetment to commit theft and B has not committed any offense. Reason: abettor's liability is not dependent on the liability of the principal offender. Here both the statements and reasons are correct and explains A properly. Option A will be the right answer. Question number 846. Carefully read the following statements. Statement first. According to section 34 of IPC, requirement is 2 persons, whereas under section 149 IPC, requirement is of 5 persons. According to section 34 of IPC, common intention is required, whereas under section 149 IPC, common object is required. Option 3. Previous consent is required under section 34 and 49 of IPC. Option 4. Section 34 of IPC and section 149 of IPC constitutes a specific offence. Which of the above statement is true? Statements 1 and 2 are correct. Section 34 of IPC requires 2 persons, whereas section 149 requirement of 5 persons. And the second statement, according to section 34 of IPC, common intention is required, whereas section 149 IPC, common object is required. Question number 847. A police constable tortured a person under the order of his senior police officer. The person lost one eye because of the torture. Which of the following will be the basis of defense which can be invoked by the accused police constable? Torture was under the order of senior police officer. Torture was given because he was under the threat of losing service. Torture was given because he was under the threat of suspension from service. Torture was given because there was imminent threat to death. Here the correct answer is option A, that is, torture was under the order of senior police officer. Question number 848. A child is in a house with Z which has caught fire. Neighboring people spreads a blanket to save the child. Z, in the interest of child, throws him on the blanket, but the child dies. Z has committed the offense of. Here Z has committed no offense. Question number 849. Which of the following statement is true in relation to abetment of an offense? It is not necessary that the offense abetted has been committed. This statement is the correct answer. It is not necessary that the offense abetted has been committed. Question number 850. Because of grave and sudden provocation of Z, A fires at Z, but Z does not die. A has committed the offense of option C, attempt to commit culpable homicide. Question number 851. X dishonestly takes possession from Y a box containing jewelry. While going home, X saw Y is chasing him. X left the box and started pelting stones on Y to stop him from chasing. X has committed option A, no offense at all, option B, offense of theft, option C, offense of robbery, option D, offense of extortion. Here the correct answer is option B, that is offense of theft. Question number 852. Right of private defense extends to causing death if property sought to be protected is public property. Public property must be protected even at any cost. Here the correct answer is A is false but R is true. Question number 854. Necessity knows no law. Reason: necessity does not justify indiscriminate throwing of passengers overboard to save sinking boat. Options are both A and R are true and R is the correct explanation of A. Option B, both A and R are true but R is not the correct explanation of A. A is true but R is false. A is false but R is true. In question number 854, the correct answer is option B, that is both A and R are true but R is not the correct explanation of A. Question number 855. Nothing is an offense which causes slight harm. Law does not take care of trivial things. Yes. Here the correct answer is option A, that is both A and R are true and R is the correct explanation of A. Question number 856. A, an insane person, kills B by firing from a loaded gun. A has committed an offense of culpable homicide not amounting to murder, an offense of murder, an offense of grievous hurt, no offense at all. Here the correct answer is option D, that is no offense at all. Question number 857. Under which sections of the IPC a person can be convicted for the offense of bigamy? Section 494 is the correct answer. Question number 858. For the application of section 149, active participation of each person is necessary. A person should be a member of unlawful assembly. Both A and B are correct, none of these. Correct answer is option B, that is a person should be a member of unlawful assembly. Question number 859. If a person who is a citizen of India commits offence out of India, cannot be prosecuted in India as the act was not committed in India, can be prosecuted in the country where the offence was committed, can be prosecuted in India at any place in which he may be found. Option D, cannot be prosecuted either in India nor in the country where the crime was committed. Option C is the correct answer, can be prosecuted in India in any place in which he may be found. Question number 860. A is the paramour of Z's wife. She gives a ring of gold which A knows belong to her husband Z. Here the correct answer is A commits theft of ring. Question number 861. Match the following offences. Grave and sudden provocation, exception 1st of section 300. Death caused in slight fight, exception 4 to section 300. Death caused by consent, exception 5 to section 300. And exceeding right of private defense, this is exception 2nd of section 300. Therefore, the correct answer for this will be option C. Now question number 862. Which of the following is the offence which is punishable in 4 stages? Options are robbery, dacoity, murder, rape. Dacoity is an offence which is punishable in 4 stages. Assertion: X and Y had independently entertained the idea to kill Z. Accordingly, separately inflicts wounds on Z. Z dies, X and Y can be tried jointly. Reason: 2 or more persons can be tried jointly if the act resulting in an offence is done in furtherance of a common intention. Here, A is false but R is true. Question number 864. The right of private defense is available to the aggressor, person who was attacked, the aggressor and the victim, the act done in defense of a person who was attacked. Correct answer is option D, that is the act done in defense of a person who was attacked. Question number 865. A police officer arrested and detained a girl in the lockup despite bail order. The police officer shall be guilty of kidnapping, abduction, intimidation, wrongful confinement. Correct answer is option D, that is wrongful confinement. Question number 866. Sex with a girl with fraudulent consent amounts to simple physical assault, molestation, outrage of modesty, rape. Correct answer is option D, that is rape. Question number 867. Wantonly means things done recklessly, things done malignantly, acts done through mischief, all of the above. Correct answer is option 8, that is things done recklessly. Question number 868. Losing wrongfully means when the property is put to auction, when such person is wrongfully deprived of property, when such person is wrongfully kept out of the property. Both B and C. Correct answer is option D, that is both B and C. When such person is wrongfully deprived of property, when such person is wrongfully kept out of the property. Question number 869. Denomination of mens rea is inferred through reason to believe, voluntarily, dishonestly, all of the above. Correct answer is option D, that is all of the above. Question number 870. Right to private defense is not available on all acts of self-defense, all acts of aggression, all acts where danger is sensed, all of the above. Correct answer is option B, that is all acts of aggression. Question number 871. In which of the acts of a prostitution it becomes a public nuisance? The act is carried on in a hidden manner. The act has resulted with an injury to an individual. It must be a case of bare solicitation of customers in a public place. None of the above. Correct answer is option C, that is it must be a case of bare solicitation of customers in a public place. Question number 872. A quack, an uneducated in matters of surgery, had performed an operation of a man for an internal piles with the help of ordinary knife. Unlike previous occasion for which the man died due to hemorrhage, decide on M's liability. M is recognized as a quack and hence not liable. M's profession is not legally acceptable, hence liable. M is not liable because the man consented for such operation. M is not liable because it was a post of operational syndrome. In question 872, option B is correct. Statement B is correct. That is, M's profession is not legally acceptable, hence liable. Question number 873. One of the essentials of holding a person responsible for dowry death is subject to harassment by peer group, subject of harassment for dowry, subjected harassment under suspicious circumstances. Correct answer is option B, that is subjected to harassment of dowry. Question number 874. A person who causes bodily injury to another who is laboring under a disorder, disease or bodily infirmity and thereby the death of the person under which it shall be deemed to have caused his death. Options are explanation first to section 299, explanation first to section 300, explanation second to section 299, explanation second to section 300. Correct answer is option A, that is explanation first to section 299. Question number 875. Principle: theft plus violence or threat to violence is equal to robbery. Fact: M meets B and her child on a river bridge. M takes the child and threatens to fling it down to the river unless B delivers her purse. B in consequences delivers her purse. What offence M has committed? Here M has committed the offence of robbery. Therefore the option C is right answer. M is liable for robbery. Question number 876. Fill in the gap. A disability for dash days constitutes a grievous hurt. Correct answer is a minimum of 20 days. Question number 877. Which of the meaning given for the maxim actus me invito non est mens actus is correct? Option A. Merely a voluntary act by me will not be a crime with criminal intention. An act done by me against my will is not my act. Neither I nor my person can be held liable for an act done under compulsion. And option D, all of them. Correct answer is option B, that is an act done by me against my will is not my act. Question number 878. The expression seduced used in section 366A of IPC means to dash a woman to submit to illicit intercourse at any time. Correct answer is option B, deceitfully induced. Question number 879. Criminal breach of trust is an offence which signifies entrustment, demand, refusal, wrongful intention. Correct answer is option A, that is entrustment. Question number 880. Fill in the blank using appropriate statement. Non compos mentis means. Correct answer is option A, that is not of sound mind. Question number 881. Fill in the blank. Deceiving dishonestly by inducing a person to retain the property is known as dash offence. Correct answer is cheating. Question number 882. Fill in the gap that is most appropriate. Whoever entices a girl child of less than 16 years has said to have caused kidnapping out of the keeping of the lawful guardians. Option D is correct. Question number 883. Fill in the gap with the offence that the accused has committed. Whoever dishonestly uses any movable property to his own advantage has committed the offence of dash. Options are breach of trust, wrongful gain, misappropriation, none of the above. Correct answer is option C, that is misappropriation. Question number 884. Malignantly and maliciously are synonyms. There is only one provision of IPC which covers both the aspects. Provide the correct answer. Options are section 153, section 270, section 219, section 220. Correct answer is option B, that is section 270. Question number 885. The IPC no more denote a positive evil intent for fixing liability. However, there are certain type of act which signifies want of care as culpable resulting out of breach of duty. What it is known as? A, rashly, B, negligently, C, both A and B, D, none of the above. Correct answer is option C, that is both and above, rashly and as well as negligently. Question number 886. Culpable homicide becomes murder when the act caused causes death and is done with the intention of causing death. Reason: one of the conditions to be satisfied for treating it murder provided the injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Here in 86, option D is correct, that is both A and R are true and R is the reasonable explanation of A. Question number 887. The application of doctrine of vicarious liability in crime seems to have been actuated by a necessity rather than desirability. The justification is based on public policy, failure to supervise, treated as unauthorized strict liability. Correct answer is option A, that is public policy. Question number 888. In which of the offence actual commission of the offence is not punished but its attempt is punished? Options are: when the execution of murder falls short, causing miscarriage, suicide, exposure with intention to abandon the child. Here the correct answer is option C, that is suicide. Question number 889. An offender claiming exemption of criminal liability under section 84 of IPC must be incapable of knowing the nature of act, the act was contrary to law, the act was wrong. Option D, all of the above. Correct answer is option D, that is all of the above. Question number 890. In order to attract the application of section 304B of IPC, it is essential that the death has occurred within, correct answer is option B, that is actual death should have occurred within 7 years of her marriage. Question number 891. Administration of an unwholesome drug is strictly punishable under law even though it may not cause hurt. Under what provisions of law punishment can be inflicted? Punishment can be inflicted under section 328 of IPC. Question number 892. Fill in the blanks. Extortion is dash when it is committed under the fear of instant hurt. Correct answer is robbery. Extortion is robbery when it is committed under fear of instant hurt. Question number 893. Fill in the blank with suitable statements. Z dies in possession of a gold ring, gold chain and gold wristwatch during the course of an accident. Dishonestly misappropriates the same, causing. Option A, an aggravated form of misappropriation as per section 404 of IPC. A type of possession by some process as per section 405 of IPC. No offence because the property in question was entrusted to before death of a Z. Option D, no offence because the property in question was possessed by some casualty. In 893, correct answer is option A, that is an aggravated form of misappropriation as per section 404 of IPC. Question number 894. Causing one thing to resemble another thing is known as counterfeiting, deception, cheating, all of the above. Correct answer is option A, that is counterfeiting. Question number 895. A private libel is not considered as strict liability because there is no common injury or danger inferred from the facts. It was the result of bona fide belief. It is not mandatory offence. The principles of Reliant versus Fletcher is not applicable. Here the correct answer is option A, that is there is no common injury or danger inferred from the facts. Question number 896. The maxim de minimis non curret lex relates to option A, slight harm, option B, disobedience, option C, exhibition of disrespect, option D, annoyance. Correct answer is option A, that is slight harm. Question number 897. Instigating or engaging in a conspiracy or intentionally aiding a person to commit an offence is better known as principal crime, second degree crime, willful misrepresentation, abetment. Correct answer is option D, that is abetment. Question number 898. Malum prohibitum means intrinsically wrong, course of law has made it otherwise, innocent but made punishable by statute, and option D, all of the above. Correct answer is option D, that is all of them. Question number 899. Demolishing a private structure standing encroached on public street amounts to gain by unlawful means, wrongful gain for public purpose, wrongful loss by mischief, none of the above. Correct answer is option C, that is wrongful loss by mischief. Question number 900. The real and abiding concern for the dignity of human life was decided in the case of Rajendra Prasad versus State of UP, Mahendra Singh versus Delhi Administration, Javed Ahmed versus State of Maharashtra, Bachchan Singh versus State of Punjab. Correct answer is option D, that is Bachchan Singh versus State of Punjab. Question number 901. Which of the following statements are not false evidence in discharge of public justice? Option A, a false statement given under instigation. Option B, a statement known to be false. Option C, statement not believed to be true. None of the above. Correct answer is option A, that is a false statement given under instigation. Question number 902. The revenue inspector knowingly disobeys the direction to conduct inquiry at a place for the demarcation. What offence, if any, has been caused by him under IPC? Option A, an offence as per section 166A. This is the correct answer. Question number 903. The maxim reum lingium non facet nisi incitria is propounded by St. Augustine. Option C is the correct answer. Question number 904. Fill in the gap. Disobedience of law is not ordinarily a crime unless the act is declared as crime by some law, society, method, all of the above. Correct answer is option A, that is law. Question number 905. Which of the mitigating factors do not justify the award of death penalty? Where the murder has been previously planned, such murder involves exceptional duplicity, when such murder was against a public servant while on duty, when the offence was committed by the accused under the influence of extreme mental disturbance. Correct answer is option D, that is when the offence was committed by the accused under the influence of extreme mental disturbance. Question number 906. What offence, if any, has been caused by the accused X in the following facts? X had some verbal wrangle with his wife Y, and in course of that he gave her a blow with a great force, and after an interval of 2 hours Y died. Medical evidence provided the causative factor as rupture in the spleen. Options are culpable homicide not amounting to murder, grievous hurt, homicide, simple hurt. Here the correct answer is option B, that is grievous hurt. Question number 907. Assertion. In criminal breach of trust, there is conversion of property held by a person in a fiduciary capacity. Option reason. A person has a right to convert property held by him in a fiduciary capacity. Here the correct answer will be A is right but R is wrong. Option B is the right answer. Question number 908. The actus reus of omission commands. There must be moral duty, there should be legal duty to act. The state has option to fix criminal liability. The act performed is due to unavoidable accident. Here the correct answer is option B, that is there should be legal duty to act. Question number 909. Read the following situations and choose the correct one. Where right of private defense is available, against an act done or attempted to be done by a public servant, where there is a time available to have recourse to state authorities, where there is a reasonable apprehension of causing injury to third person, none of the above. Correct answer is option C, that is where there is a reasonable apprehension of causing injury to third person. Question number 910. X. A servant committed theft of mobile phone of his master M and ran away from home. While travelling, the said mobile phone was taken away by a co-traveller without the knowledge of X. Decide the liability of Y. Choose the correct one among the following. Option A. Criminal misappropriation as the phone was lying on a seat of X. Criminal breach of trust as they were co-travellers. Theft as property in possession of X was taken without his consent. Cheating as the method adopted was dubious. Here in question number 910, the correct answer is option C, that is theft as property in possession of X was taken without his consent. 911. Which of the following offences fall into the causing of hurt as well as assault? Digging a pit in the public path, flinging boiling water over a person, mixing deleterious poison in a liquid and placing the same on another table, pulling hair of a woman. Correct answer is option B, that is flinging boiling water over a person. It will come under the hurt as well as assault. Question number 912. An idea of inducement by exciting hope or desire on another is known as seduction, enticing, inciting, abduction. Correct answer is option B, that is enticing. Question number 913. A takes his own suit from the tailor without his knowledge but had the intention of returning it to the tailor later. What offence, if any, has been committed by A? Stealing, dishonest taking, theft, unlawful retention. Correct answer is option C, that is theft. Question number 914. The aggravated form of perjury is known from false statement on oath, false evidence in a judicial proceeding, false affidavit before honorary magistrate, false affidavit before honorary magistrate. Correct answer is option B, that is false evidence in a judicial proceeding. Question number 915. Which of the following case does not amount to robbery? Options are taking away ornaments from the body of a lady while she was in coma, removal of ornaments after the death of a lady, voluntary disposition of valuables while theft is committed along with assault. Here correct answer is option B, that is removal of ornaments after the death of a lady. Question number 916. In the absence of any cogent definition of unsoundness of mind, the worldwide acceptance of its equivalent to insanity was propounded by Stephen Harris Kenny Davis. Correct answer is option A, that is Stephen. Question number 917. The underlying principle covering the law on consent is based on the absolute and unconditional prohibition on the gravity of the offence relating to simple hurt, death, theft from an unlocked house, submission for detaining indecent liberties. Correct answer is option B, that is death. Question number 918. When a person tries to escape from lawful custody while being taken to a magistrate to furnish security for good behavior could be punished under the provision of Section 224 of IPC, Section 225 of IPC, Section 225A of IPC, Section 225B of IPC. Correct answer is option D, that is Section 225B of IPC. Question number 919. The law is clear that consent of the party becomes immaterial when the very act itself is unlawful. In which of the cases it would be an exception? Prize fight, advantage taken in a game of fencing, aiding and abetting in a game of boxing, negligent while skydiving. Correct answer is option B, that is advantage taken in the game of fencing. Question number 920. In the eventuality of grievous hurt becomes culpable homicide not amounting to murder, the injury which is actually found should itself be such that it may put the life of the injured in danger. Was decided in the case of 𝐚𝐭𝐜𝐡 versus 𝐚𝐼, Government of Bombay versus Abdul Wahab, Mohammad Rafi versus King, Vishnovam Surma versus King. Correct answer is option B, that is Government of Bombay versus Abdul Wahab. Question number 921. Which offence is outside the range of culpable homicide in view of the fact that the accused had neither intention nor knowledge about the consequence, yet it is punishable? Options are when the injury results due to carelessness, when the mishap happens due to rash and negligent act, when the contributory act was voluntarily done, when the act resulted in the course of exasperation. Here the correct answer is option B, when the mishap happens due to rash and negligent act. Question number 922. Refusal to answer to an authorized investigation officer could be punished under Section 179 of IPC, while giving false answer statement in the process could be punishable as Section 180, Section 193, Section 181, Section 183. Correct answer is Section 193. Question number 923. Under what circumstances gross negligence could amount to knowledge, as may be required under Section 299 of IPC, impose punishment? Option A, bona fide about the supernatural thing resulting in the direct consequence of death. There was a presupposition that death will result. Presumption is that the accused had knowledge about the consequences of his act that resulted death. Option D, where there is a clear difference between lower or higher degree of criminality. Correct answer is option C, that is presumption is that the accused had knowledge about the consequence of his act resulted death. Question number 924. When a minor leaves her parental house completely without any inducement from the accused, what offence it amounts to? Abduction, kidnapping, enticing? No offence. Correct answer is option D, that is no offence. Question number 925. In which of the following judicial commutation becomes an impossibility? Double murder, sedition, gang rape followed by homicide, refugees committing a crimes in India. Correct answer is option C, that is gang rape followed by homicide. Question number 926. Law is a social engineering to remove the existing imbalance and to further the progress, serving needs of socialist democratic Bharat under the rule of law. This was the observation of Justice K. Ramaswamy in option A, Delhi Transport Corporation versus DTC Mazdoor Congress, Indira Sahane versus Union of India, State of Karnataka versus Appa Babulu Ingale, Pramanand Kataria versus Union of India. Here the correct answer is option A, that is Delhi Transport Corporation versus DTC Mazdoor Congress. Question number 927. A young man waves a currency note of ₹1000 in front of a woman, as if he offers the money for an indecent favor from the woman. He may be criminally booked under Section 509 of IPC. Question number 928. Acts done in moments of delusions are protected because, by virtue of the absence of free will, lack of intelligence to distinguish between good and evil, expediency grounds say so, circumstances are such that they are incompatible to the existence of mens rea. Here the correct answer is option D, that is circumstances are such that they are incompatible to the existence of mens rea. Question number 929. The self-evident principle of criminal justice is based on nullum crimen sine lega, nulla poena sine lege. This is the correct answer. Question number 930. Which one of the expressive factors does not constitute sedition? Disapprobation of the government, excite disrespect against government, commenting on administrative actions of the government, attempting to excite disaffection against the government. Here the correct answer is option B, that is excite disrespect against the government. Question number 931. Non-compos mentis denotes every person is considered to be sane unless contrary is proved. When a criminal act is performed during derangement, when the cognitive faculties are such that he does not know what he has done. Non-serene memory, not from birth. Here the correct answer is option C, when the cognitive faculties are such that he does not know what he has done. Question number 932. Under section 65 of IPC, sentence of imprisonment for non-payment of fines shall be limited to option A, 1/2 of the maximum term of imprisonment fixed for the offence, 1/3 of the maximum term of imprisonment fixed for the offence, 1/4 of the maximum term of the imprisonment fixed for the offence, 1/5 of the maximum term of imprisonment fixed for the offence. Here the correct answer is option C, that is 1/4 of the maximum term of imprisonment fixed for the offence. Question number 933. A instigates B to murder D. B in pursuance of instigation stabs D. B recovers from the wound. Here A is guilty of instigate B to commit murder, instigate B to commit attempt to murder, instigate B to commit grievous hurt, no offense. Correct answer is option A, that is instigate B to commit murder. Question number 934. Match the items of list 1, name of the case, and the items of list 2, offense. List 1 and list 2. Vishwanath versus State of UP. Correct match is private defense. State of Punjab versus Major Singh. Correct answer is modesty of women. S. Vardarajan versus State of Madras. Correct answer is kidnapping. And Amar Singh versus State of Rajasthan. Here the correct match is dowry death. Therefore, by giving the following answers, the correct code will be here is A. Question number 935. X, a doctor, informs his patient Y that Y was suffering from cancer. Hearing this, Y dies of heart failure. X is committed culpable homicide not amounting to murder. No crime because he X communicated in good faith. This is the correct answer. No crime because X has communicated in good faith. Question number 936. Mere presence at the scene of offence does not make one a member of unlawful assembly. Does make one the member of unlawful assembly. Does make one the member of unlawful assembly if he shared the common object of the unlawful assembly. Does make one the member of unlawful assembly unless he shared the common object of the unlawful assembly. Correct answer is option C. Does make one the member of unlawful assembly if he shared the common object of the unlawful assembly. Question number 937. In which of the following case a mere presence of mens rea is sufficient to charge a person an offence and no actus reus is required? Instigation offence, sedition, criminal conspiracy, none of the above. Correct answer is option C, that is criminal conspiracy. Question number 938. An act is said to be done in good faith when it is done or believed to be done in accordance with the law. It is done honestly, whether it be done carelessly or not. It is done or believed to be done with due care and attention. It is done property and not against the law. Correct answer is option C. It is done or believed to be done with due care and attention. Question number 939. A chased B when he saw B lifting away A's luggage on a railway platform. Seeing A chasing him, B left the luggage and tried to run away. A caught hold of B and thrashed him and thereby injured him. In this case, A is guilty of causing a hurt to B as he transgressed the right of private defense of property. A is not guilty of any offence and he can avail of right to private defense of property. A is not guilty of any offence as it was necessary to teach a lesson to B for committing theft. Correct answer here is A. A is guilty of causing hurt to B as he transgressed the right of private defense of property. Question number 940. A is attacked by a mob who attempts to murder him. In order to save his life, A fired back at the mob. As a consequence, one innocent child was killed who happened to mingle with the mob at the moment. In this case, A is guilty of murder as his right of private defense of body extend only against the mob and not against the innocent child. Option B. A is not guilty of any offence as he acted only in legitimate exercise of his right of private defense of body. This is the correct answer. A is not guilty of any offence as he acted only in legitimate exercise of his right to private defense of body. Question number 941. A told his friend C that he was going to shoot down B in the evening. In the evening, A with a loaded gun entered the street in which B was living, shouting, "B, come out and be killed." B did not come out and A went away. Mark the correct statement. A is liable for an attempt to murder because he carried loaded gun. A is liable for attempt to murder. His intention was to kill was clear from his shouting. A is not liable for an attempt to murder because he had not committed to penultimate act. A is liable for attempt to murder because he had already told C that he was going to shoot down B. Correct answer is option C. A is not liable for an attempt to murder because he had not committed the penultimate act. Question number 942. Volunteer non-fit injuria. Correct match is section 87. Dolly incapax. Correct match is section 83. Ignorantia facti doth excuse. Correct answer is correct match is section 79. Non compos mentis. Correct answer is section 84. And de minimis non curate lex. Correct answer is section 95. By going the given options, the correct match will be A. Question number 943. A allows an illegal marriage to be solemnized by B, a priest in his house. Here, B is liable for abetting the offence. A is liable for abetment. Both A and B are liable for abetment. Neither A or B is liable for abetment. Correct answer is option B, that is A is liable for abetment. Question number 944. Which of the following cases do not pertain to the defense of unsoundness of mind? Options are Emperor versus 𝐮𝐷𝐿, Queen versus Lakshman Dhagu, McNaughton's case, State of Orissa versus Ram Bahadur Thapa. Here the correct answer is option D, that is State of Orissa versus Ram Bahadur Thapa. It does not pertain with the defense of unsoundness of mind. Other cases are related to the defense of unsoundness of mind. Question number 945. A runs away with B's purse. A chases him and while chasing gives a severe lathi blow on A's head to retrieve his purse. A dies in hospital some days later because of head injury. B has committed no offense because he was exercising his right to private defense of property, murder, culpable homicide, grievous hurt. Correct answer is option C, that is culpable homicide. Question number 946. Which of the following sections do not pertain the offence committed against women? Options are section 509, section 354, section 376, section 377 IPC. Correct answer is option D, that is section 377 IPC. Question number 947. Which of the following statement is not defamatory? A says about a woman, B that she has a paramour wherever she goes. A publishes a photograph with a false caption Gunda. A says, I am not surprised that B's book is foolish for he is libertine. Option D. A in the course of public police investigation says B may be involved in the murder of D because both of them were bitter enemies. Correct answer is D. This is not defamation. Question number 948. In which section of IPC forgery has been defined? Correct answer is section 463. Criminal trespass has been defined in which of the following section of IPC? Correct answer is section 441. Attempt to commit robbery is punishable under section 393 IPC. Attempt to commit robbery is punishable. Match list 1 and list 2 and select the correct answer using the code given below. List 1 section, list 2 offense. Section 463, correct answer is forgery. Section 445, correct answer is housebreaking. Section 441, correct answer is criminal trespass. Section 503, criminal intimidation. By going this, correct code will be A. Question number 952. A finds a purse with money. Not knowing to whom it belongs, he afterward discovers that it belongs to B and appropriates to his own use. A is guilty of criminal misappropriation. Question number 953. If the offence is punishable with fine only, the imprisonment which the court imposes in default of payment of the fine shall be simple one, only rigorous, either simple or rigorous, none of the above. Correct answer is option A, that is simple one. Question number 954. Which of the following combinations are not correctly matched? Shiraz versus D. Redzan, mens rea. Barendra Kumar, intoxication. Abhidyanand Mishra versus State of Bihar, right to die. Gyan Kaur versus State of Punjab, criminal attempt. Select the correct answer using the code given below. Codes are option A, 2, 3, 4 is the right answer. These are not the correctly matched. Other Shiraz versus D. Redzan is the case combination related to mens rea. Other Birendra Kumar Ghosh and Abhinand Mishra versus State of Bihar, Gyan Kaur versus State are not correctly matched. Question number 955. A intending to commit theft enters the house of B at night and removes from one of the rooms a box to the country yard where he opens it. He does not find the box anything worth taking and leave the box. There goes away. In this case, A is liable for only for house trespass. A is liable for theft. A has committed no offence. And option D, A is liable for house trespass and attempt to commit theft. Option D is the right answer. A is liable for house trespass as well as attempt to commit theft. Question number 956. A finds the key to Y's house door, which Y had lost, and commits home trespass by entering Y's house, have opened the door with the key. What offence A has committed? Lurking, house trespass, criminal misappropriation, attempt to commit theft, housebreaking. Here the correct answer is option D, that is housebreaking. Question number 957. If death of a major person is caused with his consent, suffers death or takes the risk of death with his known consent, it is a murder, it is not a murder but culpable homicide, it is abetment of murder, none of these. Correct answer is option B, that is it is not a murder but culpable homicide. Question number 958. Extortion is described in section 383 of IPC. Question number 959. Culpable homicide is causing death with the intention of causing death, with the intention of causing such bodily injury as is likely to cause death, with the knowledge that it is likely by such act to cause death. Option D, all are correct. Here correct answer is option B, all are correct. Question number 960. If the property is removed by under mistake of fact, it is robbery, dacoity, theft, none of these. Correct answer is option D, that is none of these. Question number 961. A instigates B to cause grievous hurt to X. In consequence of the instigation, B causes grievous hurt to X. X dies in consequence. A is guilty of abetment of murder if A knew that grievous hurt abetted was likely to cause death. Grievous hurt as A had instigated to commit grievous hurt and not murder. Murder even if he did not know that the grievous hurt would result in murder. And option D, culpable homicide not amounting to murder as death had resulted as a consequence of the grievous hurt. By going through all the options, correct option is option A, murder, if A knew that grievous hurt abetted was likely to cause death. Which one of the following cases is a case relating to section 34 of IPC? Correct answer is 𝐪𝐴𝐴 Ghosh versus King Emperor. In which of the following cases the Privy Council made a distinction between common intention and similar intention? Correct answer is B, Mehboob Shah versus King Emperor. In which of the following cases Lord Somers said, "They also serve who stand and wait"? Correct answer is 𝐪𝐴𝐴 Ghosh versus Emperor. Distinction between section 34 and section 149 of IPC has been authoritatively expounded by the Supreme Court in Nanak Chand versus State of Punjab. Which one of the following case is not related to the principle of joint liability based on common intention? Correct answer is Reg versus Govinda. Cases which are related to principle of joint liability based on common intention are 𝐪𝐴𝐴 Ghosh versus Emperor, Mehboob Shah versus King Emperor, I.M. Desai versus State of Bombay. In which of the following cases a clear difference between common intention and similar intention was well discussed? Correct answer is Mehboob Shah versus King Emperor. The principle of distinction between a similar intention and same intention was laid down in 𝐪𝐴𝐴 Ghosh versus King Emperor. 𝐪𝐴𝐴 Ghosh versus Emperor is a leading case in which of the following subjects? Common intention. The case of Mehboob Shah versus Emperor was decided by one of the following courts? Privy Council. The judgment in a case of Mehboob Shah versus Emperor was given by which one of the following judges? Justice Sir Madhavan Nair. The difference between section 34 and 149 IPC has been brought out in which one of the following important cases by Supreme Court? Correct answer is Nanak Chand versus State of Punjab. Which one of the following related to joint liability under IPC? Here the correct answer is Mehboob Shah versus Emperor. The doctrine of joint liability is envisaged by section 34 of the IPC based on the decision of which one of the following? Correct answer is Reg versus Cruz. The distinction has been well explained by the Supreme Court in Nanak Chand versus State of Punjab AIR 1955 relating to which one of the following sections of IPC? Correct answer is between section 34 and section 149, common intention, common object. Death sentence should be awarded in rarest of the rarest cases was held in Bachchan Singh versus State of Punjab. The real and abiding concern for the dignity of human life was decided in the case of Bachchan Singh versus State of Punjab. The case of Bachchan Singh versus State of Punjab is considered to be an important decision of the Supreme Court of India in the context of death penalty. Jagmohan Singh versus State of UP AIR 1973 establishes that award of death sentence is not violative of Article 21 of the Constitution. Which among the following case was the first case before the Supreme Court of India where the constitutionality of death penalty was challenged? Here the correct answer is Jagmohan Singh versus State of UP. In which of the following cases the Supreme Court of India set out the guidelines for safeguarding the interest of death row convicts? Correct answer is Shatrughan Chauhan versus Union of India 2014. Shatrughan Chauhan versus Union of India 2014 is a case related to commutation of death sentences to life imprisonment. In which of the following cases Supreme Court has pronounced triple test formula for awarding death sentence? Correct answer is Shankar Krishna Rao Khade versus State of Maharashtra. In which of the following cases did the Supreme Court lay down the guidelines for the premature release of life convict? Correct answer is Lakshman Naskar versus Union of India. In the matter of commutation of death sentence into life imprisonment on ground of inordinate delay, a mercy petition, the Apex Court observed no fixed period of delay could be held to make the sentence of death inexecutable. It was observed in which of the following case? It was observed in Triveni Vain versus State of Gujarat. Which one of the following case does not belong to the same group? P. Ratnam versus Union of India, Bachchan Singh versus State of Punjab, Gyan Kaur versus State of Punjab, and Aruna Shanbag versus State of Punjab. Here, Bachchan Singh versus State of Punjab does not belong to the same group. Sedition and conspiracy. Which one of the following case is known as the Leamington Road shooting conspiracy case? Here the correct answer is Emperor versus Vaishampayam. Which of the following case is also known as Nasik conspiracy case? Vinayak Damodar Savarkar's case. The ambit and scope of the offence of sedition under section 124A of the IPC was considered by a 5-judge constitutional bench of the Supreme Court in the case of Kedarnath Singh versus State of Bihar. Which one of the following case decided by the Federal Court under section 124A of IPC? Niharendu Dutt versus Emperor. The definition of criminal conspiracy in section 120A IPC has been taken from that given in 𝐚𝐿𝐴 versus Queen. In which of the following cases husband and wife both were held guilty of criminal conspiracy? Here the correct answer is Tej Khan versus State of Madhya Pradesh. The ambit and scope of the offence of sedition under section 124A of IPC was considered by a five-judge constitutional bench of the Supreme Court in the case of Kedarnath Singh versus State of Bihar. The Supreme Court in which case held that words, deeds or writings constituted an offence under section 124A of IPC only when they had the intention or tendency to disturb public tranquility. Here the correct answer is Kedarnath versus State of Bihar. Which one of the following is a case decided by the Federal Court on section 124A of IPC? Correct answer is Neherendu Dutt versus Emperor. The case of KM Nanavati versus State of Maharashtra is related to grave and sudden provocation. Decision in which of the following cases has been described by the Supreme Court to have attained the status of landmark for bringing out correct test for application of section 300 clause 3 of IPC? Correct answer is Virsa Singh versus State of Punjab. In Rex versus Govinda, the points of distinction between the provisions of the following section of IPC were explained in section 299 and section 300. The distinction between section 299 and section 300 of IPC was first elaborately discussed in the following case, R versus Govinda. Which of the following case is considered as locus classicus on section 300, thirdly, of the IPC 1860? Correct answer is Virsa Singh versus State of Punjab. In which of the following leading cases Justice Vivan Bose distinguished culpable homicide and murder? Correct answer is Virsa Singh versus State of Punjab, AIR 1958. The State of Andhra Pradesh versus R. Punnaya case deals with distinction with which of the following sections of IPC? Section 299 and section 300. Under which of the following cases for the first time the Supreme Court of India has reaffirmed the distinction between culpable homicide and murder while adopting the view suggested in Govind case? Correct answer is State of Andhra Pradesh versus R. Punnaya. The case of Gyan Kaur versus State of Punjab related to attempt to commit suicide. Every doctor is not responsible under section 304A of IPC for the death of a person due to his negligent operation unless his intention is culpable. This has been laid down in Jacob Matthew versus State of Punjab 2005 Supreme Court. Right to live with human dignity does not include right to terminate natural life was held in Gyan Kaur versus State of Punjab. This is very important case. Section 303 of IPC was struck down by unconstitutional by Mittu versus State of Punjab. The case of S. Vardarajan versus State relates to section 363 of IPC. Section 377 of IPC regarding unnatural offence was partially struck down by the Supreme Court in the case of Navtej Singh Johar versus Union of India. Recently, Supreme Court has interpreted exception 2 of section 375 of IPC as sexual intercourse or sexual acts by men with his own wife. The wife not below 18 years is not rape. The case is Independent Thought versus Union of India. In which of the case the Honorable Supreme Court has directed to pay minimum compensation of rupees 3 lakh per acid attack victim? Correct answer is Lakshmi versus Union of India. Name of the victim of the sexual offence shall not be mentioned. It was held in which of the following cases? S. Ramakrishna versus State. Which one of the following case pertains to the constitutionality of section 377? Navtej Singh Johar versus Union of India. The Apex Court has observed how compromise is not free choice of the rape survivor but a hidden secret of law where justice is reduced to a bargain between victim's kin. State authorities and accused identify the case law. Correct answer is Ravindra versus State of Madhya Pradesh. In the eventuality of grievous hurt becomes culpable homicide not amounting to murder, the injury which is actually found should itself be such that it may put the life of the injured in danger was decided in the case of Government of Bombay versus Abdul Wahab. In which of the following cases did the Supreme Court of India strike down section 303 IPC as unconstitutional? Here the correct answer is D. Mittu versus State of Punjab. In which of the following cases Supreme Court held that brutality is inbuilt in every murder, but in case of every murder, death sentence is not imposed? Here the correct answer is Prem Sagar versus Dharamveer. Which case cited mediation in rape case sans legal permissibility? Correct answer is State of Madhya Pradesh versus Madan Lal. In which section 309 IPC was declared unconstitutional? Correct answer is Gyan Kaur versus State of Punjab. In Supreme Court bench, Justice Deepak Mishra and Prafulla C. Pant observed any kind of liberal approach or thought of mediation in this regard between rape victim and the accused is thoroughly and completely sans legal permissibility. Correct answer is State of Madhya Pradesh versus Madan Lal. A two-judge bench of Supreme Court in Sher Singh Tap versus State of Haryana held that prosecution can discharge the initial burden to prove the ingredients of section 304B of IPC even by preponderance of possibility. Match list 1 and list 2. K.M. Nanavati versus State of Maharashtra. Here for correct match is grave and sudden provocation. Virsa Singh versus State of Punjab. Correct answer is murder. Barendra Kumar Ghosh versus Emperor. Correct answer is common intention. Shyam Bihari versus State of UP. The correct answer is dacoity. Again the question is match the following. List 1 Kehar Singh versus Delhi administration. Correct answer is murder. Vishakha versus State of Rajasthan. Here the correct answer is sexual harassment. Rupa Deol Bajaj versus KPS Gill. Correct answer is outraging the modesty of women. Guru Dutt Mal versus State of UP. Correct answer is common object. In which of the following cases Supreme Court has pointed out the distinction between culpable homicide and murder? Correct answer is State of Andhra Pradesh versus R. Punaya, AIR 77. Decision in which of the following cases has been described by the Supreme Court to have attained the status of a landmark for bringing out correct test for application of section 300 clause 3 of IPC? Correct answer is Virsa Singh versus State of Punjab. In which of the following cases did the Supreme Court explain the concept of grave and sudden provocation as a mitigating circumstances reducing the gravity of the offence from murder to culpable homicide not amounting to murder? Correct answer is K.M. Nanavati versus State of Bombay. In which of the following cases the Supreme Court held that compulsory death sentence for murder committed by a life convict undergoing imprisonment for life, section 303, violate Article 21 of Constitution? Answer is Meetu versus State of Punjab. Shanti versus State of Haryana, AIR 1991, Supreme Court is a leading case in which of the following topics? Correct answer is dowry death. Lakshmi versus Union of India is a case in which of the following offence? Acid attack. In which of the following case Honorable Supreme Court has directed to pay minimum compensation of 3 lakh per acid attack victim? Correct answer is Lakshmi versus Union of India. Rupal Dev Bajaj versus KPS Gill is a famous case in Supreme Court decided in outraging the modesty of women. In the matter of kidnapping and rape, the evidence given by prosecution being illiterate and rustic young women, some omissions are natural as her collection, memory, observance and narration of chain of events. It was held by the Supreme Court in State of UP versus Chote Lal. The case of S. Vardarajan versus State of Madras is associated with which one of the following offence? Correct answer is kidnapping from lawful guardianship. In which of the following case the constitutional validity of section 364A IPC has been upheld by the Honorable Supreme Court? Vikram Singh alias Vicky and another versus Union of India and others, 2015 Supreme Court. Match the following. Sexual intercourse by husband with minor wife. Correct answer is Independent Thought versus Union of India. In camera trial of rape. Correct answer is State of Punjab versus Gurmeet Singh. Sexual harassment of women at workplace. Here the correct answer is Vishakha versus State of Rajasthan. And last, in camera trial of IPC cases of section 354 and section 377. Correct answer is Sakshi versus Union of India. Which one of the following interpretations of section 376B of IPC did the Supreme Court of India hold that in case of Omkar Prasad Verma versus State of Madhya Pradesh, the term custody implies guardianship and its meaning also included in care, keeping, charge, imprisonment, judicial or penal, safekeeping, etc. In dash Supreme Court bench Justice Deepak Mishra and Prafulla C.P. Pant observed any kind of liberal approach or thought of mediation in this regard between rape victim and accused is thoroughly and completely sense legal permissibility. Important question है, कई एग्जाम में पूछा जा चुका है, याद कर लीजिए. State of MP versus Madan Lal. In which of the following cases the Supreme Court of India has held that section 303 of IPC is ultra vires of Article 14 and Article 21 of the Indian Constitution, Meetu versus State of Punjab. In which of the following landmark case a 3-judges bench of Supreme Court prescribed 4-point test relating to section 300 thirdly of IPC? Correct answer is Virsa versus State of Punjab, AIR 1958. Priya Patel versus State of Maharashtra held that a woman cannot be held guilty of gang rape. Two-finger test was questioned in case and was held to be violative of right of privacy, physical and mental integrity and dignity of the prosecutrix. This case was Lilu versus State of Haryana.